GST has, the Department of Taxes has issued a show cause notice, called upon us to pay a penalty by the 29th. So the matter may be listed tomorrow, my lord.
Yes.
Right.
It's not a fresh matter, not for the interim order in this case. It was filed prior to the emission. But not got listed thereafter.
Orders listed in next week.
Next week.
Two other matters. It's fetching for tomorrow or the
Next week. Next week.
Your Lordship, in the writ petition, the subject matter of the writ petition is with respect to refund of income tax matters. My humble prayer is that
Next week.
next week I'm praying for that to be posted on 2nd of July, Tuesday. My humble prayer is that it can be disposed of for the reason that
Let us see.
refund has already been calculated. It is only the interest can be posted as a fresh matter.
What is listed? Refreshment is listed.
This is the education
matter that
matter,
is
my lord. There is some emergency. The petition unable to attend the next semester, my lord. Yes.
Tomorrow.
Yeah, tomorrow, my lord. Two petitions.
Adjournments?
For 2:30, my lord. For 2:30, my lord. There's an urgency, my lord. Schools have been ordered to be closed, my lord. Schools, my lord, have been ordered to be closed by the department. Some students have been affected, my lord.
Tomorrow.
With the lordship's
You
permission.
intimate the other side, intimate the government.
Yes.
Let them get instruction.
With the lordship's permission, item 70, my lords, it's there in the
17.
770, my lords. But I was only requesting if it can be taken up today anytime, my lords. I had mentioned the last time, your lordship, so please to,
All are waiting in the queue. Let us see. We'll see. We'll see.
in
Adjournment?
case,
Let us see.
List one, page number 1, 1 to 6, page number 2, 7 to 15, page number 3, 16 to 24, page number 4, 25 to 34, page number 5, 35 to 44, page number 6, 45 to 48, page number 7, 49 to 56, page number 8, 57 to 64, page number 9, 65 to 72, page number 10,
71, my lordship.
71,
Yes.
And for the petitioner, I kindly pray for a week time, my lordship.
List a week after next at request. Intimate the other side.
Yes, my lordship.
70,
I'll do it.
71. Page number 10, 73 to 81, page number 11, 82 to 88, page number 12, 89 to 93, page number 13, 95. Fresh matter, list 1, serial number 1, state.
Petition by challenging the order passed by the first of the authority. Madam Savai, tribunal is not constituted. But we don't have an alternative remedy but to approach this court. This may be ordered to the response.
Any interim relief you are seeking?
The relief I have sought, but the impugned order is dated September 2022. I have no instructions as of today whether.
Take out notice.
Please.
Issue notice to the respondent.
Serial number 2, Bhargav D. Bhatt.
My lords, the issue involved is rejection of refund. We had exported services. Same writ petition, my lord, similar issue for other SSCs. It's listed today at 95. The same batch, whether the SSC is an intermediary or not. Your lordship had passed an order on 12th of June, my lords. In one of those writ petitions, and
Same point.
not same party, same issue. For this party also, writ petitions have been pending, my lords. This is the 9th writ petition we are filing for this SSC and the group entity.
So we'll consider the interim prayer and let the pleadings be complete. So what is your contention?
My lords, the contention is we have exported software services and ITES services. And we have been allowed refunds for initial periods when GST came in for 17, 18 and 18, 19. But subsequently, our refunds have been disallowed, saying that we are an intermediary and hence the place of supply of our services in India, and hence no export had happened. So the refunds have been denied. We have already filed, my lords, more writ petitions. This is the 9th we are filing. In all those writ petitions, interim order has been passed, my lords.
Lord, in respect of the same petitioner, synopsis is in my lord. There are writ petitions.
Yes, my lords.
Page number 1 of the synopsis.
Well, I had given a list last time, my lords.
These are all the petitions pertaining to the same company for different periods.
Yes, ma'am.
So it can be tagged along that. I'll complete the pleadings.
Yes. The learned counsel for the petitioner submits that treating the petitioner as an intermediary is not legally tenable in light of the factual matrix. It is submitted that as regards the same SSC, restraint order has been passed in other writ petitions filed. Full stop. Including other writ petitions filed, including in WP 5347 of 2022. Accordingly, subject to further consideration, what is the interim prayer? No recovery.
Yes, my lords. No recovery pursuant to the
Respondents are restrained from taking any action for recovery pursuant to Annexure
Annexure A.
Annexure
A.
K. Now it has to be listed along with the others.
Yes,
or-
my lords.
But today there is one more batch listed.
Ah.
I will not be able to complete it. Really.
Hmm.
This batch pertaining to the same petitioner, it may be tagged along with that so that I can.
List along with WP 5347 of 2022. Statement of objections to be filed within 3 weeks. Yes,
Set
Obliged,
number
my
3. Madhusudan 3.
Criminal had taken notice in the last occasion for final disposal.
yes, Dilip, where is your friend?
Instead of Passover, you'll have to take to next Wednesday, my lord. Because it doesn't look like with all people there, Passover will reach in the morning. Afternoon, lordship will be on the same stage next week.
Relist the matter in the same stage on.
Second.
Yes,
Obliged, my lord.
4. Serial number 4. Radhika.
yes,
Lords, my
GST. Additional Commissioner of Central Tax. Yes, yes, madam.
Lords, my appeal before the first respondent has been rejected on the sole ground that I have not made the pre-deposit. And in spite of giving a reply with the documentary evidence as to why pre-deposit need not be made, he has not considered the matter, or he has rejected on me on that ground and has not considered my appeal on
Correct,
merits.
but
And my,
then can that be waived?
yes. Loss, because whatever, there was an audit objection saying that Senmat credit was irregularly availed, and immediately I have reversed it. I have shown him the proof in my GSTR 3B return saying that there is a matching.
No,
amount.
correct. So what I'm saying is in law, is there a provision to waive the deposit in the appellate stage? We'll see.
Because my humble contention is that whatever is the tax demand, the entire thing has been reversed. There is nothing that I really owe the department, so there is no question of.
They've been reversed.
It has been reversed with, and documentary evidence has been given to him, and he has not considered that, and he has just passed an order rejecting my appeal.
Just point.
It's page 73 of my bundle minutes.
Page?
73.
Yes.
That's the GSTR 3B return, my lords. Part C, my lords.
Yes.
Point number 3, audit reversal, wrong transfer of credit under transitional provision of GST under section 140, 64 lakhs 96,102. That is the exact amounts which has been demanded, and the entire thing has been reversed. my lords. And my humble prayer is that he be directed to accept my appeal, hear me on merits, and pass an order on merits. That's my prayer.
Mandatory pre-deposit is mandatory. There cannot be waiver of that on that. But if my learned friend is saying that already it has been reversed, that maybe we have to look into it. But if it has to be considered on merits, they have to deposit the mandatory deposit 7.5%.
This point, just point.
This point number 4, Radhika.
Page? 73. Yes.
Radhika.
Yes.
Notice maybe it should matter, I just take instructions. For that only.
We'll have it next week.
Week after next week, 10th.
Relist the matter.
Notice
Learned Council
copying will be.
Arvind Chavan accepts notice for the respondents. Relist the matter in the orders list on
10th.
10th.
Fine.
Yes.
Lords, in this case, again, Sendvat credit through TRAN 1 has been denied to me on the ground that documentary evidence was not provided. Again, in this case, DRC 01A was issued. In that reply, I have given all my documentary evidence. Subsequently, he has passed a show cause notice. There's an order in original right up to the stage. And finally, in the order in original, he says that at the stage of notice, I cannot accept the documentary evidence. It should have been filed along with TRAN 1, which there is no provision to file once. Even at DRC 01A stage, when I gave him the documents, he's refused to accept it, simply saying I cannot accept it at stage of notice.
This is a reference in the order.
Yes. Page 77. My bundle. 77 minutes.
Yes.
If I can read that parameters, I further find.
Yes.
I further find that no TRAN 1 has been filed for an amount of 2 crores in the state of Karnataka. The noticee have their defense stated that trans credit in their electronic ledger has been done strictly with the provisions of prevailing transition law for GST. I find that the eligibility for credit comes when it is claimed. Here in the instant case, the noticee has not claimed transitional credit, so the question of eligibility does not arise. I therefore find that the transitional credit availed by the noticee is incorrect and uphold the demand raised in the show cause notice. Also, while replying via their letter dated 11/9/23 to the DRC 01A dated 7/9/23, they have failed to submit the documentary evidences. I find that as per the transitional provision cited supra, mere filing of TRAN 1 application will not entitle them to claim the credit unless the same is duly verified based on documentary evidences. In the instant case, the noticee has not submitted any documentary evidences while filing TRAN 1. Hence, I find that the eligibility of the TRAN 1 credit do not come with merely filing of TRAN 1. I find that the noticee was also given sufficient time to produce the same. If the noticee was very much in possession of the invoices, he could have produced the same at the filing of TRAN 1 or even after giving them sufficient time to produce the same. Since the time for filing of TRAN 1 is already over, I do not agree to take on record the invoices submitted by the noticee during the personal hearing. Hence, I find that the noticee is ineligible. So, Lords, he's just refused.
Now you have the invoices.
Yes, sir.
You have.
Yes. He says I have produced it, but at the time of hearing, he says you cannot produce it. I will not accept it at the time.
Let us see. In light of the contention that the authority, the assessing officer, is it?
But
That while passing the order in original, the authority has invoices would indicate
the eligibility of credit.
eligibility of credit. That evidence cannot be taken out of twice consideration, subject to further consideration. There would be stay of
Annexure E notes.
stay of annexure E. Learned Counsel Akash Shetty accepts notice for the respondent. Respondent is at liberty to seek for modification of the interim order upon completion of instructions.
Lords,
Now
may
you
make
find
one
out
submission, Lords.
If it is so, then you can move the matter upon instructions that it can be remanded and considered. So you move the matter.
Lords, may make one submission, my Lord, seal number 5. Lords, I'm on video conference, my Lords, may
Serial number
Lords,
5.
the learned
Yes, my Lord, but he's also a counsel.
No, two counsels.
Lords, what has happened is, Lords, the learned counsel, my Lords, so the petitioner had served the union, but my Lords, in the array of parties, my Lords, the union is not arrayed, my Lords.
Union of Union of India is not necessary, is it?
It's not necessary, my lords. Some
Which-
confusion was there at the time of filing. They insisted
is-
that I.
Lords, I may be permitted to withdraw my memo of appearance, my lords. I had filed.
Lord Counsel Shri Vinay V is permitted to withdraw his memo of appearance as the Union of India is not made as a party. Yes, Nathan.
Obliged, my lords. Obliged.
6, Srihari. Raviraj.
For the petitioner, my lords.
Yes.
My lord, section 144B provides for the faceless assessment procedure. Subsection 1, Roman 12 talks about issue of show cause notice upon consideration of all the material available on record. Roman 12, my lords, clause 12. Now, in my case, my lords, upon consideration of all the material available on record, show cause notice was issued at page 135.
Yes.
Page 135, show cause notice proposes two variations. Page 137, my lords. 137, my lords.
Yes.
Show cause notice proposes two variations. And second, my lords, a variation of 13.36 crores is proposed. That 13.36 crores, my lords, represents the difference between the purchases as reflected in the trading account and the purchases as being considered by the assessing officer. That there is a difference. If I may read the last but 5 line, my lords. May I read, my lords? Wide notice under 142.1 dated 10th of July 2023, you have been asked to provide the details of creditors outstanding at the end of relevant assessment year, and along with the same, you have also been required to file the details of the quantity, unit of item, and value of item. However, the list provided by you.
First para, second paragraph.
The second variation, my lords.
Yes.
Second variation, second paragraph. May I continue, my lords? Fourth line, my lords. However, may I continue, my lords? However, the list provided by you are not reconciled with the total amount of purchases debited in the trading account. In the details of purchase register, you have furnished details of purchases at 25.07 crores, whereas the total amount of purchases debited in the trading account amounts to 38.44 crores, and thus there is a difference in the amount of purchases to the tune of 13.36 crores. Therefore, you are requested to show cause as to why the total amount may not be added under section 69C, unexplained purchase. This is the proposition. Two propositions have been made by him under Roman 12 of 144B. I reply, my lords, at page 139 within time. 139. 139.
129.
39.
Yes.
That is my reply to the show cause notice filed within time. Lordship may see serial number, attachment name at the bottom. I have filed a reply letter in writing, filed a purchase register, filed confirmation letters also in respect of purchases. My reply letter is at page 141. Page 141 is my reply letter. Lordship may take to para 2 in that. The purchase register. The purchase register provided in the response to notice dated 10th of July 2023 was only with respect to the parties having closing balance as on 31st of March 2022 and not the complete purchase register for the financial year 2022. And I sat on, my lords, to explain the entire difference that the assessing officer seeks to understand. The same is explained in complete, my lords. The copies of the letter of confirmation is also at page 151 onwards. I have secured letter of confirmation from each of my creditors and given a complete proof of the purchase made by me of 38 crores. Now, my lords, at page 173 is the assessment order in this background. Page 173 is the assessment order, my lords. Page 176, my lords. Insofar as the unsecured loan, he drops the addition. He accepts my explanation and drops the addition. In respect of the issue of purchase, my lords, he notes, my lords, that, may I read, my lords, para 3.8.2. In order to verify the purchases, assessee was asked to provide the details of creditors outstanding at the end of relevant assessment year, and along with the same, assessee was also required to file the details of quantity of item and value of item and reconciliation with the total amount of purchases debited in the trading account. In response to the show cause notice dated 25th of February, assessee, by reply dated 1st of March, has furnished copy of purchase register maintained by the assessee and confirmed copies of sales in the books of debtors. Now, my lords, next paragraph. A perusal of the purchase register vis-a-vis sales reflected in the Form 26 AS during the first quarter. This is an issue that is totally alien to the proceeding. This issue has never been raised till date. This issue does not constitute material available on record under Roman 12 of 144B.
The only contradiction was the trading account entry and the purchase register.
Yes, that he sought for a difference of it. I explained it along with party confirmation from the other side. I did more than what was required. He did not even ask me for confirmation, but I nevertheless supplied the same to prove my purchases. He brings a completely new material and brings to tax 11.77 crores at 178, page 178. This material was never on record. He could not have taken that material. He could not have made an addition based on material that was not on record. He did not have the jurisdiction for this. There was never an inquiry on this point also.
They can, the lordships may kindly consider, my lords, let them consider this as a show cause notice and reply to this, my lords. My lords, let them consider the reply and pass freshers.
Show cause notice under the law has already been issued, to which I have responded, my lords. This cannot be a show cause notice because there has been no inquiry in this regard. There has to be an inquiry, he has to satisfy himself, and then he can issue show cause notice if at all there is a income escaping suggestion. If at all the department is doubtful of this matter, they have the powers under 148 to issue a proceeding, my lords. But not this proceeding because it has attained finality until the point of show cause notice. There is no illegal or wrongdoing insofar as show cause notice is concerned, to which I have dutifully and correctly replied with the details. So therefore, if your lordships may see 144B, what it says is show cause notice is to be issued, to which I have filed reply. It is duty bound upon him to consider the response and issue an assessment order. He cannot bring any new material. New material, he has to invoke 148, not under 144B now.
Then you take your stand and write. Please. Learned counsel for the petitioner would submit that the assessing officer has referred to the data contained in Form 26 while comparing with the entries in the purchase register, and such aspect was not a subject matter of any of the show cause notice during the process of assessment. And accordingly, it is submitted that the order is required to be set aside as regards such addition made while relying on 26 years. Data in Form 26 years. Matter requires consideration. In the interregnum, there would be stay of.
And I said C1, my lord. C1. Not sorry, my lords, not C1. G1, G2, G3, G4.
G1 to G4. Statement of objections to be filed within 3 weeks.
Obliged, my lords.
The petitioner, insofar as office objection raised on non-filing of legible copy, learned counsel for the petitioner submits, legible copy will be filed if the same is relied upon at the time of hearing of the matter, and accordingly, said office objection is overruled subject to the undertaking. Yes.
7.
Wait, please, my lords. This is income tax reassessment here.
Termination appears, my lords, is on VC.
Yes.
Yes.
My lords, the petitioner before my lords challenges for the assessment year 17-18. The reassessment notice under section 148, which is given in annexure A108, dated 29/3/2024, my lords.
29/3/2024.
Lords, the petitioner challenges these proceedings on various counts, but at this stage, my lords, the first ground is that it's barred by limitation.
Under 149.
Under 149, within brackets 1, within brackets small a, which would give a period of 3 years, which would lapse, my lords, on 31st March of 2021. In order that, my lords.
Just point out 149.
My lords, section 149. My lords were to kindly take page 1.1019 on the right hand side.
Yes.
Lords, are there?
Yes.
Time limit for notice. Subsection 1, no notice under section 148 shall be issued for the relevant assessment year if 3 years have lapsed from the end of the relevant assessment year, unless the case falls under clause B. My lords, in order that the case falls under clause B, first of all, my lords, the respondent has to mention in what manner clause B is attracted. The entire notice under 148A within brackets B and the order under 148A within brackets D, my lords, which are also impugned before, my lords. There is absolutely no averment about the extended time limit under 149(1)B and in what manner, my lords, the extended time limit under 149(1)B would apply to the instant facts of the case. If I may be permitted to read clause B, my lords. If 3 years, but not more than 10 years, have elapsed from the end of the relevant assessment year,
In case the books of accounts has
unless
details regarding
he
asset
has to have
expenditure.
evidence, books of accounts or other documents which reveal that the income chargeable to tax is represented in the form of an asset. So which asset? All these will have to be stated. Neither in the notice under 148AB, nor in the order under 148AD, nor in the impugned notice under 148. Is there a mention, let alone the contents of 149(1)B? Even a reference to 149(1)B is not there. It
Yes,
is incumbent upon my lords for the revenue to bring upon this.
yes,
to
get
assume-
instructions. Tirumalesh, you get instructions.
Yes,
We will have to consider it, let us.
yes.
Then senior counsel appearing for the petitioner submits that for the assessment year 17-18.
17-18. my lords.
The note, proceedings have been initiated on 29/3/24.
24 my lords, yes.
29/3/24, which is beyond the time prescribed under section 149, Roman 1A, full stop. Further submitted that for the extended time period under 149, Roman 1B, no reference is made which would enable falling back on the extended time period, and in the absence of such jurisdictional finding, proceedings are vitiated. Matter requires consideration. Accordingly, there would be stay of
Annexures A, B, C, my lords.
annexure A, B, and C. The learned counsel Tirumalesh accepts notice for the respondent. Respondent is at liberty to seek for modification of the interim order upon completion of instructions.
One small prayer, my lords, for kind consideration. More or less similar matter, my lords. This honorable court was pleased to issue notice in WP 8128, my lords. If this matter may be connected, there could be 8128 of 2023, my lords. I'll pass on the.
Same SSC.
No, different SSC. Several years, one of the assessment years would be 1780, where the issue of 149(1)B, my lords, also is involved. I would not say exactly identical, but it would, my lords, be in relation to 149(1)B. So if connected, it could be handled.
Just along with WP 8128 of 2020.
8128.
But it could be decided otherwise also.
It could be decided. There are so many other grounds, my lord. It could be decided without that also.
Yeah, I will not come in the way of lawyer strategies.
My lords could even decide it independently.
No. I'm just saying.
Yes.
Yes.
Obliged, my lord. Greatly obliged.
8, Ajay Jain, serial number.
Lordship, I am appearing on behalf of the petitioner.
I'll take notice for respondents.
Lordship, I am appearing on behalf of the petitioner. Lordship, we have filed this petition against two order in original, whereby the custom duty demand has been raised on the petitioner Air India Limited. Lordship, our challenge is on 3 grounds, each of which is covered by the decision of Honorable Supreme Court. Lordship, the first one is that the show cause notices were issued somewhere in 2009 to 2014-15. And the adjudication has happened after more than 10 to 15 years. Such delay, Lordship, such inordinate delay has been considered as vitiating the entire proceeding by various High Court as well as Honorable Supreme Court in case of ATF. Lordship, that is the first ground. Lordship, the second ground is that Air India Limited has been issued this notice in respect of an actions by the subsidiary limited. Lordship, under the customs law, and a notice under section 28 can be issued only on the person chargeable to the duty. There is no deeming fiction to issue a demand notice on the holding company. Lordship, there is no such. In fact, Lordship, at the time of personal hearing, Air India Limited mentioned it very clearly that it is not pertaining to my actions. It is not pertaining to the imports made by me. There was also a letter by Air India Express Limited, which is the subsidiary company of the petitioner, wherein they stated that this is not pertaining to Air India, this is pertaining to our operations. In spite of that, Lordship, a notice has been adjudicated under section 28 against a person who has not imported it. So, Lordship, completely beyond jurisdiction and directly in teeth of the explicit provision of section 28 of the Customs Act. Lordship, the third point and the ground in this particular case is, Lordship, it is stated in the order in original that the show cause notice are adjudicated after such a delay because the show cause notices were kept in call book. And why these were kept in call book? Because there was a favorable order in favor of the SSC, but department went for an appeal. Those appeals were dismissed. So there is no ground as such for deciding this. Still they go ahead and decide this issue, violating the principle of judicial discipline.
Just 1 minute. On point number 2, you just point out point number 2 regarding your contention that this pertains to the subsidiary and not Air India. Just point out from the records.
Lordship, the order in original is at page 58. Annexure A.
Yes.
Lordship, from page 59, the first para, the Messrs. National Aviation Company, Company of India Limited, later known as Air India Limited, are operating passenger flight from Bangalore to Dubai and back through their subsidiary Air India Express. The operation of schedule of return flights are as under. Then Lordship will see the airplane code is there, IXE, which pertains to Air India Express and not Air India, because for Lordship, for Air India the code is AI, like Indigo the code is 6A. Then Lordship will see at page 65.
As regards such contention, what is the finding? Is there any finding recorded as regards this contention?
Lordship. For that, Lordship, first of all, we'll have to see page 65, wherein they mentions the submissions made by Air India Express. Both the parties were called for the hearing, Air India as well as Air India Express. Air India Express at page 55, they have recorded the submission that the show cause notice is invalid as it is issued to SEL. The company operating the flight is a separate legal entity, Air India Express Limited, and the show cause limited being served on a wrong entity. Lordship will see page 65, first para.
Page 55.
65, Lordship.
Yes.
The first para, Lordship, wherein they record the statement of the subsidiary company. The show cause notice is invalid as is issued to NACIL, Lordship, the earlier name of Air India. The company operating the flight is a separate legal entity, which is Air India Express Limited, and the show cause notice being served on a wrong entity. Therefore, the proceedings are void.
Any finding on this?
Lordship, that finding is there, page 70. Para 29.
Yes.
Wherein it is written, Lordship, that Air India Express Limited has contended that the show cause notice were issued to Air India, but the company operating the flight is a separate legal entity. On perusal of records, I find from all the show cause notices were dispatched to Air India as they were operating the international flight through their subsidiary company, that is Air India Express Limited, for which the whole matter is disputed. And I hold that the SCN dispatched were rightly served to Air India Limited. Therefore, I hold that the submission of Air India Express does not merit to be considered. Lordship, is 28, Lordship. Lordship, there is a compilation, Lordship, my colleague will hand over.
The compilation could be compilation. Section 28.
Section 28. On compilation, Lordship, page 5.
Yes.
Section 28. Where any duty has been levied or has been short levied or erroneously refunded, or any interest payable has not been paid, part paid, erroneously refunded for any reason other than the reason of collusion or any willful misstatement or suppression of fact, the proper officer shall within 1 year from the relevant date serve notice on the person chargeable to duty. A notice can only be served on the person chargeable to duty. Lordship, Honorable Supreme Court in case of Trivandrum Rubber, Lordship, which is the first case law in the compilation, and Honorable Bombay.
Yes, yes. It requires consideration. You take your stand in writing. The counsel appearing on behalf of the petitioners submits that the proceedings relating to the transactions of Messrs. Air India Express Limited, which is a subsidiary of the petitioner.
Otherwise, my lord, if it is
has
only a
been
ground of.
proceeded with as against the petitioner, which is contrary to section 28 of the Customs Act. It's further stated that the records that the assessing officer has referred to such contention, but finding is recorded devotes the mandate under section 28. Matter requires consideration. The respondents to file their statement of objections within 3 weeks. Till then, there would be an order, interim order of stay of
Annexure A and Annexure B, Lordship.
Annexure A and B. Respondents are at liberty to seek for modification of the interim order upon completing their instructions. Third counsel, so and so accepts notice for the respondents.
Response.
Amit Anand Deshpande accepts notice for the respondents.
And Lordship, even on the point of limitation, Lordship, after 10 years,
That
Supreme
we'll see,
Court
that
says
we'll
you
see.
cannot adjudicate.
Yes, that we'll see.
Lordship.
What is the office objection?
Lordship, those were in relation to some additional show cause notices which were filed. It was cleared last time on the last occasion, Lordship.
Third counsel for the petitioner submits that memo consists of documents, and the same would be filed by way of additional documents during the course of the present proceedings. Accordingly, office objection is kept in abeyance for the present. Yes.
Copies will be done.
Obliged, Lordship.
Copies to be furnished to the counsel for the revenue forthwith.
Lordship.
Yes.
9.
Obliged.
G. 9. Just make idea next Tuesday, my lord.
At request.
At the same stage.
Release the matter in the same stage.
3rd July.
On 3rd, we'll have it in the orders list. Now it has crossed fresh matters list. In the orders list. Yes.
My lord.
10.
Grateful.
Serial number 10.
Yes.
This is the rising of an ex parte order. What has happened is, if you honest way to take to page 28, the Singh officer has tabulated a chart. These mails were not received by me, I could not appear, but at the show cause notice stage, I have filed a reply and sought time. The assessing officer, if you honest take to page 28, top of the page, he gives me 2 days time. And then thereafter, within 2 days thereafter, I again sought time here also. He says, not received, but I have filed a reply. It's at page 50. I have asked for time until 24th. 51 is my letter. I have replied on 12th and said I need time till 24th March, but the order is passed on 16th. And he has made 3 different additions. On the legal issue of estimation, he could not have made other 2 additions, but still, I still need to file documents. It can go back to the stage of 143(2), Your Honor.
To the stage of show cause notice, my lords, let them reply to that show cause notice.
Thing has been filed. He's made a 6 crore addition, essentially.
They can file now.
I need to file Sunday creditors.
They can file.
Sufficient opportunity, honest may say, please.
So remanded to the stage of reply
Show
to
cause
show cause
notice.
One additional opportunity. Show cause notice will be too short. He'll see again 7 days time. 4 crores creditors I need to file. I don't know how many creditors are there. 30, 40 people. Some difficult.
You have spent enough time here before the.
Yeah. We have come immediately, Your Honors.
The petitioner has called in question validity of the order under 143(3) with section 144B of the Act at Annexure A, as well as the computation sheet at A1, comma, the demand notice at A2, and the notice at Annexure B and Annexure C. It is a case of the petitioner that during the assessment proceedings, petitioner was issued with a show cause notice. Where is the table page?
Page 27 and 28.
On 9/3/2024, and was asked to reply on 12/3/2024, and the petitioner admit till 24th March 2024.
Please.
As evidence from annexure F.
F1 also. F and F1.
F and F1, and despite which the disregarding such request for adjournment, the order itself has been passed on 16/3/2024. Full stop. He submitted that what has happened? They have added, is it?
They have made additions. 3 additions are there. Okay, honors were to take to page 37.
30?
38 euros. In page 38.
Yes.
4 crores, my sundry creditors has been added in full. Then 1 crores cash expenditure, he says, which I do not have an opportunity to reply. 53,000 is an interesting part. He, page 36, if you honest were to see, he takes the average of my net profit. There's a table.
It is submitted that the variation in respect of unexplained expenditure under section 69C, comma, variation in respect of business income, and variation in respect of unexplained expenditure under 69C could be explained if sufficient opportunity is granted. And in light of the request for adjournment having been rejected, petitioner has been deprived of opportunity to substantiate that variation would not arise. Full stop. Taking note of the information relating to details of opportunities given, which refers to notice being issued on 9/3/2024 and compliance required by 12/3/2024, and the remark not received. Clearly, there appears to be clearly the assessing officer has not taken note of the adjournment application at annexure F and F1. Full stop. In light of the contentions raised, it could be stated that the time that was afforded in the notice of 9/3/2024 is insufficient and has caused prejudice to the petitioner insofar as his request for adjournment has been rejected. Accordingly, taking note of the said contention of violation of principles of natural justice and prejudice caused, the order is set aside and matter is remitted to the stage of reply to the notice under 144 dated 9/3/2024. Full stop.
144 is 14/12/23. Notice.
There are two 144.
Two 144s. Let it go back to one.
Get one 144 at page number 27.
14/12/23.
Notice under 144 dated 14/12/2023.
Please.
Full stop. The contention of learned counsel for the petitioner that documents are voluminous and time beyond 7 days may be granted in the peculiar facts and circumstances of the case is a matter to be taken note of by the assessing officer appropriately. Accordingly, the
A1.
at annexure A is set aside, as well as the demand notice at A2 and penalty notice in B and C, and matters remitted to the stage as observed herein. All contentions are kept to open. Learned Counsel Dilip accepts notice.
Lordships have already issued notes.
We already
Process
served them.
already is having.
Yes.
Obliged. 11, Balachandran BS.
Notes, I'm tuned, annexure L.
Income tax.
Yes,
Income tax.
annexure L. This order has been
Malish,
passed.
you have to accept notice in
Yes,
this
yes, I
matter.
am there.
Yes.
Yes, my lords. I want to draw your annexure C, my lords. 77 to 81, my lords. This order was passed by this honorable court on 28 June 2023, my lords. And para 5 is relevant at page 80, my lords.
Yes.
Accordingly, penalty order dated 26 May 2023, annexure H is set aside. Consequently, the orders annexure H1 and H2 are also set aside. The matter is remitted back to the stage post notice dated 19th May 2023, my lords. So now he is saying that the penalty proceedings which are again initiated, it is by my notice dated, my lords, 92 page, my lords.
No, but that is a subsequent proceeding. Penalty is subsequent.
Subsequent to this order, my lord, set aside. He is saying that it is initiated now by 31st October 2023, his notice. And this is contrary to 2 earlier notices issued by them, my lords. That one notice is, my lords, 133.
Yes. Now, you can't be so, I can't understand. There must be application of mind, Tirumalesh.
Yes.
When the order goes, how can the penalty proceedings continue independently? All consequent proceedings go back. We have remitted it back to the stage post notice, sir. If that is so, how can penalty proceedings continue?
I am not sure if the officer is aware of the orders passed.
No, it's a.
My lord.
This observation is made in the. He has been communicated with the order.
Yes,
Oh, yes.
my lord, that's what I am saying. I kindly see 133, my lords.
133
page. This is the notice dated 22nd September 2023, my lords. And he is saying that this is in pursuance to order of Honorable this High Court.
Same writ petition.
Same writ petition, my lords. And then kindly see page 91, my lords. Annexure F, my lords. This is also the same. He is giving me 610, and he's saying that it is initiated on 31st October, my lords.
Let us see.
And if it is a 31st October, the limitation would 30th April. And if it is this 22nd September, it will be 31st January, my lords. And order is passed in April, my lords.
Learned Counsel Sri Tirumalesh accepts notice for the respondents. In light of the contention that by virtue of the order in WP 12410 of 2023, matters stood remitted to the stage post notice of 19/5/2023. There was no warrant for continuing with the penalty proceedings, which is a subsequent proceedings. In light of such facts and contention as made out, there would be an interim order of stay of
L1 and L2.
L1 and L2. The
L1 and
respondents are at liberty to seek for modification of the interim prayer upon completion of instructions. Now you find out, you don't have to wait, but you move the matter if upon looking into it, you see this ground, you move it, we'll close it.
Yes.
No, my lords, it's time barred. No, this is wrong statement of the AO in the order itself that it is initiated by 31st October. It is time barred, already time barred.
It is, yes.
Well, Harish.
May I please, Your Lordship?
Just
Lordship, I'm appearing online.
Just one.
Yes, sir.
IA 1 of 24.
And court cannot extend limitation, my lords.
IA 1 of 24 to be heard along with the main. Yes.
My lord, just one. Popat Biharu's decision is there, my lords. One minute, or will take only 1 minute.
No, let us see. That's on merits, we'll see.
No, on limitation, my lords. On
Correct.
limitation, it is the court also cannot. This is Supreme Court. The court cannot also extend limitation.
It's a double-edged sword.
Yes, Supreme Court. This is Popat Bihar, 14 to 19, my lords. And para 13, my lords, 18 pages. Page 13. It is a settled legal proposition that law of limitation may harshly affect a particular party, but it has to be applied with all its rigor when the statute so prescribed. The court has no power to extend the period of limitation on equitable grounds. The statutory provision may cause hardship or inconvenience to a particular party, but the court has no choice but to enforce it, giving full effect to the statute. The legal maxim dura lex sed lex, which means that law is hard, but it is the law, stands attracted in such a situation. It has consistently been held that inconvenience is not a decisive factor to be considered while interpreting a statute. A result following from a statutory provision is never an evil. A court has no power to ignore the provisions to relieve what it considers a distress resulting from operation, my lord. And one more only. Next decision.
This is what they argue against you. Against all SSCs, this is what they vehemently argue.
And para 6.5 from page 20, my lord, 24 page.
Yes.
And this is very interesting, my lord. Para 6.5. Now, so far as the prayer on the behalf of the appellant to condone the delay beyond the period prescribed under the statute, in exercise of powers under Article 142 of the Constitution of India is concerned, it is submitted that as observed as held by this court in the case of Oil and Natural Gas Corporation versus Gujarat Energy Corporation reported in such and such, where the statute commands the court shall not condone the delay beyond a particular days. In other words, can condone delay only up to a particular days, not beyond that. It would come within the ambit of and sweep of the provisions and policy of legislation, and therefore it is uncondonable, and it cannot be condoned even taking recourse to Article 142 of the Constitution of India. It is submitted that what cannot be done directly under the statute, as per statute, it cannot be permitted to be done indirectly in exercise of power under section. So these are the two decisions.
Yes,
their action has become already time barred.
So
it cannot be extended. They cannot be given.
Yes.
Thank you.
Well, Harish.
May I please, Your Lordship? Lordship, I appear on behalf of the petitioner challenging Annexure A, which is the impugned order passed on 1st March 2024, confirming the demand of GST on the ground that the supplies of services provided by the petitioner is not eligible for exemption as an educational institution, which results in the grant of commercial pilot license, foreign conversion license, and student pilot license, Your Lordship. This is the grievance that the petitioner has, that on an interpretation of the very same provision as to determine whether an institute becomes an education institution or not, specifically with respect to granting of pilot license training. The tribunal, in my own case, had laid down this proposition that the petitioner is an educational institution and eligible for the benefit of exemption from the payment of tax. In fact, this decision
for the previous year.
Yes, it was in the previous regime, Your Lordship, under service tax. But the law is the same. The determination of whether an institute is an education institution is verbatim, Your Lordship. And I place this on record before the adjudicating authority, stating that the tribunal has already taken a position on an interpretation of the very same provision. If I could request my Lord's attention to page 29 of the writ petition.
Yes.
My Lords, it is an extract from the notification 12 of 2017 central tax, where the entry number 66, Your Lordship. Services provided by an educational institution to its students, faculty, and staff. Now, the issue involved, Your Lordship, is whether the petitioner can be determined and adjudicated as an education institution. The definition of education institution is also expressed.
No, correct. Where is that order of the tribunal for the previous?
Yes, sir. The order is enclosed as Annexure J, Your Lordship, in page 258 onwards. It's a very detailed decision, Your Lordship, of the Honorable Tribunal, placing reliance on the Delhi High Court and the Allahabad High Court decisions, which have attained finality. In fact, the department has not filed an appeal against this order of the tribunal also before the Honorable Supreme Court. The specific finding, if I could request my Lord's attention, in page 281. My Lord has it?
Yes. Yes.
If I could request my Lord's attention to paragraph 32.9, which is at the bottom of the page.
Yes.
For the period after 1/7/2012, also the discussions made above would apply. Section 66D gives the negative list of services. Clause L of section 66, as it stood during the relevant time, reads as under: services by way of preschool education and education up to higher secondary school or equivalent. The next line is very important, Your Lordship. Education as part of a curriculum for obtaining qualification recognized by any law for the time being in force. Education as part of an approved vocational education course. Thereafter, if I request my Lord's attention to...
Let us see. The counsel for the petitioner submit that in the case of the same SSC, the tribunal for a previous time period, as per the order enclosed at Annexure J, has extended benefit of exemption, and in light of the position of law not having undergone any change in the present matter also, the authority ought to have extended such benefit which was extended at an earlier point of time. The matter requires consideration. In the interregnum, there would be stay of
Annexure A, Your Lordship.
Annexure A. Respondents to file the statement of objections within 3 weeks and are at liberty to seek for modification of the interim order, a modification of the order passed upon completion of instructions. Learned Counsel Arvind Chavan accepts notice for the respondent. Copies to be served forthwith. Yes.
Lordship, a small request, Lordship. There is one objection for insertion of page 256, Lordship. If my colleague is there in the court, if I may be permitted to make the necessary amendment.
Petitioner is permitted to comply with the
objection
in court. Yes.
I'm grateful, Your Lord.
13, Ravi Shankar.
I'm for the respondent.
Yes.
This is also an ex parte order. We have participated substantially, but the last notice we cannot reply. The honors were to take to page 31. The assessing officer has tabulated a chart. Last item, the date provided is only 3 days, essentially. Though it says 1 to 5. The time given was 3 days. My instructions are they logged in on 6th, but the portal is closed. I just want to point out 2 things. The additions made by the assessing officer at page 34. I'm a cooperative society, I lend money. What the assessing officer says is, page 34, bottom of the page, 4.7 paragraph. 15 crores, 1 lakh, he makes addition, stating that this amount has come out of the blue. It is not there in the earlier balance sheet. The previous occasion, I pointed out that it is filed under a different classification as loans, but now it is shown as creditors. Now, and the amount are immediately above 1 crore 12 lakhs. When I have 15 crores loans, I have to pay interest. He says you're not given proof of that. And over the page 3 crores, these are repayments of loans. So there's a duplication over and above what is there. So
Yes.
Yes, my lord.
has to remand it back with sufficient opportunity.
Shall we send it back or you want
Yes.
instruction? We can send it back.
Yes.
The petitioner has called in question the validity of the notice order under 143(3) of the Act, and is also sought for setting aside of the penalty notice at annexure A1 and annexure A2. In the case of counsel for the petitioner, that during the assessment proceedings, show cause notice on variation was issued on 1/3/2024 with the reply to be made on 5/3/2024. It is submitted that such short time may afforded is in violation of the SOP.
Yes, Your Honor. No,
At,
principles of natural justice say at least 7 days. Page 11, para G, I have listed what time it is issued. On first, he issues at 6:42 in the evening.
Violation of the SOP that requires at least 7 days time being afforded
Please,
for
sir.
reply to show cause
Please.
notice. Full stop. The said aspect regarding time to be afforded for reply to show cause notice is not in dispute. Third counsel for the petitioner has contended that in light of the insufficient time afforded, they were not in a position to make out a reply to counter the proposed variation and addition.
Yes, Your Honor.
Huh?
Yes, Your Honor.
And addition. Full stop. Such submission of prejudice having been caused due to the short time made available for reply requires acceptance. Accordingly, the order at annexure A is set aside. Matters remitted to the stage of reply to the show cause notice dated 1/3/2024.
Please, Your Honor. 15 days time may be granted. 15 days time.
The penalty notice at annexure A1 and A2 are also set aside. The contention of the petitioner that the time for making out a reply to the show cause notice, to which stage matter now stands remitted, ought to be extended for at least 15 days in the peculiar facts of the case in light of bulky records to be produced, an explanation made is a matter to be considered by the assessing authority appropriately. Third counsel Tirumalesh accepts notice for the respondent.
It's already been served last time.
Yes. At last sentence.
Obliged. 14, Srihari.
I'm for the
Because
respondent.
challenge in this writ petition is to notice under section 148 at page 89, my lords.
Income tax.
Yes, my lords.
Mr. Tirumalesh, my lords. This is Mangaluru.
Yes.
Notice under section 148, it at page 89, my lords. It is issued by the jurisdiction assessing officer. The pleading in the petition is that it has to be issued by the faceless, and the lordship in the interim order, sir. I'm passing along a copy of the interim order, my lords, issued by your lordship.
But this matter is still to be resolved. This matter is still to be resolved, but on merits?
On merits, my lords, he has issued, made additions of 2.16 crore demand is created without there being any due opportunity. All the responses were duly filed, my lords.
Now this issue of faceless is not yet resolved.
It is not resolved, my lords. This is a completely new matter. Bombay High Court in the copy of the Bombay High Court orders includes Bombay High Court in the matter of Hexaware Technologies has adjudicated the matter in detail and held that 148 notice cannot be issued by the judicial assessing officer in view of the specific section 151A, which provides for issue of the notification. And notification is actually issued. And notification clearly provides that all the 148 notices have to be issued in the faceless manner by way of automatic allocation. So it cannot be issued by the judicial assessing officer because it fails the very purpose of the faceless assessment.
So this requires consideration.
Batch of matters are there.
Huh?
Similar matters are already stayed.
But bunch is growing.
Lordship may actually
Get it resolved at some point. In light of the contention that notice under 148 could not have been issued by the jurisdictional assessing officer and ought to have been issued under the procedure prescribed for faceless assessment.
Yes.
Matter requires consideration, and there would be a stay of
M1, M2, M3 and N1, N2.
M1 to M3 and
N1, N2.
N1 and N2. That Counsel Tirumalesh accepts notice for the respondent. Respondent is at liberty to seek for modification of the
Lordship may actually
upon completion of instructions.
My lords may actually fix a date for this matter, my lord, because the Bombay High Court already considered the matter. So Lordship may fix a date for
this point has to be decided. Let them complete the pleadings in any one matter. We'll hear.
Please, my lords.
Yes.
15.
Lords, I appear for respond number 1, my lords, in this matter.
Please, my lord, I appear for the petitioners in this matter. Through online, my colleague is in the court, Mr. Recapture. Lordship, there are two petitions in here. First
just 1 minute. Yes, Customs, Principal Commissioner Customs. Yes.
Lordship, there are two petitions. One is Cart to India, which is the main assessee against whom investigation has been carried out by the Customs, and the other is ATM, which is a sister concern, but because of the investigation, certain goods have been seized of that. So I will request my lords to take the Cart to India petition first.
Yes.
So this is a second round of litigation before my lords, and the order, the previous order in the petition of Cart to India is at page 113. And paragraph 6 of this order, there was a direction given where the respondents were directed to consider our submissions and pass an order for release of the goods which were seized by the impugned seizure memo, which was challenged before the this honorable court members. The order in original was passed pursuant to this High Court order, and that order in original has not considered the vital points which we had argued, that there was no seizure itself under 110 of the Customs Act, and in absence of a seizure, no goods could be held back. This was one point. And the second point was that the time prescribed that to issue a show cause notice is 6 months. If the time is beyond 6 months, then the goods have to be returned. So these were the two primary arguments before the authorities. And of course, on the merits, on the facts, there were other submissions. What had happened is that there were, just to give a background about the facts.
No,
Yes,
now let them take notice. We'll see.
Lordship, what has happened, in fact, pursuant to the filing of the petition, partial goods have already been released. They have released the partial goods which were in the godown. They are holding to my electronic goods like my computers, my hard disk, which is causing a hardship to me for day-to-day operations as far as this assessee is concerned. So they can take instructions. I absolutely agree with my lords. They can take instructions on the main issue, but I'm seeking at least my electronic goods. They can make copies. They can clone my electronic data and return those electronic goods to me so that I can continue with my day-to-day operations of business. So that is my request in this particular petitioner's case. And the prayer in respect of this, my lords, is at in the interim prayers at page 27, my lords. The prayer 35B.
Consider, we'll have it, you get instructions only on release of electronic, the rest is released.
Yes, my lords.
Subject to only on the, so far as the electronic goods. They have no objection for you to make copies. We find out later.
This is a second round of litigation. Not when the first round of litigation had taken place, they had appeared before us and they had made a detailed submission. Based on which, my lord, whatever goods that were liable to be released, we released it. Now, my lord, the investigation papers are, my lord, voluminous. I am told by the officers that the investigation is about to be completed and the SCN is about to be issued in 1 or 2 days. If show cause notice is issued, my lord, it will be still more easier for them to get it released. Therefore, my lord, I would request before passing any interim order, if the matter could be taken up after 7 or 8 days, Lord, quietus can put final to the entire matter itself.
So I'll have it week after next, let us see.
Very well.
Yeah, Lordship may keep it next.
Let them serve the cop. 2 weeks.
I'll fix a date.
Very
They
well.
want 10 days time, I'll fix a date. This is the matter in the orders list on week after next. On 10th. Third Council, Amit Anand Deshpande accepts notice for respondents. Union of India.
Lords, I appear for the union.
Union of India Pillai will appear.
For respondents.
Lords, I appear for the union.
Third Council, Shri Vinay accepts notice for the first
Obligements.
Yes. Vinay Venugopal.
One more indulgence.
First respondent. In WP 15789 of 24. Innocent coding. In WP.
Lordship, the second petition has peculiar facts.
15608 of 24. 1560. The Council Vinay Venugopal for R1. Will direct them to accept notice.
Yes.
This you want separate orders in this, is it?
Yeah, the second one, I'll just explain in
Both
2
of
minutes,
them
my
are
lord, what the,
similarly they were
what,
heard and they were decided.
yeah, both can be heard together, but the second petition is very peculiar in terms that there was no investigation against this petitioner. The investigation was against the first petition's petitioner. Yes,
Just one. Learned Amit Anand Deshpande accepts notice for respondents 2 and 3. Now your prayer here is similar or different prayer?
The prayer here is in respect of only for release of the goods which are lying in the warehouse, which in respect of the person against whom investigation is going on, they have already released those goods. As far as my goods, because my goods were in the same warehouse as the person against whom investigation is carried out, and there were some labeling errors in respect of the goods, they seized my goods also. That is the second petitioner. So I told them that these goods belong to me and not to the person against whom you are doing the investigation. So to that extent, they said that you are not proved your ownership to the goods and therefore we will not release the goods. Whereas the person against whom the investigation is going on, they have already released the goods. So my prayer in this particular petition is only limited that I will give whatever undertaking you want. I have also annexed a specific letter from the other person that the goods don't belong to him and they belong to me. I'm willing to give any kind of undertaking. So that's a limited relief as I am seeking in this particular petition, my lords.
Let us see. Let them take instruction. We'll pass orders on the next day.
Very well, my lords. Very well.
Now, what is now in the event digital goods are seized, and let's assume that you can't release them. Data can be still shared with the petitioner.
The officer instructs me to state that if he appears before the IO and shares the password, These are all, my lord, password protected data. If he gives the password, my lord, we'll copy it and we shall return it. That is what the officer is saying. They must
Very
give
well.
the password.
Now the counsel for the revenue is submitting that if you share the password, then they will take the data and they may
we will.
consider returning it to you.
We will.
In the interregnum, petitioner to appear before respondent number
2, my lord. Respondent number 2.
In
Tomorrow
light of,
already, if
in
he appears,
light of the submission that if password is furnished, the authorities will consider the interim relief as prayed for in this petition.
Very well.
Yes.
Obligement.
12 days time. My lord. For 12 days.
Yes. List on 10th.
Obligement.
Yes.
Copies will be directed.
Copies to be furnished 4th.
Yes, ma'am.
I am great.
16, Raghavendra CR.
May it please your lordship. Though, my lords, the challenge primarily is to annexure a order. The petition.
Commissioner of Central Tax.
Central Tax.
Yes.
Union of India and is also CBIC is also impugned the respondents. Reason, my lords, being that the challenge is to the works contract entry, the GST regime. The lordships have already heard it and stated the earlier matters, but I will just refresh your lordships' memories as to what the issue actually is. The petitioner, my lords, undertakes works contract services, laying electrical cables, transformers, etc. for government, predominantly for government and government companies like KIDB, BMRCL, BESCOM, etc. The dispute here, my lords, is that they have discharged tax at 12%, tax 18% tax. That is the dispute. Now, of the differential tax, my lords, more than 30% has already been paid by us. Factually. The challenge, my lords, is to works contract as an entry itself in service tax. The lordships would see page number 183, my lords. Kindly come to 185. This is the schedule 2. The lordships were to kindly have the GST Act also to be useful.
Page 180.
185.
Composite supply.
Schedule 2 essentially classifies the services. It says the following composite supplies shall be treated as supply of services, namely works contract as defined in clause 119 of section 2. Now, what is the composite supply, my lords, is found in 2(30). 2(30) may be add of the CGST Act.
Section 2.
30. 2(30). Lordships have got. Yes. Composite supply means a supply made by a taxable person to a recipient, consisting of 2 or more taxable supplies of goods or services or both, or any combination thereof, which are naturally bundled and supplied in conjunction with each other in the ordinary course of business, one of which is a principal supply. Therefore, my lords, if you classify works contract as a composite supply, you must be in a position to find out what is principal, what is ancillary, so as to put it. For example, I'll simplify this with, permit me to show and give your lordships an example. If we were to buy a television set, it has to be installed also. Television set is a goods and the installation is a service. It's a composite supply of 2, where the principal supply is the television set, because that is what I want. The services of installation is incidental. So it will come as a composite supply Because you can find out what is the principal supply, you can find out what is the ancillary or incidental supply. But when it comes to works contract, which is by nature indivisible, for example, my lords, this building, can we find out what is principal and what is incidental? It is not possible. So the theory of making works contract a composite supply itself seems to be faulty, which your lordships noted in an interim order, earlier matter. We'll place that before your lordships. The division bench also was seized of it that time in Dharwad. Works contract by nature, my lords, is indivisible. If it is indivisible, my lords, the question of what is principal, what is ancillary cannot be gone into. If that cannot be gone into, my lords, the charging section will not get attracted under section 8. Section 8 and 9, if your lordship sees the mechanism for charging in, is in section 8 for composite supply. Lordships were to come, the tax liability 8. Tax liability on composite and mixed supplies. The tax liability on a composite or mixed supply shall be determined in the following manner, namely, a composite supply comprises 2 or more supplies, one of which is a principal supply, shall be treated as supply of such principal supply. That means, my lords, what they do is, whatever is the rate for the principal supply is applied. If goods is predominant, goods, it will be taxed at goods rate. If services is predominant, it will be taxed at the service rate. Now, in case of a works contract which is indivisible, if you cannot determine what is principal and what is ancillary, it will be difficult for you to apply this itself. So on that basis, my lords were pleased to pass this order. Your lordships notice this dichotomy. That's mega engineering, the lordships would say.
Yes.
Amongst other the contentions raised, the lordships have got it. The primary contention raised is that in case of works contract which is indivisible, there appears to be an ambiguity between section 230 read with section 8 vis-a-vis paragraph 6A of schedule 2. It is submitted that this aspect requires adjudication in terms of prayer at annexure B. It's also submitted that the division bench at Dharwad has passed an interim order where an identical issue has been raised. Pending that, my lords, therefore the annexure of annexure A was stayed. This is one of the, on this point, if your lordships is convinced, I will not go into the other points.
Let us see, you take this interim order.
Annexure A, my lords.
Annexure A. Senior counsel appearing for the petitioner submits that the question of indivisibility of works contract and segregating principal supply is a matter raised before the coordinate bench, where an interim order has been passed in WP 14515 of 2023. Full stop. Interim order passed in WP 14515 of 2023 on 13/7/23 reads as follows. Next, accordingly, subject to further consideration, there will be stay of the order at annexure A.
A, man.
Respondents, learned counsel G1 accepts notice for respondents.
1, 4 and 5, I think he can take, my lords.
1, 4 and 5.
I think 2 is Union of India.
Union of India.
Madan Pillai takes.
Madan Pillai for R2. AGA for
3.
R3. Yes, Hem Kumar for R3. Respondents at liberty to seek for modification of the interim order upon completion of instructions.
17.
Deeply obliged.
17, Sandeep.
Wait, please. This is a writ petition challenging an order passed under the GST Acts for the financial year 18-19. Principally, my lords, on the ground that the liability or the order also has been passed in the name and the GSTIN of a dissolved firm. The firm, my lords,
was dissolved with effect from 31st March 2019. The registration, my lords, under the GST Act itself,
GST,
this would be state. Mr. Hemko.
yes.
So the firm also, my lords, under the GST Act also sought for cancellation of registration. The registration was cancelled by way of an order dated 1st October 2020, but with retrospective effect from 31/3/19.
Yes.
My lords, and after that, after the firm was dissolved and after the cancellation, for the first time in 2022, May, an audit proceeding was commenced, my lords. And subsequently, that has led to an order being passed on 24th April 2024. The two principal submissions, my lords, is that even apart from the general proposition that an assessment cannot be made on a non-existent person, is that under the GST Act specifically, audit can be done under Section 65 on a registered person. Audit report admittedly was passed on 10/10/2023. More than 3 years after the order cancelling my registration was passed, and more than 4 years after the order was made effective. Secondly, the assessment under Section 73, which is pursuant to the audit under 65, can be done on a person. Person, my lords, under the GST Act is defined to include a firm. If I am not a person as on the date, because I'm dissolved from 31/3/2019 itself, all the determination under Section 73, which includes notices which have to be served on the person chargeable with tax. If there is no such person as on that date, the order itself would be bad in law, as my humble subject. Yes.
In case the entity is dissolved.
Yes.
You mean to say there cannot be any proceedings against dues, etc. of that entity?
Yes. So that's the, in fact, that's the question which has come up time and again before various courts, my lords, especially with respect to a firm. With respect to a company, in fact, my lords, an order was passed just
before accepting its dissolution, they have to.
Yes. So in fact, that is the thing. Before the dissolution itself, they had the power to do the assessment. Even apart from that, courts have held, my lords, while interpreting other parameteria provisions, is that the Supreme Court has held, my lords, that in the case of a firm which has been dissolved, is a taxing authority is stopped from carrying out an assessment after the dissolution. They answered that by saying that if the taxing statute permits by expressly that an assessment can be made assessing or charging provision. So under the GST Act, there is no specific provision permitting assessment of a dissolved entity, contrary to what is there under the Income Tax Act. Income Tax Act specifically says under Section 189, which says that if a firm is dissolved, even then the assessing officer can assess the income of the firm as if there was no such dissolution, and all the provisions of the Act would apply correspondingly. No such provision is there under the GST Act. Like I said, my lords, so therefore my contention is that after the dissolution was done, after the registration also was cancelled, they could not have done an audit, and certainly they could not have passed an order. In a similar circumstance with respect to a company, an order was passed by this honorable court, quashing the show cause notice and assessment under GST. There it is a company which was dissolved under the IBC.
Yes.
Registration has been cancelled with effect from 31/3/2018. But assessment pertains to 2018-19, which is prior to assessment period, was prior to the cancellation of registration as well as the decision.
Anyhow, you take, but the proceedings were initiated only subsequent.
Proceedings were initiated, but this is for a period when the firm was existing, when they have conducted business.
Let us see. Take your stand in writing. Counsel for the petitioner submits that the firm having been dissolved with effect from 31/3/2019, proceedings subsequently cannot be initiated against such dissolved firm. Matter requires consideration. In the interregnum, there would be stay of
A1, A2.
A1 and A2. Order at A1 and A2. Respondents to file the statement of objections within 3 weeks. And are at liberty to seek for modification of the interim order granted upon completion of instructions. Learned Counsel Hemkumar accepts notice for the respondents. Please, sir.
18, Sandeep.
Serial number 18, my lord, pertains to, in fact, it's very similar to serial number 14, which my lords just heard, where one of the contentions is that the notice under 148, in terms of which the petitioner's assessment has been reopened, has been issued by an officer other than the faceless, not under the faceless scheme. My lords have passed a similar order of stay. I've produced it at annexure 124.
Who appears? Who appears?
This thing, Dilip would appear.
Third counsel for the petitioner would submit that the notice under 148 would not have been issued by the jurisdictional assessing officer and ought to have been issued after following the procedure applicable for faceless assessment. Matter requires consideration. In the interregnum, there would be stay of
Annexures N1 to N3
annexure N1 to N3
and P1 to P3.
and P1 to P3. The counsel Dilip accepts notice for the respondents. Respondents are at liberty to seek for modification of the interim period upon completion of instructions. What is this
For dispensing.
IA1 of 24 is allowed and petitioners dispense with production of certificates as stated in the application.
Number 21 also is the case of the same petitioner, same.
P1,
Please, Manoj. For the subsequent assessment here.
the same order. Same order.
No, just the annexures, my lords, may just do, I'll just point that out, Manoj.
No, is it the same contention?
The same contention. Yes, I'm sorry, Manoj. Yes,
So
same.
same order.
The documents, I mean, the pleadings to be stated, Manoj, annexures M1 to M3 and N1 to N3. That would differ.
The same order. Stay of
M1, M for Mumbai, M1 to M3 and N1 to N3.
M1 to M3 and N1 to N3. In the same order as it is.
They may be tagged, Manoj.
List serial number 21 along with serial number 18.
Much of it.
Dilip accepts notice for the respondents.
19, Pradyumna.
Yes.
Lordship, the petitioner is engaged in supply of manpower that technically qualified people to
Petitioner of commercial taxes.
I'll take notice.
Yes.
supply of manpower, Lordship, to technically qualified engineers and others to different companies, Lordship. Audit of his records was conducted for the year 17-18, Lordship. There were various objections. Ultimately, they have crystallized in 3 major objections, Lordship, which are part of this petition, Lordship. May I kindly pass on because the number of issues, Lordship, just summary of the demands. Serial number 1, Your Lordship, in the table, there is a demand of GST of 53.19 lakhs on a turnover of 2.95 crores, Your Lordship, which according to the impugned order was short declared, Your Lordship. During the audit following the audit of the records, Your Lordship, an audit report was issued. It was contended that this 2.95 pertains to pre-GST period, that too in respect of services provided to units located in special economic zone, where service tax was payable but was not payable by way of an exemption, Lordship. I have placed the copies of the exempt notification in this compilation, which I have now passed on. This was not considered, Lordship. The order has been passed, where apparently number of hearings have been given, Lordship, number of opportunities. I have in fact attended number of hearings, given the documents. In fact, there were calls to me also, the council saying that we come. I said, we have actually given all the documents of SEZ where services were provided, and this pertain to pre-GST period.
And Lordship, there is one statutory report, statutory return to be filed by an assessor to GST, that is Form 9C, which is, it is audited reconciliation report, Your Lordship, which is filed under Section 44, read with Rule 83 of CH-10 rules, Your Lordship. According to Your Lordship, I have to file, and in that report, I have shown clearly shown the turnover pertaining to pre-GST period of 2.95 crores. That has been overlooked, Your Lordship. He could have conducted an inquiry with the customer because the customer names are there. That has not been done. Apparently, records that number of hearings were good. Hearings were not necessary, not required, because even during audit itself, I had clarified this issue. This is one issue, Lordship, 55 lakhs rupees, 53.19 lakhs, along with interest, attendant levies, comes to more than 1 crore. Second thing, there is second item, Lordship, there is a demand of ITC to the extent of 6.89 lakhs, Lordship. That is difference between GSTR 3B and GSTR 2A returns, Lordship. Where Lordships already have taken a view that even in the absence of a party not making any submissions, the assessing officer ought to have examined the circular issued in 2022 by the board, Your Lordship, which provides that for 17-18, where even if appeals are pending, proceedings are pending, he could have given that opportunity. That was not done. Lastly, there is a demand of 3,66,000 of GST on expenses and reverse charge mechanisms. My submission is that these expenses, Lordship, pertain to travel, conveyance, etc. of the staff of the company. They are not spent for some other purpose, staff. So all 3 demands, according to me, are unsustainable, Lordship. I pray that the matter has to be remitted back, because we have the evidence and have placed it also in the writ petition, Lordship. The copies of the permission given by the Special Economic Zone.
Second. Council Chairman Naik accepts notice. The respondent. This is the matter. The preliminary hearing is on 2nd.
Lordship, they have returned to the department, has returned to IBM, who is withholding my payment for more than 15 days. Similar action has been taken to another company called Caterpillar, Lordship. An interim order, Lordship, where they should not deduct my payments interim until the next hearing, Lordship.
Respondent not to take precipitative steps till the next date.
Annexure N, Your Lordship, Annexure N and similar action, any course.
Not to take precipitative steps till the next date.
Obliged.
20, Pradyumna.
Lordship, I am challenging this impugned order passed by the appellate authority, where my appeal has been rejected on the ground of limitation, Lordship. The brief facts, Lordship, are that during 2021, I was called upon by the central tax authorities to offer explanation on the difference between ITR and service tax returns, Lordship. Your Lordship, I kindly see page number 46 of my petition. Page number 46.
Yes.
Even during the almost the second wave of COVID, Your Lordship, was already the effects were being felt. During that period, I was called. I proceeded to the office. I submitted the documents on 19/4/2021, Your Lordship, clarifying that my services include the VAT sales also. An entire turnover doesn't attract service tax. Subsequently, I issued a show cause notice, which crystallized in an order, Your Lordship, passed by the original authority, where the entire amount was confirmed. 1 crore odd amount was confirmed. I filed an appeal, Your Lordship, against this order on 3rd April 2023, which was within the limitation, Lordship, which is there on page number 06, Lordship. Page number 06.
Yes.
On the day of the filing of the appeal, present appeal before the appellate authority, I didn't have the resources to pay the pre-deposit amount, Lordship. I did not pay I was not able to make the pre-deposit. So for that reason, there is the averment of the petitioner that he was not given an acknowledgement. Is that with an advice that you pay and come back. So in page number, immediately he wrote a letter, Lordship, on page number 107, Lordship, which is dated 2nd May 2023. There he pleaded with the Commissioner of Appeals that he was still facing financial hardship and that 30 days time may be provided to pay the 7.5% amount, Lordship. And true to his words, Lordship, he paid these amounts on 14th June 2023. The challenges are placed on page number 108 and 109, Lordship. Around 9.31 lakhs, Lordship, it's constituting 7.5% of the amount was pre-deposited. And on that, when he showed this evidence of pre-deposit, the acknowledgement was given, that is dated on 19th June 2023, which is there on page number 104, Lordship. Page number 104, Lordship.
Yes.
Acknowledgement was given on 19/6, after being satisfied that he had made the pre-deposit.
By the time that pre-deposit was made, Your Lordship, the appeal was beyond the condonable period of 30 days, according to the appellate authority, and dismissed the appeal on this ground, Your Lordship. My prayer is, Your Lordship, going by the track record of this present petition, Your Lordship, he had approached the department during COVID. He had also filed the appeal for which he did not get an acknowledgement with the advice that you make the pre-deposit. He made the pre-deposit. In bed, he made also request that 30 days of time may be given, Your Lordship. So as regards the demand, Your Lordship, that suffers from grave infirmities, the entire amount has been taken for worst contact, where 60% abatement was liable to be given.
Yes, sir.
Take notice, I'll take instructions because Commissioner himself does not have power to condone. Therefore, the indulgence of this court may be required. I'll take instructions.
Counsel Arvind Chauhan accepts notice for the respondents. Read is the matter.
On 16th.
On 16th. 16th. In the orders list.
And an interim lordship, because department is now pressurizing me to pay the amounts, Your Lordship. Until then, Your Lordship, no, at least they may not issue courtship steps, Your Lordship, for recovery. Annexure A.
Respondents are restrained from taking coercive steps till the next date.
Grateful.
Urgent 22. 22.
Please, my lord, I'm appearing for the petition in this case, my lords. Let's in this case, we are challenging the notification issued by the central government, which is at page number 28, my lords, to extend the time limit to adjudicate the show cause notices issued under section 73, my lords. It's the notification is at page number 28.
But then this requires the stand of the respondents.
Well, it's in a similar case, nuts at page number 69. This honorable court has admitted the writ petition and granted stay to some the other SSC minutes. Page number 69.
No, he's saying that interim orders are passed by the coordinate bench.
Jeevan has taken notice, Jeevan sir. Jeevan sir has already taken notice in this matter. It's not there.
So he's saying coordinate bench, insofar as the same notification.
Passed over, my lord. I'll just inform Jeevan.
Pass over.
23.
Lordship is an ex parte assessment order, Your Lordship, followed by 148 AD order by issuing 148 AB notice. But Your Lordship, none of the notices and the 148 AD order, even 143 assessment order was served upon the assessee, Your Lordship. It came to the knowledge of the petitioner, Your Lordship, when they initiated the penalty proceeding and A and B was served on the assessee.
You're not assessing.
No, Your Lordship. It was not served upon me, Lordship.
Your Lordship, if it
It
is
was
only
only
for,
uploaded in the portal.
if their claim is that it is not served, my lord, if they want the matter to be go back, my lord, for reconsideration, and they can file the reply, my lord.
Yes, Your Lordship. At the stage of, in response to 148 AB notice, Your
Your
Lordship.
Lordship, but I have to get authorization, my lord. Yesterday only the copy has been served. Let them also serve the soft copy, my lord. Your Lordship can have it on Tuesday and get it disposed of, my lord.
Last week, the matter had come, Your Lordship. It was issued notice to. Tomorrow also it can be taken, Your Lordship.
Let them serve the soft copy, my lord. Today only.
I'll serve it by today itself, Your Lordship. Tomorrow the matter can be taken, Your Lordship.
There is no such urgency, my lord. Let it come on Tuesday.
Yes, the penalty proceeding has already been initiated, Your Lordship.
No, just 1 minute. When
Tuesday, my lord.
Tuesday.
Tuesday.
Relist
The proceeding can be stayed, Your Lordship, till Tuesday.
in the same stay, list the matter in the preliminary hearing list on first. And second, in the interregnum, respondent not to take any precipitative steps pursuant to the impugned orders.
Petitioner to serve
Even-
soft copy, my lord.
Petitioner to serve So,
Even the penalty proceeding, your lordship, to be stated.
so I said pursuant to the impugned.
Much obliged.
24.
She's scared, it won't reach next time.
No, yesterday only I sought for soft copy, Lord. They told that only hard copy is required to be given.
She's ready to accept your explanation, but she feels that matter won't reach. Yes.
Much obliged.
24.
Please, my lords. Its cost title is at page number 16. 1, 3 is center, my lords. 2 and 4 is state. Answering respondent, my lords, is 4. Essentially, we're challenging an order in original. The 1 and 3 parties have been made because we're also challenging the notification which my lords had in serial number 20. But I'll not harp on the notification, my lords, because in our opinion, it has to go back.
So 1 and
1 and 3, my lords.
1 and 3.
1 and 3, G1, my lord.
And then comes G1 accepts notice for respondent 1 and 3. Shamant Naik for 3 and 4.
2 and 4.
2 and 4.
For 2 and 4. Yes.
My lords may have page number 14, which is the list of dates.
Page
14, my lords.
Yes.
List of dates, my lords. This matter has gone through the entire scenario, my lords. Audit, pre-show cause notice, and then order, my lords. Our contention is not that opportunity has not been given. Our contention is that despite adequate documentation, my lords, examination of these documentation has not happened. And the officer has gone beyond the scope of his jurisdiction, my lords. To that end, my lords may see point 4, which is the audit report. On point 5, pre-show cause notice is issued on 14/12, my lords. In the pre-show cause notice, he states that you can give your response by 22/12, my lords. Therefore, we give our response to the pre-show cause notice by 20/12. Next day, he issues the show cause notice. We therefore reply to the show cause notice, etc. He goes on to record in the order that no response has been given to the pre-show cause notice. That's fine. That's not a problem because we've given adequately responses to the pre-show cause notice, to the show cause notice itself, my lords. My lords may have page number 281 for a minute, my lords. There is a summary chart that we have made of, These are the 6 issues in this, my lords. My lords may have 4th column, the total tax column. My lords have that?
Page 281.
281, my lords, annexure Q.
Yes.
4th column is the total tax column, my lords. At the bottom, my lords may see the total tax demand is about 29 crores odd, my lords. Out of this, my lords, 1 and 4, just to give examples, my lords, 1 and 4 will come up to about 26 point something crores, my lords. 4 is on tax not paid on import of services. And my lords have that, my lords. And my lords is on 3B and 2A, my lords. Just quickly, my lords, to point out what has happened in this matter. I am a person who's involved in advertising services and provision of advertising space, my lords. So I design, create advertising and provide space on the internet for them to display the spaces, my lords. Now, what I do insofar as point number 4 is concerned, there is something known as a 3CEB return, my lords, that I have to file under the income tax, which is basically all the related party transactions that I have overseas. I have to report it pan-India in this 3CEB column, my lords. Now, in India, my lords, I have 2-3 locations, 2-3 states in which I operate out from. Now, for GST purposes, my lords, this entire import of service that I do, my lords, I'm supposed to pay RCM basis, my lords. Now, my lords may have, for a moment, page number 94, my lords, of the order. I'll demonstrate through the order itself, my lords, their contention, our response, and the final order. Page 94, my lords. 3.5, my lords, somewhere in the middle, my lords. Tax of rupees 22 crores, my lords. During the course of audit, on verification of the financial audited statement and Form 3CEB, it is observed that the assessee has incurred expenditure of 123 crores towards import of services like information technology services, etc. And therefore, this is liable to be taxed at 18%, my lord. No difficulty on that. The tax amount of 18% on this 123 crores is 22 crores, my lords. No problem. My lords may now have page number 110. He's extracted, to be fair, he's extracted our responses also, my lords. 110. At the bottom, my lords, tax not paid on import of services. Your good office in the caption notice has alleged the tax is not paid on the import of services as reported in 3CB of the notice. Next page, my lords. In this regard, we wish to highlight that the transactions reported in Form 3CEB is pan-India based on inclusions and transactions from all states. In this regard, we have attached here with state-wise bifurcation of transactions as annexed by a good office in the caption notice as Annexure 9. Now, this Annexure 9, my lords, may have at page number 224. It's a small Excel sheet that we've prepared, my lords, at 224, Annexure J.
Yes.
My lords may see on top, my lords, vendor name as reported in 3CEB and the various GSTNs that I have. The first one is Haryana, my lords. The second and third one are Delhi. The fourth one is Maharashtra. The fifth one, the last one is Karnataka. And then, my lord, the grand total comes. At the bottom of this grand total, my lord, audit and show cause notice that has been issued. If at all there is a transaction that happens in Karnataka, my lords, I'm supposed to pay an RCM under Karnataka state, whatever be the amount as per the 3CEB, I'm supposed to pay that. What he has done is, he has taken my pan-India total and said, you have to pay RCM on this pan-India total of 123 crores. What we are saying, my lords, is this. Insofar as Maharashtra is concerned, I have paid RCM in Maharashtra because the import of service has happened in Maharashtra. Insofar as Haryana is concerned, I have paid import of service RCM in Haryana because the transaction has happened there. In Karnataka, unfortunately, my lords, I do not have a transaction for that year, which he fails to accept. My lords may now have page number 126.
Let us see, this matter requires.
He just needs to go back, my lords. We can consider, we can give them all of this documentation.
Tuesday or
again.
Wednesday, my lord, I'll make my submission.
My lords can keep the question of the notification open and this can go back.
It is, when do you want it?
Wednesday, my lord, 3rd.
This is the matter. The preliminary hearing list
Lords may have a stay of this order till then, my lords.
on 3rd. In the interregnum. Respondents not to take precipitative steps to the impugned orders.
My lords, same stage next week, if possible.
Let us see, let it come in preliminary hearing.
Sure, lords. Brief.
So number 25. May Rajkumar.
Yeah.
Please.
Yes.
OG for the assessment year 14-15 was passed on 24th January 2024, Annexure B, determining a refund of 26 crores. My lords, kindly see Annexure B, page 48. ₹26 crores, 98 lakhs, refund was determined. In the meantime, my lord, 17-18 assessment was completed. That was in fact way back in 21. And there was a demand notice. If my lords kindly turn to page 57. Demand for 17-18 was 17 crore 48 lakhs. Page 57.
Just 1 minute.
Yes.
For 17-18,
there was a demand for 17 crore 48 lakhs. I filed an appeal against that order. I filed an application for stay before the assessing officer, paid the required 20%, which is about 3.5-4 crores. And stay was granted. My lords, may kindly see Annexure G.
page?
Page 65. As 20% of demand is paid, collection of balance payment. And that was extended by page 66. And thereafter, multiple times, the balance demand was sought. I said, since 20% has been paid by the circular, I don't have to pay anything else. Now, my lords may kindly see page 50. I have paid 3.5 crores off that 17 crore demand. Page 50, 51, they again adjust 17 crore 48. The entire out of 26.98 crores refund determined for 14-15. Page 50 and 51 together 17 crore 48 lakhs. Despite my paying 20%. And there being a stay. This is covered by your lordship's order yesterday in Mr. Ravishankar's case, where your lordship said the refund could not have been adjusted and granted. So squarely covered.
Your Lordship, may kindly have on third, my lord.
That is writ petition number 8106 of 2024.
Relist the matter in the same stage on third at request for the respondent.
Number 26, Shri Hari.
On third they want it.
Can it be on second? Hmm? Third is great.
Yes, ma'am.
Serial number 26, my lords, there are several contentions. The first contention is identical to the contention in serial number 14, my lords. 148 being issued by the jurisdictional assessing officer instead of faceless. That is the first contention, that's identical. The next contention, my lords, is with regards to the validity of section 148A clause B notice.
Income tax. Who appears?
6, Dilip.
148 AB.
148 AB, my lords. It's at page 76, my lords. Notice has been issued. Lordship may take to page 77. Notice is issued to me stating that there is a cash deposit of rupees 45,000 in my bank account. I respond stating that mere deposit of 45,000 does not constitute information under the Act.
No, this is only above a certain amount.
That's one part of it, my lords. That's insofar as the cash deposit 50 lakh rupees is concerned. That doesn't apply to this case because this is the case within 3 years. This is the case within 3 years. Therefore, the 50 lakh limit doesn't apply. But what's important is the meaning of the term information defined under section 148 AB and 148. Now, this Karnataka High Court in the case of Vasanti Ramdas Pai versus ITO, copy of which is placed in page 116 of this petition, has explained in detail what the information would mean. And it has to be very definite and very specific is what the ratio of the judgment is. Now, I respond to the 148 AB notice, to which there is a further second one show cause notice issued. Without disposing the first show cause notice, a second show cause notice is issued now. Page 79 is the second show cause notice. Page 80 is the annexure. In response to my submission that the proceeding may be dropped, the respondent number 1 notes that please refer to your reply dated 13th of February 2023, wherein you have requested 15 days time and that the cash mentioned in the notice is only rupees 45,000 and requested to drop the proceedings. Your argument is not acceptable as the surrounding factors such that the withdrawals are indicated in Form 26 AS as 1.7 crores and 5.87 crores from the syndicate bank and SBI bank. These two are my own bank accounts. I have withdrawn the cash from my own bank account. That does not in any way mean that the income has escaped assessment. Money has come. If money has come from undisclosed sources, then they can say that they can ask for a source of the cash. From the sales made by me, I have withdrawn cash. Mere withdrawal from my own bank account of cash should not constitute information, my lords. Does the information of cash deposit of 45,000 suggests escapement of income?
You made out a reply to this.
Not filed reply,
My lords?
You have not made a reply to this.
I have only, for this I have not made reply, my lords. For this I have not made reply and directly an order is passed for this. My submission is that 45,000 is the only information on the record brought by him. On the basis of 45,000, information could not have arisen on the record of the assessing officer that would suggest that income has escaped assessment. withdrawal of money from my own bank account out of declared sources should not constitute income escapement. I am entitled under the law to withdraw my own bank account.
148 AD.
Yes, my
Order
lords.
is passed with respect to A3 or A1.
AB. There is no A1 at all. There was no inquiry conducted by him.
So only in as regards A3 order was passed.
AD order was passed on the basis of the second show court notice, supposedly. First of all, the second show court notice is not valid because he should have disposed the first show court notice. He could not have issued a second show court notice. Then he issues a second show court notice as an addition or in improvement to the first show court notice. And he says 26 years is the basis. 26 years does not constitute the 5 limbs of information under 148.
Yes.
My lords, the second show cause notice, my lords, is consists the first show cause.
Also.
Please, my lords, he refers to the reply filed by them also. Not so my submission, my lords, the second show cause notice, my lords, will merge, the first show cause notice will merge, my lords. Let them file reply to 148 AB, my lords. We'll consider that, my lord.
The first contention nevertheless remains, my lord, because he does not even have the jurisdiction. I challenge his jurisdiction. The 148 AB proceeding also ought to have been conducted by the Faceless. He does not have the jurisdiction.
He may close it by accepting her explanation.
My lords.
He may close it by accepting her explanation.
Department is not taking the stand, my lords.
Lords, let them not.
And in any case, 148 is issued in this case.
And it's an ex parte order also.
148 is at page 85.
Let us see.
148 at page 85 is issued by the jurisdictional officer.
We'll keep it pending.
Lords, next week it can be closed, my lords. My lords may kindly send it back to the stage of 148 AB. We'll consider the reply and we'll pass.
148 nevertheless is a sustains, my lord. It has been already been issued by the assessing officer. 148 is bad at law.
If it goes back, we'll keep open this contention.
Please, my lord.
On merits, if they decide in your favor, there ends the matter.
My lords, but my challenge to 148 AB nevertheless remains, my lords, because the first informer.
No, we are not disputing that, but we are saying after remand, if he were to accept your explanation in response to 148 AB, there ends the matter. According to you, you have a good case. You make out a reply. Let us see. We'll have it next week. Let us see.
Lordship may have it next week.
So on the point of jurisdiction, we'll keep it open. But on merits, if you are going to if you explain and he accepts, there ends the matter.
But jurisdiction aspect will remain, my lords. They are unlikely to accept my contention. That's a matter that is already settled against them by the Bombay High Court and Telangana High Court. So he does not even have the jurisdiction. Even if you are sending it back, it will again go back to the officer who does not even have the jurisdiction in the first place. Therefore, that issue needs to be addressed first, my lords, whether he has a jurisdiction or not. With Bombay High Court and Telangana High Court in my favor, should I still once again go back to the very same officer who does not have the jurisdiction?
Lordships, Lordships, on last week have already remanded a matter in keeping the jurisdiction issue open. Kindly pass a similar order in this.
You get it resolved then. Get it
I wish to press on this
decision at your highest level and get it resolved. There's no point in all matters being stuck in this logjam.
Yes, it's in this budget, my lords, there'll be an amendment is what. That is the reason.
If I may submit, my lords,
in light of the contention that 148 notice ought not to have been issued by the jurisdictional assessing officer, and the procedure under the as applicable for assessment and the faceless scheme ought to have been followed. There will be stay of
J1 to J3.
J1 to J3
and K1, K2.
And K1 and K2. Delete accepts notice for
this case, Lord. I'm doing the stone crusher activities. Kindly see, my Lord, audit observation. Annexure.
Royalty matter.
Royalty matter.
Royalty matter. The state
of the contention. Interim order in other matters.
My Lord, connected matters. Yes.
Of the contention that
court officer. Connected matters.
On mining.
Annexure, my Lord.
cannot be taxed.
F and H.
And this court and the coordinate bench as well as the apex court has passed interim orders. There will be interim order of stay of
Annexure F and H.
annexure F and H.
Yes.
Any payment. Annexure F and H. Council Shaman Naik accepts notice for the respondents.
Respondents 2 and 3, my lord.
Two and-
One, I think. Mr. Niralgi, my lord, will take notice.
2 and 3. Madnan Pillai for R1.
Correct.
Much of it. 28.
ಮೊನ್ನೆ ಒಂದು ಮಾಡಿ ಮೊನ್ನೆ ಒಂದು ಮಾಡಿದ್ರಲ್ಲ ಅದನ್ನ clarify ಮಾಡಿ. ಅದನ್ನು ಇಟ್ಟಿರು. Yes.
There are several contentions in this matter, my lords. The shortest one being at page 97, 148 AB notice. Page 97. The 148 AB provides me only 5 days time.
148
clause A,
no,
clause
page,
B.
Page
Page 97. It gives me only 5 days time, my lords.
by 28th.
23rd of March 2022 is the date of the notice. 97.
Time is available or barred now.
Lords 1.
Lordship have already passed orders in this matter, my lords.
No, correct. So time is not available for them to take fresh proceedings.
No, my lords. 1516 is time barred, my lords.
What is the, how many years?
10 years, my lords, if it's above 50 lakhs. Lords will have 10.
Not 10 years.
What is the time limit?
Time limit for the, under the first provider to 149 provides that the proceeding cannot be initiated if it could not have been initiated under the old proceedings. That's the language we use. In this case, my lords, the notice is dated 23rd of March 2022. Time is given until 28th of March. It's only 5 days time. On this ground, my lords, this court's order is at page 353. Page 353, this court has already passed order holding that provision of time less than 7 days. Coordinate bench order, my lord, sorry.
Page?
Page 353. Coordinate bench order where the 148 AB issued providing less than 7 days statutory time has been quashed.
No right can be preserved with them to initiate with respect to the same.
Yes, my lords. In this case, that would not arise because of my second contention, my lords. If I may take your lordship through that, my lords. Lordship may take to page 89. This is the case where I did not file my ITR originally. Page 89.
Page
89. I filed my Form 4 under income declaration scheme. I did not file my ITR originally. The central government released income declaration scheme. And in the income declaration scheme, I filed my Form 2 disclosing my income because the income declaration scheme essentially provided immunity if upright disclosure is made and no interest and penalty would be levied. Copy of the scheme, everything is part of the record, my lords. Page 89 is the certificate issued in my favor by the Principal Commissioner in respect of the disclosure made at row number 5. I have already made disclosure with regard to the incomes. Now, the very same income is sought to be taxed by the respondent number 1, assessing officer, at page 97. 148A clause B notice, annexure thereto, my lords, is at page 98. Page 98 lists the very same income which I have already declared under the income declaration scheme, paid tax at 45% and gained immunity. I filed my reply and my reply is at page 100.
So these TDS deduction.
Yes, my lords.
Are with respect to the same.
Essentially the same. TDS deduction is the mode of information that was supplied to the department because on account of TDS being deducted, the department came to know that income have arisen. And that constituted the basis for the 148AB notice to be issued. But what was not on record, what the respondent did not take on record is my declaration already made before the department under the income declaration scheme.
Where is this 161700?
My lords. My lordships is looking at my form 4 declaration or at my 148 AB.
No, at annexure A3, you pointed out at serial number 5.
Yes, my lords.
1617.
No, serial number 5 is the details of details of declaration as per the acknowledgement issued in form number 2.
Correct.
And the description, lordship may see pension income, house property income, professional income, income from other sources, and capital gain on sale of property. Again, income from other sources, capital gain on sale of property, income from other sources. Income from other sources essentially is interest. Now, your lordship may come to the basis of information for issue of 148 AB is at page 98.
Yes.
148 AB notice is once again issued on the very same income. Again, rental income, income from sale of property, interest income, which is income from other sources. Again, sale of immovable property, purchase of immovable property. Therefore, information is incorrect here. Income that is already declared by me and 45% tax is paid by me. That is treated as income that has escaped assessment. It could not have escaped assessment because it's already subjected to tax at the higher rate of 45% under the scheme. Yes. And despite my filing response, 148 AD order is passed without even considering it, without even looking into it.
Yes.
Lordship, the reply will be considered and will pass a fresh order, Lordship, if they want to go. 148 AD order. If it is not considered.
Wanted to go on the 7 days itself.
148 AB notice itself, 7 days itself, it will go. This jurisdiction is also another challenge. Faceless and jurisdiction assessing officer 148, Hexaware, Bombay High Court. There is a second challenge. Third challenge is that information 148 AB notice is bad because the information is incorrect. And incorrect information cannot be the basis.
Those cases, your lordships have reserved liberty because the assessment year was 2021. We had time to issue fresh.
Correct, but here it's
case,
not.
my lords, please, I'll have to file objections. I'll get instructions.
But what is that goes, it goes. That's all. What instruction?
Next week, my lords, I'll next week, my lord.
Learned Counsel Dilip accepts notice for the respondents. What is the interim prayer?
Interim prayer is for J1 to J3, K1 to K3.
Will be stay of J1 to J3 and
K1 to K3.
K1 to K3. In light of the contention that the time afforded for making out a reply in 148 capital A small b notice is less than 7 days as statutorily mandated. Just a week after next date.
29, Srihari.
In serial number 29, my lords, the notice is to the challenge is to notice to section 148 at page 89. This is the case of 148 being issued prior to 31st of March 21 and assessment being completed after 31st of March 21. And that assessment could not be valid in the light of the fact that there is no savings clause. Lordships have already issued interim orders in identical matters at page 148. One such order is at page 148.
Now, what is the point?
The 148 notice is dated 30th of March 2021. 148 section was amended by way of substitution with effect from 1st of April 2021 by the Finance Act. And in the new section, there is no savings clause in respect of the proceedings arising out of 148 already issued under the old provisions. Therefore, in the absence of savings clause, the 148 under the old form does not survive. The only option open for making an assessment for the assessing officer was to issue a fresh show cause notice, fresh 148 notice. He could not have acted on the basis of the inexistent provision, that is section 148, issued prior to 31st of March 21.
Page, interim order at page?
Page 89, my lords.
No, the interim order.
144. 144, Lordship's judgment in another identical matter. This is also another very big batch, my lords.
The counsel for the petitioner would submit that notice issued on 30th March 2021 under 148 could not be continued subsequently in light of amended provision
Amending provision under of 148 by Finance Act 2021.
by Finance Act 2021. In light of the interim order passed by the coordinate bench in WP 13162 of 2023, there will be an interim order of stay of
K1, K2, K4, K5.
K1, K2, K4 and K5.
Lordship, it's not coordinate bench, my lordship. It's the lordship's court, own court. Not coordinate court.
That will be coordinate bench only.
Plus.
Yes. Learned counsel Tirumalesh accepts notice for the respondents. I sit in different benches on different dates.
My lords.
Yes.
30,
Obligations.
30 Pratim.
Yes.
Lordship, I have challenged the order of the appellate authority in this petition, Lordship. Demands are the three.
Tribunal is not constituted, is deposited 30%.
And I have paid, Lordship. I just.
Unique.
In light of non-constitutional tribunal, petition requires to entertain, and as it is submitted, that 30% has been paid.
Yes.
30%.
40% of the tax amount.
Tax amount.
Tax. 40% are paid, 40%.
40%.
40%. In fact, as per the GST Council recommendation, it has to be not 20% only, Lordship.
40% of the demand has been paid. There would be stay of the impugned order in appeal. Learned counsel Shaman Naik accepts fees for the
respondents.
Annexure M and N, Lordship, coercive notices, bank attachment notices are there. Annexure M and N, Lordship.
Further, there would be an interim order of stay of consequent proceedings at annexure
M and N, Lordship.
M and N.
Interim prayer is only for A.
Correct.
But
attachment. Yes.
31, Karthik.
Appeal for petitioner, my lords. Lords, there's urgency in this matter, my lords. 24th June was the last date for payment of examination fees without penalty, my lords. The petitioner institution had made a representation, my lords, on 5th June, requesting them to appear to allow them to make payment of examination in government industry ITI in Mandya, and also to appear for practical examination in Mandya. My lords, theory examinations are held in Mandya, my lords. Practical examinations, for that, what happens is every year, this institution got affiliation in 2010, my lords. In 2000, it's existing since 2008, my lords. What happened in 2019, July 2019, they'll shift from Shumaga to Mandya, my lords. And then after shifting, my lords, 18 September 2019, respondent number 2 issues a shifting rule, implementation of shifting rule. In that, it says that the shifting of the institution has to be done in rural areas within the block, and if it is in urban areas, it has to be shifted within the municipal corporation limits. But the petitioner institution had already shifted in July 2008.
So when was this? Was a circular or a rule?
My lords, it was a rule, my lords. It is at annexure C, my lords.
Page?
Page 32, my lords. The 6th meeting of recommendation committee meeting dealing with affiliations of ITs.
Now, this is 18th of September 2019.
Yes, my lords. Annexure C, page number 32, my lords.
Correct. Now, your shifting was done earlier to this or later?
Earlier, my lords. July 2019, we had shifted, my lords.
Permission was obtained?
No, my lords. It was for re-affiliation. Affiliation was granted in the year 2010 itself. Okay. For then we were asked to file an application, my lords. For every 5 years, we'll have to file an application for re-affiliation. So 30th January 2020, we move an application, my lord.
No, but for shifting, you have taken permission, is it?
For shifting, my lords. For shifting, we shifted because there was a less number of students, my lords, less number of admissions.
Is permission required for shifting?
My lords, it is permitted, my lords. Even before the shifting rule came, many institutions were permitted to shift. For example, before
Filed for affiliation.
yes, my lords. No, for re-affiliation.
When did you file that?
30th January 2020, my lords. Annexure D. Many institutions are granted, my lords, were granted re-affiliation even though they shifted from one district to another district. In fact, three institutions in Rajasthan.
That may be so now. It's a matter of law, isn't it?
Yes, my lord. Then what happened, my lords? They carried out an inspection, my lords. Annexure 9th October 2020, they carried out an Annexure E, my lords, page number 38. They carried out an inspection, my lords, and they were satisfied that all the infrastructure was existing as per norms. Thereafter, my lords, they reject the application saying that they have less than 4 trades. Less than 4 trades, my lords. But then subsequently, respondent number 2 itself clarifies that since it is an existing institution, it can operate if there are 3 trades also.
My lords, challenging that order, they have preferred an appeal, my lords. In that appeal, kindly see.
Lords, if I may be permitted to complete. Then, my lords, then what happens? They clarify that for the existing institutions, if there are 3 trades, it is they can operate. So thereafter, my lords, in the year 2021, so pending the release of re-affiliation, all tickets are generated, my lords. Respondent number 3 and 4 permit the trainees and students of the Petitioner Institute to appear for practical examination in Mandya itself, where the petitioner institution is located and the students have taken their course and where they are residents, my lords. Annexure H, my lords, 47, page number 47 to 50, my lords. All tickets are generated at Mandya itself, my lords. And they are allowed to appear for practical examinations in Mandya. Thereafter, my lords, Annexure L, my lords. Once again, the petitioner rejects the institution's application for re-affiliation on the basis of shifting rule, my lords. Thereafter, we file an interim order, writ petition, my lords, before this honorable court in the year 2022, my lords, wherein the respondents in the said writ petition were directed to conduct the examination in the government ITA, my lords. They were permitted to appear. In 2022, again they take up this matter and all tickets are generated and they were asked to appear in Shumaga, my lords, where the institution had earlier affiliation. Earlier address was in Shumaga. Say all tickets were generated and the trainees were instructed to appear for examination centers in Shumaga. Thereafter, the petitioner institution files a writ petition and this honorable court permits them to appear in government ITA in Mandya itself. Then thereafter, my lords.
Through interim orders, if you finish the course, what is the logic?
My lords, this honorable court permits them to impart the course for students in 2023-24. Admissions were allowed, subject to the outcome of this.
What happened to that writ?
My lords, Annexure P, my lords, page number 70. Was issued, my lords. Respondent number 2.
No, what has happened finally in those writs?
Page number 82, my lords. 82, in writ petition number 18850 of 22, my lords. Page number 82, the order is as follows, my lords. This writ petition is disposed of. The respondent number 2 is directed to consider the application of the petitioner is in accordance with the norms of NCVT and pass appropriate orders within a period of 15 days from the date of receipt of copy of this order. Further liberty is reserved for the petitioner to submit additional documents if required by respondent number 2.
No. What about the shifting? The shifting rule was referred to in this writ? No.
Yes, my lords. It was brought in, my lords.
That is the reason they have applied, my lords. So they have re-applied after passing of this honorable direction, my lord, court direction.
It permitted to impart the
But
course, my lord.
they have not pay the affiliation fees, my lord. We have informed the petitioner also to pay the affiliation fees. Then we'll conduct the inspection, my lord.
At 83, my lords, Annexure V, my lords, 29 February 2024, the principal of the government IT conducts inspection, my lords. And then it is found that they have all the infrastructure as per norms, my lords. So it is due to the respondent number 2's, they are not granting re-affiliation. This difficulty is faced by the students, my lords. 80 students are there, 80 trainees.
It's permissible.
My lords?
Whether it's permissible.
My lords,
It's not permissible. It's not permissible.
my lords, they had to pass, the order was passed on 27th November, my lords, 2023. But then they didn't pass, my lord, they just kept it and we are made to suffer, my lords.
No. I'm saying, is it permissible to shift or no? That's the question. It's
Yes,
not
my lords.
permissible.
In fact, 28th
Permissible.
annexure X, my lords, page number 86 to 87.
No.
This institution, my lords, it was located in Bangalore. Then later on, it got shifted to Kolar, my lords. They are granted re-affiliation.
Can't claim negative equality. Now the question is whether it's permissible to shift or no. Central government has issued notification, it's not permissible to shift. How do you get over this?
My lords,
To be in the municipal block
my lords,
or in the rural block?
my lords,
How do you get over
my lord,
this?
the shifting rule came into operation on 18 September 2019, my lords.
You have applied for re-affiliation only later.
Lord, that is for re-affiliation, my lords.
Correct.
But we had already shifted, and from 2019, they are aware of all respondent number 3 and 4. They are well aware, my lords. And in fact, respondent number 3 and 4 applications to respondent number 2 to issue release of re-affiliation. Since 2019, this is going on, my lords.
No, at least you should have obtained, you would have ended the matter. What do you say? Now, after they shifted to Mandya, the first exam was held in which year?
21, my lords. 2021, we didn't file any writ petition, my lords. The respondent number 3 and 4 voluntarily allowed us to appear in Mandya itself.
Then now, how are you going to handle this mess now?
My lords, this 2022, again they.
Yes, madam, what is to be done? Now, at some point of time, they have allowed them after 3 years to.
Through
otherwise,
interim order of this honorable court, we are allowed, my lords. Otherwise.
Otherwise, can it not be treated as fresh affiliation at Mandya?
Yes, my lords,
And
we
then
are.
you evaluate it freshly.
Please,
If
my
it is competent and it meets all the regulations,
Please, my lords.
then you can give recognition in Mandya itself.
Yes, my lords, we are also issued them note. This is the circular, my lord. To pay the fees, they have applied for the affiliation, my lord, but they have not. Yes, my lord, sir, but they have not paid the fees, my lord.
Just read this.
ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ಆದೇಶದ ಮೇರೆಗೆ ಸ್ಥಳಾಂತರಗೊಂಡಿರುವ ಕೈಗಾರಿಕಾ ತರಬೇತಿ ಸಂಸ್ಥೆಗಳು SCITE ಮರು ಸಂಯೋಜನೆಗಾಗಿ DGT ನವದೆಹಲಿಯವರ ಆನ್ಲೈನ್ ನೋಟ್ರಿ ಪೋರ್ಟಲ್ನಲ್ಲಿ ಮರು ಸಂಯೋಜನೆ ಪಡೆಯುವ ಅರ್ಜಿ ಸಲ್ಲಿಸುವ ಸಂಸ್ಥೆಗಳ ಸಂಯೋಜನಾ ಶುಲ್ಕ ಪಾವತಿಸುವ ಬಗ್ಗೆ ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಉಲ್ಲೇಖ ಸೋನ್ಸೋ ಪತ್ರದಲ್ಲಿ ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ಬೆಂಗಳೂರು ಇಲ್ಲಿ ದಾಖಲಾಗಿರುವ WP ನಂಬರ್ 1775/22 ಗ್ಲೋಬ್ ಅಂಡ್ ಅದರ್ ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್ಸ್ ದಾವೆಗಳ ಸಂಬಂಧ ದಿನಾಂಕ 26/6/23 ಮಧ್ಯಂತರ ಆದೇಶದಂತೆ ಕ್ರಮವಹಿಸಿದ ಸ್ಥಳಾಂತರಗೊಂಡಿರುವ ಕೈಗಾರಿಕಾ ತರಬೇತಿ ಸಂಸ್ಥೆಗಳು DGT.
Now we'll direct them to pay the.
Please, my lord.
But eventually.
Thereafter, the DGT will look into the matter, my lord. They will conduct the inspection.
Correct, but then you have to treat it as a fresh affiliation.
Please, my lord.
Lord, page number 63, my lord.
For the time being, you pay the affiliation fee. Pay the affiliation fee and follow the procedure that they have called upon you by notice of 15/5/2024. We'll see.
My lord,
Find out.
my lord, sir, pending release of re-affiliation, my lord, students may be permitted.
No, I will permit you, you pay this amount.
Yes, my lord.
Find out.
One minute, my lord.
Last date was,
my lords, 2020 itself, they have paid, my lords. 2020, when they filed the application initially, my lords, that time itself, they have paid, my lords.
What happened to that application?
That was rejected, my lords, on the
Then
shifting
there-
rule.
Then there it goes.
On the shifting rule, it got rejected, my lords. But this honorable court had disposed saying within 15 days, you will have to consider after that they've not passed any order. To consider with 27th November 2023, my lords, this honorable court asked them to consider and pass appropriate orders, but they have not passed any order. After that, 29th February 2024, the principal of government IT conducts inspection and is satisfied that the infrastructure are existing as per norms.
After the writ petition.
After, yes, my lords, 29th, actually within 15 days, they had to pass order, my lords. They come in 29th February 2024.
Where is that order?
My lords, at annexure N, my lords.
Page?
Page 82, my lords. 82, my lords, annexure T. My lords.
For that application, you had paid the fee.
Yes, my lords.
After this, what happened?
After this, 29th February to 24, my lords, so the principal comes. The principal of the government ITA conducts inspection. My lords.
And what does the report say?
Read out, my lords. Page 83, my lords. ಯಂತ್ರೋಪ ಪ್ರಕರಣಗಳು ಹಾಗೂ ಇತರ ಸಾಮಗ್ರಿಗಳು ಶೇಕಡ 95 ಅಷ್ಟು ಯಂತ್ರೋಪಕರಣಗಳು arose, my lords. They did not comply with the order, my lord.
Let us see. We'll see. In education matters, interim orders, we'll see. That's all. All through interim orders, you complete the course. Matters are not disposed of. The petitioner submits that pursuant to the order passed in WP 18850 of 2022. In the case of the petitioner, there was a direction to consider application of the petitioners in accordance with the norms of NCVT and pass appropriate orders. It's further submitted that in terms of annexure V, inspection has been conducted and the report would reveal that the petitioner has complied with the requirements.
Yes.
Full stop. However, it is submitted that no order as yet has been passed pursuant to the direction in WP 18850 of 2022. Full stop. Accordingly, subject to further consideration, what is the interim order?
Page number, interim order, my lords. Interim order is for direction of respondents to permit the trainees of the petitioner institution to make payment of examination in government ITM India and to appear for practical examination in government ITM India, my lords.
Accordingly,
Page number 100, my lord.
the prayer in IA 1 of 24 requires to be considered. And respondent 3 and 4 are to permit the petitioner's institutions to pay examination fee and on its acceptance, permit them to appear for the practical examination in the Government Industrial Training Institute at Mandya as sought for with respect to the schedule of CTS main examination for the session 22-24 scheduled to commence from 30th June 2024 to and to go on till 27th August 2024. Copy of the order to be furnished to AGA for necessary communication as well. No, but I'm saying in these education matters, through interim orders, exams are done and results are announced. In matter keeps pending till the very end. Now you are at Mandya.
Yes,
and
ma'am.
what has happened Now, now you can at least ask the court you're going to get. How in doubt if a fresh affiliate, whatever's happened, you can ask for protection. Yes.
Grateful.
32. Parsarathy.
Please, Your Lordship. These are repetitions challenging the notices issued under section 153C of the Income Tax Act. These notices were issued on 30th March 2024. But I have been a regular assessee. My earlier assessments have been concluded. Taxes have been paid and there is a finality to all those years. Now, suddenly I get these notices on 30th March 2024. I point out to the income tax officer that you have no jurisdiction to issue these notices because there is no satisfaction note recorded by you. We don't know what is the date of search, which party was searched, when was the material handed over to you, which were collected in that search, because that is the date on which you get jurisdiction. All those things we asked by 2 elaborate letters, absolutely no reply, stony silence from his side. Suddenly I get a letter from the income tax department saying that my assessments have been centralized, transferred to the central circle. And for the first time in that letter, they refer to a search which was conducted on 23rd of March 2021 under section 132 in 3 parties cases. But my case appears to be a fallout of that they have not so far told me what exactly has been collected by them and all that. Now they want me to file returns of income for 6 assessment years. 7 assessment years. But my first submission is
now that incriminatory material has not been
punished. Nothing. I know nothing. No satisfaction note is shown to me, no incriminating materials. I don't even know when the date on which those incriminating materials were handed over to my assessing officer. But section 153C, subsection 3, which was brought into the Act by the Finance Act 2021, says the provisions of 153C will cease to operate wherever there is a search which is conducted on or after 1st of April 2021. But in the case of 153C, the section deems that the date of handing over of the seized materials by the assessing officer who conducted the search to my assessing officer will be deemed to be the date of search. But 23rd March 2021 is the date of search in those 3 parties. Now, when that material was handed over to my officer is not so far told to me. Now, unless those materials have been transferred to my assessing officer on or before 31st March 2021, no notices can be issued to me. No, notices are without jurisdiction. But they want me to file the returns by 28th of June.
A letter seeking for incriminating and satisfaction note, my lords, I'll get instruction with regard.
No, I am saying that
just
so far as my lords, the search is before 2021. My lords, if the handing over is, my lords, before 1/4/2021, my lords, the notice under 153C is still valid.
Correct. That's on 1. 2, what is the incriminatory material? That should be put forth to him also. And if there's no incriminatory material, it goes. Isn't it? You take it, find it.
Well, the notices have to be stayed.
Yes. And senior counsel appearing for the petitioner submits that
So far as handing over, my lords, date of handing over, my lords, in the statute, the provision still remains, my lords, it's not been omitted.
No, that is there. If it's handed over with cut-off date, then on jurisdiction point is taken care of. On merits also you'll have to satisfy. Let us, senior counsel appearing for the petitioner submits that petitioner has not been made known of the incriminating material which may have been collected in the search on 23/3/2021. If such material is put forth to the petitioner, question of filing returns doesn't arise.
If it is handing over is after the
Correct.
1st of April, handing over filing of returns doesn't arise.
Other contentions have also been raised. relating to the jurisdiction to issue notice in light of the requirement that incriminatory material ought to have been handed over to the jurisdictional officer before 31/3/2021, with respect to which respondent ought to take its stand. Subject to further, the matter requires consideration. Subject to further consideration, there will be an interim order of stay of
A to A6. Annexure A to A6.
A to A6.
A6.
Learned Counsel Dilip accepts notice for the respondents.
Lordship may give a date,
So I'll get 3 weeks
16th,
after 3 weeks.
16th or 17th July.
So let them file their statement of objection. Let them complete their pleadings. Now that you have got an interim order, let them complete their pleadings and then you move it. Statement of objections to be filed within 3 weeks.
3 weeks.
Lordship may fix a date.
4 weeks.
It will be better.
After 4 weeks.
You move it as soon as they file their statement. As soon as they file, 4 weeks I have said, so you move it after 4 weeks.
Great.
Yes.
Great. Will do.
33. Yes.
Grateful.
33.
Yes.
My lord, yeah, the petitioner challenged 148 AB notice, 148 AD order, and 148 notice, my lord, on multiple grounds, my lord. One of the issues that, my lord, the very same issue for the earlier assessment year, my lord. For the this is the present assessment year is 2021, my lord. The earlier assessment year 1920, please see the notice at page number 112 to 114, my lord. 112, my lord. Hundred and 12 is for earlier year, my lord. 1920, my lord, assessment year. The annexed portion, my lord, 113, para number 2, my lord. In your case, information has flagged of inside portal. As per risk management strategy formulated by CB. As per explanation 1 to 148 of the incurred expenditure on advertisement of rupees 10,26,840 is education institution, my lord. For advertisement expenditure, what they incurred 10 lakhs, they want to disallow. That is the income escapement of assessment that has been issued notice for the purpose of for the assessment year 1920, my lord. This honorable court stated that operation of that issue notice, page number 115, my lord. 115 and 116, my lord.
Now similar demand in the present case.
And the similar issue, my lord, at 148 AB, which is at page number 52, my lord, the present assessment year 2021, my lord.
Page?
Page 52, my lord. The 53 is the relevant para number 2, my lord, identical, my lord.
Advertisement.
Advertisement expenditure, that is the only issue, my lord. Apart from that, my lord, there are multiple issues, my lord.
That we'll see. That we'll see. Now, what has happened after this?
After this honorable court stated the operation of the notices, my lord. Matter is pending before this honorable court, my lord.
In the present case.
Present case, my lord. After this, they have passed the order under 148 AD, my lord, which is at page number 59, my lord. Then 148 notice is issued, which is at page number 62, my lord.
Now it is at that stage or then
only that stage, my lord. No further thing, my lord.
Let us, counsel for the petitioner submits that in the case of the very same SSC, as regards advertise expenditure on advertisement, regarding which reassessment proceedings was sought to be initiated. This court in WP 17757 of 2023 has granted an interim order of stay, and that in the present case, also 148 AB notice has been issued seeking for making the expenditure on advertisement as a subject matter of 148 proceedings. notice, 148 notice and proceedings thereafter. In light of the same, there have been interim order of stay of the 148 notice at annexure,
My lord, annexure A1 to A5, my lord.
annexure A1 to A5. And Counsel Shri Sushant Tiwari accepts notice for the respondents. List along with the WP number 17757 of 2023. Yes.
Please, my lord.
34.
My lord, in this matter, my lord, the petitioner challenged the same 148 AB notice and AD order and 148 notice on multiple grounds, my lord. The very same year, my lord, there is an assessment order passed, my lord. After reopening, there is an assessment order for the very same assessment year, my lord. Please see the assessment order, my lord, which is at page number 130 to 139, my lord. Page number 130, my lord. Recently, this assessment order is passed for the very same impugned assessment year 2017-18, my lord. At page number 130.
This is reassessment.
Yes, my lord. Reassessment order has been passed for the very same assessment year, my lord.
Now what are they doing now?
Now again they issued the one more 148 notice, my lord, for making one more assessment, saying that there is a cash deposit, which is already considered in this assessment order, my lord. Please see at page number.
But can there be twice? No bar.
Please see at page number 135, my lord. 135 down para 8, my lord. There's the assessment order reproduction. As per the information available within this office, the assessee made cash deposit for the period 1/4/2016 to 8/4/8/11/2016 amounting to rupees so and so in his bank account maintained with the Kotak Mahindra Bank. Further, during the demonetization.
This is the same amount mentioned in the 148 AB notice.
My lord, for the entire year, but actually, my lord, this has been explained. My lord, it is arising out of the cash sales that deposit has been made, my lord.
What I'm asking is.
Yes, my lord.
In the present 148 AB notice.
Yes, my lord.
Is this the same figures that again?
No, my lord, this is the cash deposit is other than the cash deposit, what is mentioned here, my lord. But however, my lord, they are considered the entire year has been considered and passed to the order, my lord. Then it amount to change of opinion, my lord. Again, issuing a fresh notice, it amount to change of opinion. That is one of the ground, my lord. Apart from that, my lord, this notice was issued by the jurisdictional assessing officer, my lord, not by the faceless, my lord. Then, my lord, there is a copy of approval has been not granted, my lord. In this case also, this.
What that you have to get it determined at the earliest. Let us see. In light of the contention that no, but now these items were not a subject matter of the reassessment proceedings. Where is the bar to revisit it now?
No, my lord, here, the original assessment itself, they are considered everything and passed on order, my lord, because the information in their possession, my lord, for the entire financial year, that's what they mentioned in the assessment order, my lord. Please see the assessment order, page number 136, my lord.
Correct, but in the assessment proceedings, unless these items of cash deposit, which now they have raised under 148 AB notice.
But 148 AB notice, that information is totally wrong, my lord. That is not at all the cash deposit, my lord. Please see the 148 AB notice, my lord. They are referring to 3.16 crores, which is already included in the assessment order, my lord. At page number 69, my lord.
Yes, 3.13.
3.13, actually there is no cash deposit of 3.13 crores at all. They are not given me the information. How did they get it, my lord? Which they are supposed to give information as per the guidelines for issuing 148 notice. Along with the notice, they have to give me the source of information also, my lord. 3.13 crores, my lord. But my actual cash deposits are, my lord, which I have put it in my writ petition. At the page number 49, my lord.
No, but they say at para 3 at page 73, information is brought out above is from Kotak Mahindra Bank. Account number they mentioned, page 73, para 3.
Yes, my lord.
They are claiming.
Yes, my lord.
It's Kotak Bank account number also they mention.
Yes, my lord, that account number they have mentioned, my lord. But so much of cash deposit is not there in that account, my lord. That's what I explained to them, my lord, which is at page number, my
74.
Yes, my lord. 74 is my reply, my lord. Please see, my lord, 76 para 5, my lord.
Yes.
Fourthly, it is submitted that the assessment proceeding have been completed in our case for the assessment year 17-18 wide order dated so and so. In the assessment order, income has been assessed at so and so by making an addition of so and so as an unexplained money under section 69A of that. In the assessment order so positive, the cash deposit during the demonetization period was 37,18,530. Then, my lord, para 7, my lord, now we have received the aforesaid notice 148 AB dated. Your honor has mentioned that we have made cash deposit to the tune of 3.13 crore in the bank account. It is submitted that the extent of cash deposit in the bank account is not 3.13 crore, but only sum of rupees 2.84 crore as shown above. These cash deposits are from out of turnover of the business trading in rice, broken rice, ragi and other food grains. And the same are
2.84 crores has been
2.84 has been already declared in my sales returns, my lord, which is already taxed, my lord. Again, they are making that cash deposit one more time addition, my
Let
lord.
us see you take your stand in writing. Lord Counsel appearing for the petitioner submits that the cash deposits referred to in the 148 AB notice is incorrect as made out in the reply dated 12/4/24, and accordingly the proceedings and order under 148 AD requires to be set aside. Subject to further consideration, there would be stay of
Annexure A1 to A4, my lord.
A1 to A4. Respondents to make out their statement of objections within 3 weeks.
Much obliged.
They are at liberty to seek for modification of the interim order upon completing their instructions. IA 1 of 24 is allowed and petitioner is dispensed with furnishing of original copy as mentioned in the application.
35. Sayed.
Appear for the petitioner.
Just 1 minute. Just ಅದು IA ಆರ್ಡರ್ ಮಾಡಿದ್ನಲ್ಲ ಅದು 33 ನಲ್ಲಿ ಆಯ್ತಾ ಇವಾಗ IA ಹೇಳಿದ್ನಲ್ಲ ಅದು 33 ಮಾಡು 34 ಅಲ್ಲಿ petitioners IA is allowed, petitioner is permitted, dispensed with production of original/certified copy of annexures A1 to A4 as sought for.
35.
For the petitioner, my lord.
Yes.
We are challenging annexure A order, my lord, on the sole ground that the order was passed stating that there is a mismatch in GSTR 3B and 2A. That is the sole ground that they have used to reject, my lord. My lord, this court in numerous matters has stayed proceedings like this because the broader aspect of this is pending.
What is it?
Also,
Assistant Commissioner of Commercial Taxes. 3B and 2A?
mismatch, my lord.
Mismatch.
Yes, my lord. Assessment year 18-19, my lord.
There is some relief by virtue of Lord Counsel for the petitioner submits that so then we'll consider this interim prayer. What is the interim prayer seeking? in light of the submission made and taking note that there have been certain recommendations the GST Council which may have a bearing on the subject matter of the present petition. There would be an interim order of stay of
Annexure A, my lord.
Annexure
A.
Annexure A till the next date. Learned Counsel M. Kumar accepts notice for the respondent. Relist the matter week after next.
My lord,
Copies to be served.
I'll serve. Lord, A and subsequent proceedings.
Annexure A and proceedings pursuant thereto. Yes.
36, sir.
Obliged.
Prashant, 36.
Yes.
My prayer, your lordship, at page 76, your lordship.
Who appears?
This is for the
Additional Director.
central tax, your lordship.
Commissioner of Central Tax. Learned Counsel G1 accepts notice for the respondents. Yes.
I'll just take 2-3 minutes only, your lordship. But also see my prayer.
Yes.
The challenge, your lordship, is to the show cause at Annexure A. Prayer B, your lordship, to issue an order or a direction in the nature of mandamus holding that the amount paid as compensation by the LSP, lending service providers, to the petitioner is in the form of liquidated damages and is not taxable under the provisions of the CGST Act in terms of circular number so and so. What happens, your lordship? We are an NBFC, your lordship. So we give loans, your lordship, to various companies, various individuals who wants to take loans depending upon what they want. Maybe 2 lakhs, 3 lakhs, 5 lakhs, etc. Now this is done through the apps. So there are fintech companies, your lordship, who have apps through which the borrowers can apply for. Now these fintech companies, your lordship, will do a credit worthiness check of these borrowers, whether they can afford to repay, etc. Your lordship. That is one thing which they do. And for that, your lordship, they charge us service charges on which they are supposed to pay the service tax, that is the GST that is paid. Now sometimes, your lordship, there is a default by the borrowers. Now, if there is a default by the borrowers, your lordship, I suffer a loss because I will not get that money back. So the fintech companies, your lordship, there is an arrangement by which some portion of this loss is compensated by them. So suppose 5%, there's some percentage agreed, your lordship, about 5% of the loss is compensated. That's all what happens. Now the department wants to demand GST on this amount, which is collected by me or received by me as a compensation, on the ground that there is an obligation for me to tolerate an act, and therefore this is taxable. According to us, your lordship, these disputes came up. There is a circular issued by the government on this point explaining what exactly would be covered as a toleration to act. But also kindly have a look at that circular, one paragraph in the circular. Page 277, your lordship. After I point out the circular, your lordship, in my reply to the 01A, he refers to the circular, refers to all the paragraphs other than the paragraph, your lordship, where the answer is given. My lords will kindly see page 275. Circular dated 3/8/2022. My lords have it, your lordship.
Yes.
Para 2, your lordship. Agreeing to the obligation to refrain from an act or tolerate an act or a situation or to do an act has been specifically declared to be a supply of service in para 5E of Schedule 2 of CGST Act, if the same constitutes a supply within the meaning of the Act. We'll also see para B, agreeing to the obligation to tolerate an act or a situation. This would include activities such as a shopkeeper allowing a hawker to operate from a common payment in front of his shop against a monthly payment by the hawker, or an RWA tolerating the use of loudspeakers for early morning prayers by a school located in the colony, subject to the school paying an agreed amount to the RWA as compensation. Para 3, your lordship. The description agreeing to the obligation to refrain from an act or to tolerate an act was intended to cover services such as described above. However, over the years, Doubts have persisted regarding various transactions being classified under the said description. My lords can come to page 276, your lordship, on the top, para 3.1. Some of the important examples of such cases are service tax GST demands on 1, your lordship, liquidated damages paid for breach of contract. My lords can come directly, your lordship, to para 7, your lordship. Para 6.1 and para 7. Para 6.1. A perusal of the entry at serial 5E would reveal that it comprises the aforementioned 3 different sets of
If you don't mind, can we continue at 2:30?
With my lord's permission, may I mention serial number 88 on today's board by lords?
Yes.
That matter is covered by bundle technologies passed by my lords in this about illegal recovery of money during the investigation of GST Act. Lordship, this is at 88. My request is to keep it high on board on any day convenient to my lords. I will be coming from outside Bangalore. Whatever date convenient, high on board, my lords. Today it may not reach. That's what I was told.
Today it will definitely not reach.
Precisely. That's why my serious request, my lord. Honest request.
But you can do it online only. I'll try. I'll give a date. I'll have to
Please, my lord.
restructure the cause list method because old
My lord.
matters are not reached. Let us see. You
Yes,
file
my
a
lord.
memo. If it, according to you, it is covered, is it?
My lord, yes, bundle technologies. Memo is already filed. Mr. Sandeep Ring appears personally there.
No, it's good. So it
He has
doesn't
filed a
require
memo.
much hearing.
In my opinion, yes, my lord. The replies are filed. The rejoinder is filed.
List the matter. List the matter in the odd 3rd of July. Orders list on 3rd of July.
Obliged, my lords.
With your lordships kindly, my lords. Your lordships kindly, serial number 53 and 60, your lordship may kindly have it at 3rd, my lords. 53 and 60.
53 and
53 and 60, my lords.
60. We'll be Sanmati. Sanmati is there?
Because penalties are getting hampered. Let there not be any penal proceedings.
49 interim order earlier granted is extended till the next date. 49 is an interim order.
With my lord's kindly. Serial number 92.
Yes.
Not that school pathway matter not wherein a private property not they are requesting not for a pathway. I have filed my objection. It could be taken up not during next week, not 3rd of July. I am for the respondent.
You will inform the petitioner.
I shall not. He is outside.
We'll have it on Monday.
Monday, please.
Monday, 1st of July.
My objection, I'll file it in the petition.
1st of July.
Please.
Matter 10th.
Continue. Right? Continue. Preliminary hearing hours money 2:30. Yes.
36. Prashant.
Easy.
As I was submitting, your lordship, this, suppose one of the borrowers, your lordship, default, then there is a loss which is occurred to the NBFC. So therefore, your lordship, certain amount, your lordship, is received from the fintech companies who originally, your lordship, did all the KYC of the particular borrower, etc. Therefore, compensation is received or loss received. The question, your lordship, is whether this is liable to be subjected to GST under the category of agreeing to an obligation to tolerate an act. Now, this particular category, your lordship, was there in the service tax law, carried forward to the GST. A number of issues were being raked up, like bond. Suppose the employee goes off, your lordship, then there is a bond that happens. So we have to repay the amount in terms of the bond. So a number of situations came to be seen. So they started investigations, your lordship, against a number of companies on each one of the issues. Then the circular came to be issued. My lords, will kindly have a look at the circular. Page 276, your lordship. Starts at 275.
Yes.
276, your lordship, para 6.1. There's two paragraphs I'll read, your lordship. The perusal of the entry at 5E of Schedule 2 would reveal that it comprises the aforementioned three different sets of activities, namely the obligation to refrain from an act, obligation to tolerate an act or a situation, and obligation to do an act. They want to cover us under B, your lordship. Obligation to tolerate an act or a situation. That is, this amount which we receive, according to them, is a consideration which we receive for tolerating the act of a default by the borrower. Even the fintech companies also, your lordship, would not know whether the borrower default at all or not. So in spite of it, your lordship, they say, no, it is a consideration you receive for tolerating an act of default by the borrower. That's the case. You'll also kindly see, all the three activities must be under an agreement or a contract to fall within the ambit of the said entry. In other words, one of the parties to such agreement contract, the first party, must be under a contractual obligation to either refrain from an act or to tolerate an act or a situation or to do an act. Further, some consideration must flow in return from the other party to this contract agreement to the first party for such refraining, tolerating, doing. Such contractual arrangement must be an independent arrangement in its own right. Such arrangement or agreement can take the form of an independent standalone contract or form part of another contract. Thus, a person, the first person, can be said to be making a supply by way of refraining from doing something or tolerating some act or a situation to another person if the first person was under an obligation to do so and then performed accordingly. Para 7, this is where, your lordship, they clarify. There has to be an express or implied agreement, oral or written, to do or to obtain from doing something is payment of consideration for doing or abstaining from such an act for a taxable supply to exist. An agreement to do an act or abstain from doing an act or to tolerate an act or a situation cannot be imagined or presumed to exist just because there is a flow of money from one party to another, unless there is an express or implied promise by the recipient of money to agree to do or abstain from doing something in return for the money paid to him. It cannot be assumed that such payment was for doing an act or for refraining from an act or tolerating an act or a situation. Payments such as liquidated damages for breach of contract, penalties under the Mining Act for excess stock found with the mining company, forfeiture of salary or payment of amount as per the employment bond for leaving the employment before a minimum agreed position, penalty for check dishonor, etc., are not a consideration for tolerating an act or a situation. They are rather amounts recovered for not tolerating an act or a situation and to deter such acts. Such amounts are for preventing breach of contract or non-performance and are thus mere events in a contract. So why we put this condition, your lordship, is so that the fintech company also takes more care to ensure, your lordship, the creditworthiness of the borrowers. It is nobody's objective, your lordship, that he should default in making payment. The objective of giving a loan also, your lordship, is not with that purpose that he will default in making even one installment. That's the whole purpose. The amount which I recovered from the fintech companies are therefore, your lordship, amounts recovered for not tolerating an act or a situation and to deter such acts. Such amounts are for preventing breach of contract or non-performance and are thus mere events in a contract. Further, Such amounts, my lords will kindly note this sentence, do not constitute payment or a consideration for tolerating an act because there cannot be any contract for breach thereof or for holding more stock than permitted under the mining contract or for leaving the employment before the agreed minimum period or for doing something leading to the dishonor of a check. As already stated, unless payment has been made for an independent activity of tolerating an act under an independent arrangement entered into for such activity of tolerating an act, such payments will not constitute consideration and hence such activities will not constitute supply within the meaning of the act. Therefore, your lordship, bar submission, this circular covers our position completely because this is not, your lordship, a situation where there is an independent arrangement for collecting these amounts. These are all part of the same activity by which the amount is given as a loan to a borrower. There is an unforeseen circumstance, your lordship, that he will default. So the fintech company also, your lordship, would not have a situation that any customer to whom the loan is given will essentially default in making a payment. So these are all events, your lordship, that happens as part of the process. These, according to the circular, your lordship, are not to be considered as a consideration for any supply. Therefore, this para 7, your lordship, would cover us completely. We had a similar situation, your lordship. Where, your lordship, the case of Wipro, there was a difficulties, your lordship, in concluding the services that were there to the satisfaction. Therefore, to have a settlement, your lordship, certain amounts were received. They wanted to tax it under the same category of tolerating an act because after receiving the settlement, we'll continue to provide the services. We had argued, your lordship, based on this circular, and my lords have examined this circular. My lords will see para 3 and 4, your lordship. So and so canvases that those circular it is categorical that the payment of liquidated has not examined the question whether the payment by the petition in terms of the confidential settlement agreement would be liquidated damages in the backdrop of the settlement during the pendency of the suit, and so on. So submits that the 7th respondent has failed to consider that the primary services is not exigible to GST. The follow-up on such services would also not be exigible. 2 different points we had canvassed here. Prima facie, the aforesaid submissions demonstrate that 7 respondents' jurisdiction would be doubtful, and if the question of jurisdiction is raised, the petition could be well-founded. Hence, the respondents are directed not to take any precipitative action without the leave of this court, so also to complete their pleading search. And we pointed out this circular, your lordship, to the authority as a reply, your lordship, in 01A. All this, your lordship, the show cause which is issued, your lordship, refers to this circular, comes up to para 6.1, your lordship, and then stops at that. Doesn't go, your lordship, to para 7. At page 102, your lordship. The benefit, your lordship, to the trade after a circular gets issued is effectively lost, your lordship, if these circulars are not really adhered to. Also kindly see page 102, para 5.5. This circular is referred, and from page 103 to 104, my lords will see last portion of 103 and 104, your lordship, para 6.1 is referred. The conclusion that is drawn at para 7, your lordship, is for some reasons ignored. And then this demand is raised.
Yes.
Get instructions on this. I'm aware of the issue. Even in the erstwhile service tax also, this was the issue, my lord.
In light of the contention that the present transactions, if evaluated in terms of the circular number 178/10/2022-GST would not qualify as constituting consideration for supply of service. Matter requires consideration and accordingly there would be stay of.
Whether that could be
Action
a
A,
supply for service or not is the question. Yes, and promise not to, my lord, to tolerate an act, consideration to, my lord, received for tolerating an act. Whether that could fall under that category or not, my lord, that is what they are arguing is it is an promise not to tolerate. That consideration flows not to tolerate.
If evaluated in terms of the circular, service and accordingly would fall outside the ambit of taxability. Matter requires consideration. Accordingly, there would be stay of
Annexure A, your lordship.
Annexure A. Statement of objections to be filed within 3 weeks. This is the matter thereafter.
Grateful.
37.
Please, your lordship. Pay for the petitioner.
Yes.
Lord, petitioner number 1 is an association, society. Lord, petitioner number 2 is a school conducted by the first association. My lord, the school started operation in the year 1989 with 4 classes, that is first standard to 4th standard, that is a lower primary. My lord, over the period of time, now the school conducts kindergarten to 10th standard. Lord, over the years, my lord, the recognition was always renewed. Now, in 2012, the location was changed because, my lord, the earlier building was dilapidated. There was a threat to the safety of the students. So it was shifted to another location, which was very close by, about 300 to 400 meters from the old location. My lord, in 2012. Now, 2012 to 2023, my lord, again, inspections were conducted at the new location every year and it was renewed. The recognition was renewed every year. Now, in 2024, my lord, Annexure A, at page 15, I receive a letter saying that, my lord, my recognition is discontinued as the location is unauthorized. Right. There are about 400 students from kindergarten to 10th standard. Periodically, inspections are being done from 2012 when I changed the location. Till about a year back, my lord, it was renewed in the new location. And all the other conditions are complied with, including the fire safety norm certificate is produced. It's on record, no, my lord. And even the PWD has issued even the structural safety certificate. So all the other
when did you shift?
In 2012, my lord.
After that, recognition was.
Yes, yes, it was renewed. Every year it is being renewed, my lord. In fact, I have produced one at Annexure F, my lord, page 25. Annexure F. That first para, my lord, that is a new address that is provided in the first line, rather the second line. Modern Education Society, that is 58/2. That is a new location, my lord. So this is as way back to 2022, my lord. So for each year, my lord, we submit all the documents, all the compliances are also set right. Now in 2024, my lord, at Annexure A, I received this, April, I received this letter.
From 2012.
2012, yes.
Permissions and there was a renewal of recognition.
Yes, from 2012. So from 1989 onwards. 1989 was in the
after shifting.
After shifting also, yes, ma'am. So this is after shifting. I just produced one document at page 25. That is the new address.
Now in the other conditions are fulfilled.
All conditions are fulfilled. There is never a discrepancy or deficiency in satisfaction.
Now you find out whether at least ex post facto shifting permission can be granted.
My lord, in fact, within the department, my lord, there is a letter issued by the block education officer recommending a post facto permission also. I have produced that document too, my lord. But I don't think any steps have been taken on that. Lord, I produced that. That is at Annexure K, my lord. That's the last document at page 36. The block education officer himself has recommended for a post facto permission.
No, but it says there are some other documents you're required to furnish.
No, we have furnished all the documents. That is why in Annexure A, the impugned document, they don't talk about anything else. No other deficiencies or.
But at Annexure K,
Yes, Manoj. So
at
that
the-
everything has been complied with thereafter. So they don't take a decision on that.
let us see. We reserve liberty for the authority to consider if the requirements of Annexure K are fulfilled.
Yes.
In
Till
light
such
of-
time, let them not precipitate, Manoj.
In light of, that's what in education matters I was saying morning. Only thing is not to precipitate interim order.
No, the difficulty is 400 students, Manoj. That's all. Otherwise, we can always wait. But 400
The-
students from kindergarten to 10th standard.
In light of the contention of counsel for the petitioner, that though the college is shifted in the year 2012 and subsequent renewal of recognition has been made, impugned order has been passed at Annexure A only on 24/4/2024. Full stop. Reliance is also placed at Annexure K, wherein post facto approval for shifting is also under consideration, and it is submitted that the requirements have been fulfilled. And if there are any further requirements as referred to at Annexure K, same would be complied with. In light of the same, there would be stay of the order at Annexure A. The respondent number, BO is respondent number.
But I think the decision will have to be taken by 2, Manoj. 2 and 3.
The respondent number
That is
Three.
block education officer is 3.
3
3. Yes.
is
Two.
2 and 3 are also permitted to look into compliances specified at Annexure K and process the same without prejudice to order at Annexure A, which is pending consideration before this court. AG accepts notice for the respondents.
Publish. Grateful.
38.
For the petitioner's counsel. Matter relates to service tax on advocate
No.
covered by your lordship's.
Yes, yes.
Judgment.
There's no other income.
Lots.
There's no other income other than
We have
advocates.
prepared a memo because your lordships had insisted on that in the previous round. In fact, he had given a reply, they have not considered that. Order is passed, recovery notice issued.
Covered, my lords.
We'll dispose it.
No, it's coming up first time, my lords, actually.
Huh.
I appear for union because of advance notice, my lords. With GST also we intimated.
Huh.
My lords,
So we'll have it next week.
we went on to Fridays already.
Who appears?
I'll only appear, my lords.
Land counsel. Appears for respondents, one, all
All respond. Even GST, my lords.
Vishal Tiwari appears for respondents 1 to 7. Stated as the learned counsel, senior counsel appearing for petitioner submits, matter is covered. Accordingly, list the matter in preliminary hearing list on
Friday, my lords. This Friday, even next day, 8.
Friday.
Friday.
Friday, yes. Yes, 2 names, is it?
That's his actual name from college days, which we know. Not said. The enrollment is the same name, but he has cut short the name for the code. Lords,
Yes.
can it be in preliminary hearing? If it goes to B group, it may not reach.
No, preliminary hearing.
Lords, the interim order that they already issued a recovery notice is there at Annexure G.
In the subject to further consideration, there would be stay of
Annexure G, my lords, the recovery notice. Please.
39. 39.
I beg to appear virtually in this matter, Lordship. This is, petition is filed against the order of the Principal Commissioner passed under section 119 2B of the Income Tax Act.
just 1 minute. Yes, income tax. Principal Commissioner of Income Tax.
This one, then Raviraj.
Will
Ravi-
Commissioner of Income Tax.
Raviraj Dilip's.
Huh?
One is Raviraj and Dilip.
Ravi Raj and Dilip. Dilip is there? Yes, what is the matter?
Lordship, in this case, the petitioner filed return of income, and while the return of income was filed, the petitioner inadvertently offered higher income to tax. So in the year 2020, the petitioner purchased a Union of India bond for a face value of 10 lakh rupees. And on 30th of March 2022, the bond came to be mature for the face value of 10 lakh rupees with an interest of 91,000 rupees. Inadvertently, in the books of accounts, when the entry was being passed, the entire 10 lakh rupees of face value and 91,000 of interest, the entire 10 lakh 91,000 was considered as an income, so reported in the books, and return of income was filed. After the return of income was filed, the same came to be processed, intimation came to be issued under section 143(1). Later on, the petitioner realized this anomaly, that excess income has been offered, and the petitioner filed an application under section 109(2)(b) before the Principal Commissioner of Income Tax. Lordship will find it in Annexure D at page 52.
You wanted, that is, you have filed a revised return.
No, Lordship, we wanted the permission under section 119(2)(b) to file a revised return. And this, the Principal Commissioner order in Annexure F, page 59, our request under 119(2)(b) came to be rejected for the reason that we have not been able to establish a genuine hardship.
Yes. Let us,
Lordship will see the finding in page 61.
just 1 minute.
Yes.
So we'll, 119(2)(b), we have to consider only whether the rejection of the delay. So we'll have it next week. And Learned Counsel Dilip, is it?
I'll take it.
Sushant Tiwari accepts notice for the respondents. This is the matter. You are seeking for any interim relief?
No, Lordship. Okay, Lordship could take it in the next week and dispose of matters, not short issue.
Very well, madam. This is the matter in the preliminary hearing list, week after next date. 10th of July.
Obliged.
40, H.V. Manjula.
This case I am for the petitioner.
Yes.
May I request to come to the page 78.
Page?
The 78, running page. That is the operative portion of the impugned order. The third respondent, Assistant Commissioner of
Just one. Yes, GST.
GST. Demand.
Chief Commissioner of Central Taxes.
Yes.
Yes. Yes.
Confirm the order to pay a GST of rupees 24,43,418. The petitioner is an agriculturist. He is a plantation owner. He is growing a pepper. The third respondent came to the conclusion that the petitioner supplied the black pepper for a period from July 2017 to September 2022. July 2017 to September 2022. It is the specific case of the petitioner that he has not supplied the black pepper, he supplied the green pepper. He is an agriculturist, third parties. He processed it or converted it to a black pepper and sell it. May I just request to come to the annexure E. It is at page 95.
Yes,
Relevant page is 107, page 107.
yes.
May I just come to the last serial number 54.
Yes.
Services relating to cultivation of plants and rearing of all life forms of animals except of rearing of horses for food, fiber, fuel, raw material or other similar products or agriculture product produced by way of A. Agricultural operations directly related to production of any agricultural produce, including cultivation, harvesting, threshing, plant protection or testing, supply of farm labor. C is very important. Processes carried out at an agricultural farm, including tending, pruning, cutting, harvesting, drying, cleaning, trimming, sun drying, kindly mark it, sun drying, and fumigating, curing, sporting, grading, cooling, or bulk packaging, and such like operations which do not alter the essential characteristics of agriculture product, but make it only marketable for the primary market. So this is agricultural produce. Now may I just request to come to that.
Now the proceedings are under which act?
CGST Act.
Yes. You're saying it's exempt.
It is comes under the exemption clause. But he jumped into the conclusion that it's a black pepper and demanded for the GST.
Exam, because commercial crop is not included in Schedule 3, which exempts the supply of goods or services. Whatever is under Schedule 3, my lord, it is neither as a supply or a supply of goods nor a supply of services.
This
If there is
12
a
of,
separate exemption notification is there, my lord.
12 of 2017.
12, 25 by 12.
12 of 2017 GST.
File could you file? Nim copy could you?
Commercial crop, my lord,
Idರಲ್ಲಿ page 94 in the start act. Agricultural produce is 54.
Sun drying to make it marketable.
Next page C.
Can you see, my lord, the services relating to cultivation of plants and rearing of all life forms of animals except the rearing of horses, food, fiber, fuel, so and so. Agricultural operations directly related to production of any agricultural produce, including cultivation, harvesting, threshing, plant protection or testing. Yes, ma'am.
They're saying C.
C is the relevant.
Processes carried out at an agricultural farm, including tending, pruning, cutting, harvesting, drying, cleaning, trimming, yes, ma'am, which do not alter the essential characteristics of agricultural produce, but make it only marketable for the primary product. Please. Let's examine. What he, my lord, supplied is, my lord, that assumes importance, that rather than, my lord, all this.
I supplied green pepper.
Black pepper is there, my lord, I think it is a commercial commodity. Which,
In fact, he also admitted because.
Let us see.
Let him serve a copy, my
In
lord.
light of the contention raised. That what was,
ಏನಾಗಿದೆ ಈಗ ಆರ್ಡರ್ ಮಾಡಿದಾರೆ
that what was transacted.
Order in original ಆಗಿದೆ. Otherwise, it is an appealable order before, my lord, the joint commissioner appeals under the act. Some, my lord, for stay, my lord, some condition may kindly be imposed, my lord, but normally it is.
10% of the GST amount to be subject to payment of 10% of the GST amount.
10%.
Taxable amount.
There would be stay in light of the contentions raised. There would be stay subject to Payment of 10% of the tax demand. AG accepts notice. Learned.
24 lakhs 46,031.
Respondents. Yes.
Ma'am, serial number 68 is similar matter, same or
Same SSC.
same.
60.
68. Parties is brother of this petitioner.
68, same order. Office objections to be complied with.
Adeno needful is not done anta baradilla anta. That is the only office objection.
It is. Yes, next. No, but there's a difference between the process of sun drying
And mechanical process.
and the pepper itself.
Pepper. Yes, sir.
Let us see.
That's
Yes, let us. Yes.
41, Vikram.
May it please your lordship.
Yes.
Issue, my lord, is this. For the period April 2018 to
Just
March.
you appear.
Please.
Central Board of Indirect Taxes.
Please.
Then commercial of commercial
Yes.
taxes.
Happy for Indian members.
Now you appear for? Yes. 4 and then Council M. Kumar. Accepts notice for respondent 2, 4 to 8. Then R1, Sushal Tiwari for R1. Then what about 3? Even
CBIC.
accepts notice for third respondent. Yes.
Lord, the short point is this. For this period, April 18 to March 2019, I applied for refund under section 54 of GST. CGST. That refund was granted in annexure D series orders. And the refund was paid to me also. Now, the question that arises is, without impugning those refund orders, as known to law in appeal or in revision, whether you can invoke the provisions of section 73 on the premise that this is an erroneous refund. That is the only question that arises. Apart from that, I have raised limitation, calculations, etc. But this is a different issue. The main point, jurisdictional point is this. In my own case, if your lordship will see, on this very issue, annexure A is the petition I had filed in the Kerala High Court, and annexure B is the order of stay granted by the Kerala High Court also. There are 2 division bench judgments directly on the point, not on GST, but in excise. I'll show you lordship that.
So without appeal is 107, is it?
And 107 or revision under 110.
So without
108, I'm sorry.
So without 107 or 108.
Yes. Direct recourse to 73 on the basis of some audit objection.
73 is adjudication.
Adjudicate. That is, no, 73 is a notice issued claiming erroneous refund. The refund
Erroneous?
can become erroneous.
Erroneous?
Refund. If a refund is granted pursuant to adjudication orders, the refund can become erroneous only if it is subject to appeal and corrected. Otherwise, it cannot become an erroneous refund. Direct recourse, that is the only point. If your lordship will see, at page 73 is the order of stay granted by the Kerala High Court in my own case. Direct judgment.
Yes. It is.
Some matters are already pending before my lords. Similar matters are already pending before my lords.
So what is the interim relief you are seeking?
Stay of annexure K order. That is order passed. In fact, there he says, only reason given is application is not under 54. Your lordship will see annexure D order. It starts by saying 54. It doesn't deal with the issue at all. At page 210, your lordship can see the order.
Senior counsel appearing on behalf of the petitioners contends that the order passed under section 73(9).
Yes.
Adjudication, resorting to adjudication as regards refund earlier made is impermissible without the department having instituted proceedings of appeal under 107 or revision under 108.
108.
Matter requires consideration. Accordingly, there would be stay of the order at annexure K. For pleadings to be completed within 3 weeks.
Like.
42.
Anotherly, IA for 1 of 24 is allowed and petitioners dispense with production of original or certified copies of annexures named therein. Full stop. The petty IA 2 of 24 is also out. And petitioners dispense with production of enlarged typed copy of annexures H and K, subject to the undertaking that at the time of hearing, if so required, enlarged copies would be produced. Yes. The IAS.
In
42.
May I please?
Yes.
But this petition actually, my lord, a show cause notice issued by an assessing officer in Uttarakhand seeking to exercise jurisdiction over me by treating me as an assessee in default for a failure to collect tax at source when I sell alcoholic beverages. But under the Income Tax Act, any person who sells certain kind of goods is required to collect tax at source at the time of sale. Because I have, since the financial year 1920, centralized this collection of tax and tax deduction at source at my corporate office in Bangalore, which is permitted. I have one TAN number and I can collect and deduct tax at source under that TAN number for all transactions across the country. I did that. I did the collection in Bangalore, paid it over to the department. But suddenly in 2023, December of 23, an officer in Uttarakhand wakes up and says, no, you've sold in the state of Uttarakhand. You should have paid the tax in Uttarakhand, not in Bangalore. And he issues a show cause notice to me. But I point out to him that I have this option. I have done it centrally. How can you exercise jurisdiction over me? He still says that, no, there is a notification by the board that I exercise powers over companies which have the principal office or any other office within my jurisdiction, and therefore I'm entitled to deduct, act.
But now this process of deducting at Bangalore is permissible.
Yes. My lord, there is a circular of the board itself which says you can have one number, one tax account number. Now just see page 71.
Yes, sir.
Under section 2041, has my lord got that? Where salary is paid by a company, the person responsible for deducting tax at source under 192 is the company itself, including the principal officer thereof. The principal officer is defined under section 233 of the Act. In some cases, tax in respect of all the employees of the company is being deducted at source at the head office, and the return under section 206 is filed at a place where the head office is situated. In some other cases, the companies are discharging their responsibility partly through their branch office, requiring the company to file return with them, even where this is being filed with the assessing officer, where branch or head office is situated. It is clarified that where the head office or the branch office is already filing the return under section 206, no other assessing officer shall require the assessee to file such return with him. Where, however, the return of income is being filed, the officer having jurisdiction in terms of Rule 46A may proceed to enforce compliance to the provisions relating to deduction of tax at source from salary. Board Circular 719 states that where the head office or the branch office is already filing the return under section 206, no other officer shall require the assessee to file such return with him. Where, however, the return is not being filed, the assessing officer having jurisdiction in terms of Rule 36A may proceed so as to enforce compliance to the provisions relating to deduction of tax at source from salary. It has been decided to extend this procedure to all TDS returns filed under Rule 37 as required under section 206. So the whole object is, if you do it centrally, it's okay. Now, my lords, will just see section 120 of the Act also. Section 120 deals with jurisdiction.
My lord will see section 124 subsection 1.
Yes.
Whereby virtue of any direction or order issued under subsection 1 or subsection 2 or section 120, the officer has been vested with jurisdiction over any area within the limits of such area, he shall have jurisdiction in respect of any person carrying on a business or profession, if the place at which he carries on his business or profession is situated within the area, or where his business or profession is carried on in more places than one, if the principal place of his business or profession is situated within that area. So the entire emphasis is that where is your principal place of business? You should be assessed there. My principal place of business is Bangalore. My permanent account number is mapped to Bangalore. My tax account number is mapped to Bangalore.
So now you are seeking stay of?
Annexure H and K. Annexure K is at page 56. And annexure H is at page 41.
Yes. Consider you take instructions. Now, finally, the fact remains that TDS is being deducted.
Now
That Bangalore.
Petitioner claims that he's filing his returns, TDS returns in Bangalore. And now Dehradun has issued show cause notice.
No, correct.
Now-
So now the deduction of TDS as regards all business of all of their branches is being done here.
That's what
So
I.
as long as that is tallied, there is no prejudice.
So this is TCS, not TDS.
Huh?
TCS, tax collected at.
So
the concept is the same. Both are pay as you earn.
it's basically not salary, it is the sale on liquor, 1% that they have to.
In light of the contention raised by on behalf of the petitioner that by virtue of the circular at annexure
The circulars are at annexure
M.
the petitioner is entitled to deduct tax at source from salary of employees where the principal at the place of the principal office.
That's right.
And that in light of section 124 subclause 1, the jurisdiction of the assessing officer is also determined on the base of principal place of business. The proceedings initiated by respondent number
1.
Without jurisdiction. Full stop. In light of such contention raised, there would be stay of
annexure H and K.
Annexure H and K. Land Council Arvind Chavan accepts notice for the respondents. But he could have verified if it was in fact being deducted by his counterpart here. There, that would have ended it there, unless there's some competing
I
competition.
think, my lords, what each state has probably its quota. That is why he wants to.
Competition to fulfill quota.
My lords, but my lords have said tax deducted at source on salary. What we are concerned with is TCS, my lords. That circulars with regard to TDS on salary extended to other payments.
Vidya. The tax deducted at source for the TCS on salaries better.
TCS under section 206C.
TCS under section
206C, capital C.
Lost it. 206C.
Obligement.
Yes.
Education matter. A petitioner is running a education institute, B.Ed college in Karnataka. My institution was de-recognized on 2019. Subsequently, I had filed a writ petition and there was an order to consider my representation. And in 2020.
You appear for?
Bangalore Institute.
I appear for Bangalore University.
Now I've given a representation to the Bangalore University to consider my representation for affiliation and to write because earlier NCT was de-recognized my institution, my lord. Now by annexure C, they have recognized by their order dated annexure C, my lord, page 18.
But
Now
now,
it is-
now what is the stage of their application?
They have submitted an application, my lords. It is to be considered in accordance with section 59 of the Karnataka University Act. It is under consideration.
my lord,
My instructions are that, my lords, it is under consideration.
So I'll have it next week, find
no, my
out.
lord, the second is the exams, my lord. I have to write exams because earlier there was a direction, my lord, at page 17, my lord. I'll like
No, without affiliation, how you
No,
can?
we already submitted the applications. Applications we have submitted, my lord.
No, but will that suffice for you to?
Yes, my lord. Only the condition says that we have to fulfill the conditions, my lord.
No, no, correct. That they have to decide.
No, my lord, only it's not. It is a re-affiliation, my lord, not in refresh this one, my lord. Re-affiliation.
What the NCT has done is it is continued the.
You are
affiliation.
Can they continue?
Yes, my lord.
My lords, they have passed an order.
Huh?
The NCT is already passed an order continuing. Now we will have to consider the application in accordance with section 59.
Now NCT has passed order.
Yes, my
They have
lord.
passed order.
Where is that?
That's
Next
page 20, my lord. Sorry, my lord. Page 18, my lord. 18, annex to C. Which is at paragraph 15, my lord. That's page 20, my lord.
Yes.
Shall I read, my lord? And page 27, sorry, para 24 is the final. Now, therefore, order is in page, sorry, para 27. Now.
Now, after this, what is the procedure?
My lords, they'll have to file a representation to the Bangalore University. The Bangalore University will consider their representation for recognition based upon section 59 of KUA. There are certain provisions which steps which section 59 provides. We will have to follow those steps and then give them affiliation if those steps are fulfilled. That would also include issuing paper publication, visiting their premises. There's so many.
Okay, get instructions and submit.
Lord,
When do you want it?
Lord, second is the exams, my lord.
They've already taken a week's time.
Monday.
Second is the last date to file the examination fees. It is been extended, my lord.
The NCT.
Allah,
what it has
only
done,
thing
my
is, my
lord,
lord, we have.
in paragraph 27, page 22, they say that now therefore this order is issued permitting the institution so and so Karnataka for continuation of recognition of BA. This continuation, my lord, my instructions are, my lord, from the registrar that this continuation, whether it would come from 23-24 or 24-25, they will have to ascertain, my lord. We don't know from when it is continued.
Like it is for 23 and 24 only, my lord.
So the registrar wants to seek a clarification with respect to that and then submit.
I'll have it on Monday, you find out.
Lord, Monday will be, my lord. Let it be on Friday, my lord. Because second is the last date to miss. We have to accommodate the students, my lord. We already admitted 100 students.
No, but now, when was this NCT order passed?
13th June, my lord.
2020?
2024.
And the representation is given to us on 14th.
Then how within 1 week you can expect them to finish?
My lord, earlier there was an order, my lord. Earlier we had met party also, my lord.
Yeah, it's up to you. I'll have it on Friday.
Please.
Relist the matter on Friday. Land Council so and so undertakes to appear for the second respondent. AG accepts notice for the first respondent. Yes. No, within 1 week, can you expect them to complete the process? I don't know.
It's impossible, my lords.
I don't know. That you take your stand.
Yeah.
Please.
Two 30 matters. 94, Vivek.
Adjudication.
Yes.
I seek for a pass over, my lord. Senior on his legs.
Pass over, let us. Yes.
95. Ravi Raghavan, 95.
What are these matters?
Is your lordship on export of services, your lordship. In fact, my lordship will recall, there was a small chart I had given your lordship. All these writ petitions on the same issue, all the refunds, your lordship, have been rejected. On the ground, your lordship, that I am intermediary. I am an intermediary in the export of services. We had pointed out, your lordship, two things. One, there is a circular issue by the government explaining what is intermediary. And they give illustrations.
No, now who appears for the respondents?
I think two batches have been clubbed together. He will be appearing from 95.7. Hitachi Energy India Limited. 95.7 to 95.11 are different matters. Those matters are covered by my lord's judgment with regard to delay arising in filing of an appeal before the first appellate authority. Whether the physical presentation of the appeal has to be taken or the online filing has to be taken.
Correct.
The lords have taken the decision in the case of Hitachi. All these matters pertain to that matters.
Huh.
The other matters, my lord, central authorities are the main respondents.
Only respondents.
Now this 90, just 1 minute.
95.7 to 95.11.
Now 95 to 95.6 are a different batch, is it?
Yes, yes.
Different batch.
Yes, that is different.
Those are different batches. Maybe all this pertains to
Customer-
what my learned senior is mentioning, export of services or whatever.
Intermediary or export of service.
Correct. 95.7 to 95.11 is only on the ground of limitation. Okay, let us, that we'll see. So now 95 to 95.6.
95.1 to 95.
May my lord kindly grant me some more time. If I want to 95.6.
95 point?
There are different councils, my lord, I have just.
95 to 95.6.
First batch, that is 6 matters.
Let me explain, your lordship. Just, I'll take 2 minutes to explain why my lords had posted it today.
Yes.
The first of the writ petitions, your lordship, the stay order was passed on 31st March 23, your lordship. First, that is the, what is the first petition? 10315.
Yes.
13007, your lordship, was the first one. No. So the first stay order, your lordship, was passed on 31/3/2023. your lordship,
4580 and
saying that
615.
objections have to be filed. And thereafter, your lordship, on the same ground of intermediary, all the subsequent refund claims have been rejected. The total claims, your lordship, that has been rejected is about 55 crores. So no further refunds are granted, only because, your lordship, on the first matter, a view is taken, all subsequent matters, the same view is taken. So this is, our refunds, your lordship, are getting stuck. The other one, your lordship, is, one is the refund getting stuck. They are also creating your lordship, an outward liability. That is about 83 crores demand has been created. In this chart, your lordship, I've indicated both. It is our submission, your lordship, that on the merits of the matter, as I pointed out in the earlier matter also, your lordship, after representations being given to the board on how to clarify intermediary, because intermediary, your lordship, was there in the service tax law, it got carried forward in the GST law also. Therefore, since issues were being raised up, even on a principal to principal basis, suppose there are a transaction, and then that principal, your lordship, deals with somebody else, they were treating us to be an intermediary. So the board issued a very clear circular explaining who is an intermediary, how you should consider intermediary, and they give illustrations. On illustration 1 to be considered as intermediary, illustration 2 not to be considered as intermediary. And all the orders, Your Lordship, are orders passed by the first appellate authority. After we refer to the circular, circular is looked at. And then, as I said, Your Lordship, given a go by, and then these orders are passed. And all the orders, Your Lordship, refer to the circular, first appellate authority's order before my lords. Right, Your Lordship. So our submission, Your Lordship, is whether they file a counter, that is slightly different, Your Lordship, because these are all orders passed. We are not challenging the constitutional validity or any provision. Orders speak for themselves. So we will argue the matter, Your Lordship, based on the circulars and the decision. There are about 10 decisions, Your Lordship, of the high courts. Punjab Haryana High Court about 2 decisions, Delhi about 4-5 decisions, tribunal, Your Lordship, decisions, civil appeals dismissed by the Supreme Court on same issue of intermediary. Therefore, our submission, Your Lordship, is that as far as the merits are concerned, we will argue based on the circular, Your Lordship. Whatever stand they want to take, Your Lordship, let them take for my lords.
In all these cases, they have treated you as
Intermediate, absolutely.
So the refund orders have been
All
set
the
aside
refunds
in
of
appeal.
input tax credit, Your Lordship, has been rejected.
In appeal.
Yes, Your Lordship.
The factual matrix is similar.
Same agreement, Your Lordship. One agreement, I have an agreement with Amazon Ireland. Then I have an agreement with another company in Seattle. They in turn, Your Lordship, have an agreement with another Amazon entity who ultimately supplies goods or supplies services. So we don't have an agreement with the first entity. We have an agreement with the immediate entity. Now he is supposed to do all the customer related services, etc. He outsources to us. Therefore, whether in a situation like this, we should be considered as an intermediary. The circular clearly says that where the activity is outsourced and you're doing it on a principal basis to the entity to whom ultimately they are providing a service, you will not be considered as an intermediary. The circular completely covers us, Your Lordship. Therefore, I'll point out the circular, etc. Your Lordship.
Yes.
Lords can take the first writ petition 4580 of 2023. That will give a factual matrix. Page 10, Your Lordship. Page 9 and 10, Your Lordship.
Yes.
Page 9, Your Lordship. 2 paras I'll just read because that sets out the factual position, Your Lordship. Various Amazon Group companies incorporate different countries around the world, operate e-commerce marketplaces in the respective regions. These entities either sell goods directly to the end consumers or list the products of selling partners for sale to end customers. Some of these Amazon consumer entities engage other Amazon Group companies such as Amazon CS Ireland and AMZN WCS LLC USA, hereinafter referred to as foreign affiliation, for the provision of customer support services, including customer support services. Amazon ES Ireland Limited has its principal place of business in Ireland. The foreign affiliates in turn subcontract the obligation of providing support services to the petitioner. Accordingly, the petitioner entered into customer services agreements dated so and so with Amazon Ireland and AMZN, and thus the customer services agreement stood transferred to Amazon.com Services Inc. A diagrammatic representation of the contracting from Amazon consumer entity to the foreign affiliate and then subcontracting to the petitioner is as under. My lords will see there is a diagrammatic presentation on the next page, on the top. On the top, your lordship, is the Amazon consumer entity that sells goods to the customers, that also provides your lordship listing because of the.
What is listing
Yes,
services?
sir. What happens is, my lords will see there are a number of resellers, your lordship. Some number of companies are there. Now, Amazon, your lordship, is a marketplace. Now, these companies, your lordship, can get themselves, in a crude sense, registered, your lordship, in the marketplace. So the listing services is a service of listing those companies in the marketplace. Thereafter, your lordship, whenever customer gets in touch, they get into the marketplace, then they will know, your lordship, what are the products, which companies, then they can place an order. That order goes directly to the reseller. Reseller thereafter, your lordship, supplies the goods. Either it will be supplied directly by the reseller on his own to the customer, to us, or your lordship, Amazon will do what is called the fulfillment activities. So Amazon, your lordship, does the warehousing. It will have the goods there and then thereafter supply to customers like us. So that, your lordship, is the listing services to the selling partners, who in turn sell the goods to the customers. On the top, your lordship, Amazon selling goods to the customers is not there in India because of the FDA restriction. Now, my lords will see on the left-hand side, the Amazon consumer entity has an agreement of customer services agreement with the foreign affiliate, which, your lordship, is the Ireland entity. And the Ireland entity in turn has a customer services agreement, your lordship, with us, ADCI. So therefore, that, your lordship, is the complete offloading of the activity of subcontracting done to us. Now the question, your lordship, is ADCI, which is the petitioner before my lords, is an intermediary, and if so, to whom? Because, your lordship, we are providing services to the foreign affiliate. The foreign affiliate in turn doesn't do sale of goods or selling the goods or giving the listing services. They in turn provide the customer services agreement to the Amazon consumer entity. Therefore, we will not be considered as an intermediary either to the immediate entity, namely the Ireland entity, or to the Amazon consumer entity, because we have no contract with them. Therefore, your lordship, this cannot be considered as an intermediary. That, your lordship, is the short point. Now, my lords, will have a look at the definition and then the circular, your lordship. In this compilation, your lordship, we have just passed on. The lords can come to page number 5. The definition of export of services. 2 subclause 6.
Yes.
The lords will see export of services means the supply of any service when the supplier of service is located in India. There is no dispute on that, your lordship. The recipient of service is located outside India. No dispute on that. The place of supply of service is outside India. The dispute, your lordship, is on this. 4. The payment for service has been received by the supplier of service in convertible foreign exchange. No dispute on that, your lordship. Supplier of service and the recipient of service are not merely establishments of a distinct person. So they are not, your lordship, or branches, etc. They are independent entities. Now, my lords will look at 3. The place of supply of services outside India. For the place of supply, your lordship, there are separate rules, which my lords will find at page number 7.
Now, ADCI
Yes,
is situated
in India. ADCI, lordship, in India.
and it's providing services to the foreign affiliate.
Foreign affiliate, which is the Ireland entity. And that entity in turn, your lordship, provides it to another consumer Amazon entity. So we don't provide it to the Amazon ultimate entity at all. Now, my lords will see page number 7. 2 provisions I'll show and then I'll take my lords to the circular. Section 13, Your Lordship. Place of supply of services where location of supplier or location of the recipient is outside India. We'll also see 13.2. The place of supply of services, except the services specified in subsections 3 to 13, shall be the location of the recipient of service. So this is the default rule, Your Lordship. Normally, it will be the location of the recipient of service, namely the Ireland entity's place. Subclause 3, my lords, will see individually, wherever specific situations are there, they said that will be the location where the services are actually performed. We are not covered by 3, Your Lordship. My lords can come to page 9. My lords have page 9. The place of supply of the following services shall be the location of the supplier of service. Namely, my lords will see clause B, intermediary service.
8,
8, Your Lordship, on the page number 9.
Yes.
On the top, Your Lordship, clause 8, the place of supply of the following services shall be the location of the supplier of services. Namely, clause B, Your Lordship, intermediary services. So if I am providing an intermediary service, the place where I am located will be the place of supply of service, Your Lordship. So in other words, the place of supply will not be outside India. So while normally it will be export, but because of the fact that the place of supply is in India, it will not be considered as an export, only because if I am intermediary. What is intermediary also, Your Lordship, is defined, Your Lordship. Page 5, Your Lordship. Page 5, Your Lordship. Subclause 13. What is an intermediary? My lords have it, Your Lordship. Intermediary means a broker, an agent, or any other person by whatever name called, who arranges or facilitates the supply of goods or services or both, or securities between two or more persons, but does not include a person who supplies such goods or services or both or security on his own account. So there are two limbs to this definition, Your Lordship. First one, I should be either a broker, an agent, or any other person. In terms of the agreements, Your Lordship, we are not a broker of the Ireland entity. We are not an agent of the Ireland entity. Who arranges or facilitates a supply of goods or services between two or more persons. We don't do that arranging or facilitating the supply of services between two or more persons, because we do not have a contract with the ultimate Amazon entity who provides the services or goods.
But the last part
Does not include a person who supplies such goods or services on his own account. We provide these services on my own account. So I will not be covered by the opening portion of the definition, and I will be covered by the exclusion in the definition, Your Lordship. Now my lords will see their circular, Your Lordship. Page 21, Your Lordship. Circular dated, Your Lordship, 29/2021, Your Lordship. We are in 24, Your Lordship. 3 years after the circular is issued, these issues are continue to be raised.
Yes.
I'll read this greater portion of the circular, Your Lordship. because it explains the entire definition also. Representations have been received citing ambiguity caused in interpretation of the scope of intermediary services in the GST law. The matter has been examined. In view of the difficulties being faced by the trade and industry, and to ensure uniformity in the implementation of the provisions of the law across field formations, the board, in exercise of the powers conferred by 168(1), hereby clarifies the issues in succeeding paragraphs. Intermediary has been defined in subsection 13 of section 2 as under. The concept of intermediary was borrowed in GST from the service tax regime. The definition of intermediary in the service tax law, as given in Rule 2F for the place of provision of services rules 2012, issued wide notification, was as follows. From a perusal of the definition of intermediary under the IGST Act as well as under the service tax law, it is evident that there is broadly no change in the scope of intermediary services in the GST regime vis-a-vis the service tax regime, except addition of supply of securities in the definition of intermediary in the GST law. The concept of intermediary services as defined above requires some basic prerequisites which are discussed below. Minimum of 3 parties. By definition, an intermediary is someone who arranges or facilitates the supplies of goods or services or securities between 2 or more persons. It is thus a natural corollary that the arrangement requires a minimum of 3 parties, 2 of them transacting in the supply of goods or services or securities, the main supply, and 1 arranging or facilitating the said main supply. Suppose, your lordship, the main entity is providing certain services, and I facilitate the supply of said service, either from this place to this place or the other way around. And if I am an agent, I'll come to that here. So I should be an agent. I should facilitate the supply between one person to another. So I should be part of the same transaction where the supply happens.
Also third party.
Third party, absolutely. Now, my lords will see, it is thus a natural corollary that the arrangement requires a minimum of 3 parties, 2 of them transacting the supply of goods or services or securities, and 1 arranging or facilitating the ancillary supply, the said main supply. An activity between only 2 parties can therefore not be considered as an intermediary service. An intermediary essentially arranges or facilitates another supply, the main supply, between 2 or more persons and does not himself provide the main supply. 2 distinct supplies. As discussed above, there are 2 distinct supplies in case of provision of intermediary services. Main supply between the 2 principals, which can be a supply of goods or services. Ancillary supply, which is the service of facilitating or arranging the main supply between the 2 principals. The ancillary supply is supply of intermediary service and is clearly identifiable and distinguished from the main supply. A person involved in supply of main supply on a principal-to-principal basis to another person cannot be considered as a supplier of intermediary service. So that's the first criteria. Then, intermediary service provider to have the character of an agent, broker, or any other similar person. The definition of intermediary itself provides that intermediary service provider means a broker, an agent, or any other person by whatever name called. This part of the definition is not inclusive, but uses the expression means and does not expand the definition by any known expression or expansion such as and includes. The use of the expression arranges or facilitates in the definition of intermediary suggests a subsidiary role for the intermediary. It must arrange or facilitate some other supply, which is the main supply, and does not himself provide the main supply. Thus, the role of intermediary is only supportive. Does not include a person who supplies such goods or services on his own. The definition of intermediary services specifically mentions that intermediary does not include a person who supplies such goods or services on his own account. Use of words such in the definition with reference to supply of goods or services refers to the main supply of goods or services or both between 2 or more persons who are either arranged or facilitated by the intermediary. It implies that in cases where the person supplies the main supply either fully or partly on a principal-to-principal basis, the said supply cannot be covered under the scope of intermediary. Subcontracting for a service is not an intermediary service. An important exclusion from intermediary is subcontracting. The supplier of main service may decide to outsource the supply of the main service either fully or partly to one or more subcontractors. Such subcontractor provides the main supply either fully or partly thereof and does not merely arrange or facilitate the main supply between the principal supplier and his customers and is therefore clearly not an intermediary. For instance, A and B have entered into a contract as per which A needs to provide a service of, say, annual maintenance of tools and machinery to B. A subcontracts a part or whole of it to C. Accordingly, C provides a service of annual maintenance to A as part of such subcontract by providing annual maintenance of tool and machinery to the customers of A, that is to be on behalf of A. Though C is dealing with the customer of A, but C is providing main supply of annual maintenance service to A on his own account, that is on a principal to principal basis. In this case, A is providing supply of annual maintenance service to B, whereas C is supplying the same service to A. Thus, supply of service by C in this case will not be considered as an intermediary. Now, my lords also will see they have given some illustrations, your lordship. Right, your lordship. Illustration 4. So therefore, your lordship, if we have to come back to para 3.5 to say A, B, your lordship, and C. A, your lordship, would be the main Amazon entity or the immediate entity to whom they have given the activity. B, your lordship, would be the customers of A, that is Amazon entity. So Amazon US, your lordship, to Amazon Ireland, for an easier understanding, your lordship. Amazon US to Amazon Ireland, customer of Amazon US. So A, the B is customer, and then he is subcontracted to C. C in turn is subcontracted to me. Therefore, your lordship, C himself will not be considered as an intermediary. I can definitely not be considered as an intermediary because I am, as it is subcontracted to me, I am doing it for Ireland. Now, my lords will see illustration 4. A is a manufacturer and supplier of computers based in USA and supplies his goods all over the world. As a part of this supply, A is also required to provide customer care service to its customers to address their queries and complaints related to the said supply of computers. A decides to outsource the task of providing customer care services to a BPO firm B. B provides customer care service to A by interacting with the customers of A and processing their queries, complaints. B charges A for this service. B is involved in supply of main service, customer care service to A, and therefore B is not an intermediary. Therefore, it's a submission, your lordship. I pointed out the factual matrix. In the light of this circular and the specific illustration given, I cannot be considered as an intermediary. And if I cannot be considered as an intermediary, lordship, the place of provision of service will be where the recipient is located. Therefore, it will be an export of service. This is what, your lordship, we have been trying to point out. A series of decisions, your lordship, are there. I can take my lords to the decisions.
What is the agreement between ADCI and the foreign affiliate?
Yes, my lords will have a look at it.
Now it is this that is subject matter.
Your lordship,
the service of ADCI
to the foreign affiliate is the subject matter of the dispute. The writ petition 4580, your lordship.
Yes.
Page 57. This, your lordship, is the customer services agreement entered, your lordship, between Amazon Development Center India, which is the petitioner, your lordship, having its principal place of business in India, and Amazon CS Ireland, a company outside India, your lordship. Now my lords will come to services. In the recitals, your lordship, recipient wishes to engage provider to outperform the services listed in Exhibit P. I'll come to Exhibit P in a minute, your lordship. My lords will come to para 1.
These are two related entities.
Part of the same group, your lordship. Part of the same group, but different legal entities. Entity in India, your lordship, and entity in Ireland are different legal entities. That, your lordship, even their own circular also says, your lordship, that even if it is part of the one group, so long as they are differently incorporated here and incorporated in the other laws, they have to be considered as independent legal entities. Now, my lords can come directly, your lordship, to this is the agreement in terms of which, your lordship, the my lords will come to page 59. Para 5.1, your lordship. Relationship between parties. I am reading this, your lordship, because the definition requires, your lordship, an intermediary to be an agent, broker, or any other person. So we will go by the agreement to say what is the relationship between parties. You also will see page 59, 5.1. Relationship between parties. Unless otherwise set forth in Exhibit A, B, or C, no party has any authority of any kind to enter into agreements or licenses in the name of or binding on any other party, or offer to create any warranty or other obligation, express or implied, on behalf of any other party. Any services performed by a party pursuant to this agreement are performed by such party as an independent contractor on a non-exclusive basis, and nothing in this agreement creates a partnership, joint venture, franchise, or agency relationship between the parties as a result of this agreement. So therefore, the agreement sets out, your lordship, that I am not an agent of the Ireland entity. That's the first one, your lordship. Unless I am an agent, your lordship, I will not be covered by the first portion of the definition of intermediary. Right. Yes. Now my lords will come to Exhibit B, which is their services, your lordship. Page 67, your lordship. The services shall consist of the services described in Exhibit B. Services may include, but not limited to, the following: pre-sale and after-sale customer services, as are reasonably required by the recipient, lordship, the Ireland entity, to address inquiries from e-commerce customers, interested website visitors, or other service customers. Customer service communication shall be conducted by electronic email, telephone, or other means of communication. Services will not include entering or negotiating any contracts for sale of products. Therefore, what we will do, your lordship, any customer wants any information about the website, the customer will be of the original entity, so that they will come onto the website. That, your lordship, we will be given the job of addressing those complaints or inquiries, etc. We will give them the information. Thereafter, ultimately, your lordship, whether the customer really gets the goods from the main entity, gets the services from the main entity, we are not concerned. Similarly, your lordship, what is the value at which the supply has to be given, supply of goods or supply of services is provided by the main entity to the customers, we are not involved. We'll also see the last portion. Services will not include entering or negotiating any contracts for sale of products or services, as the case may be, your lordship. An intermediary is somebody, your lordship, who will essentially negotiate any contract on behalf of somebody. We should have the authority to do it. Or, your lordship, he will essentially sit in the place of the principal to say that this is the principal's activity, I am as his agent, So therefore, this is what I will provide to you. Therefore, they will communicate to me as representing the principal. That is what an intermediary is. That's why the three parties, etc. condition is there, Your Lordship. We don't have any such conditions. We have no such relationship also. Apart from providing the services, Your Lordship, pre-sale, post-sale, after the sale happens, Your Lordship, any after-sale customer services we will provide. But we are not concerned with the actual providing of or supply of service from the main entity or the supplier of service or goods to the customers. And from 1.2 to 1.5, Your Lordship, are all services which I provide to the Ireland entity as a whole. Like, for example, Your Lordship, finance, accounting and payroll services, tax services, legal services, all this we provide. So a bouquet of services we provide to the Ireland entity. Therefore, it is our submission, Your Lordship, that going by the definition of intermediary, applying the circular and looking at the agreements, Your Lordship, we will not be considered as an intermediary as far as this case is concerned, Your Lordship. And I take my lords to the order that is passed, Your Lordship. There are a number of decisions, Your Lordship, which I have placed on record. I'll take my lords to the decisions slightly later. Your lords will see the order, Your Lordship, is at page 50. And at 47, his discussions and findings start. Can I request my lords, Your Lordship, to just see one decision, Your Lordship, before we can go through the order. There, Your Lordship, in page number 23, my compilation. The Punjab Haryana High Court, Your Lordship, is one of the first decisions, Your Lordship, that came on the GST. Gen Pack, page 23, Your Lordship. Page 23, Your Lordship, at page 24. At page 23, last line, Your Lordship. An illustrative list of services stated to be rendered by the petitioner is as under: maintaining vendor customer master data, scanning and processing vendor invoices, bookkeeping, preparing, finalizing books of accounts, generating ledger reconciliations, managing customer receivables, developing, licensing and maintaining software as per clients' needs, technical support, data analysis and providing solutions to clients in respect of forecasting of demand for their offerings, and management of inventory supporting various business functions like sourcing and supply chain management. It is asserted that aforesaid services are actually deliverables of the petitioner on his own account. Such services are provided by the petitioner from India remotely through telecommunication links using its own infrastructure and workforce of approximately so and so employees. Petitioner entered into a master services subcontracting agreement dated 1/1/2013, hereinafter referred to as MSA, with Genpact International Incorporated, an entity located outside India. It is asserted that as per terms of the MSA, various services are to be provided by the petitioner on a principal-to-principal basis. Further, the petitioner is engaged by GI for actual performance of BPO services to the clients of GI located outside India. The arrangement requires the petitioner to complete the assigned process scope of work directly by the third parties located outside India. Copy of the MSA entered is enclosed as so and so. Thereafter, Your Lordship, they were granted refund. My lords can come directly, your lordship, to page 26. Para 20, your lordship. The primary issue that arises for consideration is whether the petitioner would be covered under the expression intermediary as defined under the provisions of IGST Act, and consequently the BPO services rendered by the petitioner under the MSA is to be treated as intermediary service. The court, your lordship, looks at the definition. At page 29, your lordship, para 23. By way of passing the impugned order, findings have been recorded that petitioner provides services on behalf of GI, and as such, there is a principal agent relationship. The petitioner is arranging and facilitating the supply of service between GI and its customers, and while doing so, petitioner is acting as an intermediary. It has further been held that petitioner is not providing service on its own account. That apart, it has been observed that there has been a material change in the definition of intermediary under the GST regime, and consequently, the petitioner cannot benefit from the orders of refund that have been passed under the sales tax regime. Para 24, we have examined the MSA in depth, and it was imperative to take a view as regards the findings recorded in the impugned order. My lords can come to the second recital here. Whereas, provider is an affiliate of GI and has agreed to act as a non-exclusive subcontractor for GI, subject to and in accordance with the terms of this agreement. Then, your lordship, the other clauses, your lordship, may not so much be relevant. Page 30, your lordship, para 25. The recitals of the MSA provide that GI has subcontracted the petitioner for providing the services to customers. It is clear therefrom that the petitioner is engaged by GI for actual performance of BPO services and information technology services to the customers of GI. Petitioner will be held responsible for all risk related to performance of services, which would be akin to services provided on its own account. Clause 3.1 provides GI would be responsible for obtaining new customers and maintaining relationship with the existing customers. 3.3 provides GI would be responsible for negotiation with all GI customers. So all these clauses, your lordship, my lords can come to this next page. Page 31, para 27. The MSA dated so-and-so entered between the petitioner and GI is clearly for the purpose of subcontracting services to the petitioner by GI. These are the very services which GI was contractually supposed to provide to its own customers. As per the definition of intermediary, the following three conditions must be satisfied for a person to qualify as an intermediary. Para 30. A bare perusal of the recitals and relevant clauses of the MSA reproduced herein above do not in any manner indicate petitioner is acting as an intermediary so as to fall within the scope and ambit of the definition of intermediary. Such clauses cannot also be interpreted to conclude that the petitioner has facilitated the services. The said clauses are in relation to the modalities of how the actual work would be carried out and do not in any manner establish that the petitioner was required to arrange, facilitate a third party to render the main service which has actually been rendered by the petitioner. Then they refer your lordship to the earlier orders passed. Page 33, your lordship. Para 45. It is undisputed, my lords have it, para 45 is undisputed that the petitioner has an agreement only with GI. You can substitute your lordship GI with Ireland in my case, and petitioner your lordship with ADCI in India. Pursuant to the subcontracting agreement as per MSA, the petitioner provides a main service directly to the overseas clients of GI, but does not get remuneration from such clients. Pursuant to the arrangement, it is GI which gets paid by its customers to whom the services are being provided directly with the petitioner. Nothing has been brought on record to show that the petitioner has a direct contact with the customers of GI. Still further, there is nothing on record to show petitioner is licensing or acting as an intermediary between GI and its customers. All that is evident from the record is that the petitioner is providing the services which have been subcontracted to it by GI. As a subcontractor, it is receiving fees charges from the main contractor for its services. The main contractor, in turn, is receiving commission agents from its clients for the main services that are rendered with the petitioner pursuant to the arrangement of subcontracting. Even as per the aforesaid circular dated 29/2021 and in reference to para 3.5, it stands clarified that subcontracting for a service is not an intermediary service. Therefore, they say, Your Lordship, that will not be considered as an intermediary. I'll read just 2 pages of the order, Your Lordship. There are other decisions. I don't want to trouble my lords on that. I'll refer to it, Your Lordship, if required later. Page 52, Your Lordship. There are 7.12, Your Lordship. From the agreement and the submissions of the appellant, it is clear and undisputed that the appellant, who is a taxable person under section so and so, are required to perform customer support services by addressing queries of the end customers or selling partners operating on the e-commerce website of the Amazon consumer entities through phone, chat, email, and other modes of instant messaging on various queries, namely pre-sales, such as customer queries relating to product availability, delivery methods, rates or times, issues with the checkout process, and other related issues. Post-sales, such as customer queries relating to post-shipping package whereabouts, product quality and defects, payment and billing related issues, returns and refunds related issues, warranty related issues, etc. The appellant provides assistance to the customers of foreign marketplace entities who seek such technical support in respect of Amazon's digital and divide products. Non-order related, such as login issues, returns policy, Amazon account related issues. Hence, it is clearly concluded that the appellant is a person arranging or facilitating the supply of service, namely pre-sale and post-sale services as detailed above between Messrs. So and so and the end customers or selling partners operating on the e-commerce website. And accordingly, I hold that the appellant is an intermediary as defined under section 213 of the IGST Act. Between Messrs. Seattle and Ireland and end customers or selling partners operating on the e-commerce website for supply of above service. Based on the above analysis, I also find that the appellant fulfills all the conditions prescribed by the circular to be considered as an intermediary. We'll also kindly note how he applies it, Your Lordship. The said service supplied by the appellant is between Seattle and Ireland and end customers or selling partners operating on the e-commerce website. The service applied by the appellant between Seattle, Ireland and end customers or selling partners operating on the e-commerce website of the Amazon consumer entities in the form of addressing queries of the end customers. We'll also kindly see after the extracted portion, this is ancillary to the main supply of goods between Seattle and Ireland and end customers or selling partners, and that the appellant is a person who arranges or facilitates the main supply of goods. That's how we get it. So one thing, Your Lordship, is the first foreign affiliate. My Lords could just have the chart back, Your Lordship, at page 10. The entity on the top, Your Lordship, is the Amazon consumer entity, which supplies goods to customers or sells goods to customers or provides listing services to the selling partners. He in turn, Your Lordship, has entered into a customer service agreement with a foreign affiliate, namely the Ireland entity. Ireland entity also, your lordship, doesn't sell goods, doesn't provide listing services. They only provide, your lordship, customer services agreement to the Amazon entity. We are at the next level. We are not even at the level of Ireland. We are at the next level. We are providing services, your lordship, to the Ireland entity, which itself cannot be considered as an intermediary. If that cannot be considered as an intermediary, the question of the Indian entity being considered as an intermediary does not arise at all yet. So we do not facilitate the supply of goods or services from the Amazon consumer entity on the top to the customers, to its customers, wherever they are. If we do not facilitate that, your lordship, we will not be considered as an intermediary. This is the short point, your lordship. And this, your lordship, is any number of decisions I can take, my lords, on this point itself has been decided. So if I get in touch with a customer of, let's assume, the US entity, I provide certain support to him. I do it pre-sale, post-sale, does not make any difference. I am not facilitating the supply between the first provider of supply of service to its customers. If I am not party to that transaction, I cannot be considered as an intermediary.
Yes.
There are a few other decisions, your lordship, I can take, my lords, later. After my friend argues, your lordship, I'll point out those decisions also. In fact, in that index, your lordship, I've indicated how test of agency to be applied, confirmed by Supreme Court, your lordship. Then how foreign entity is only the recipient, three parties. Each one of these points, your lordship, has been examined by the high courts or the tribunal, confirmed by the Supreme Court. I thought I'll refer to GenPact, your lordship, because that was on subcontracting.
Next week, your lordship.
When do you want? Next Wednesday. Wednesday at 2:30. Next Wednesday.
What's happening?
Is the matter. On 3/7 at 2:30. Please.
My lords have kept one more batch at 2:30 on 3/7. That GE group also, I think, has been kept at 2:30 on 3/7, your lordship. Interested, what is the difference? Because I will be under pressure from a number of people.
So we'll finish this, we'll have this, we'll finish and then we'll.
Great.
And then senior will have a choice which matter he wants to go on. If he intimates with other
My
matters,
lords.
he not have pressure of getting ready.
No, we also have to use some strategies. Let us.
Extremely grateful.
Lords, the other numbers in the same batch.
Now the other batch, we'll delink it and yes, and who appears for the petitioners?
Lords, I'm appearing in that.
You make one table
Please, man.
in each of the case. What is the?
Change of dates in a few matters. If they can make it available.
It's only
Make
date
one
change, my lords.
make a table for on which day order is passed and then which day certified copy is filed.
Please. And the date of online filing of the appeal.
Date of service of the copy, Millers.
Date of online filing, date of physical.
Physically using the copy. And the date of the order passed by the first appeal.
These are the 4 dates we'll put, and
Appeal.
this will need to be simply substituted in the orders, my lords. This is my submission.
You make a table.
Please.
Have a look at that order which we have released today.
Please, my lords.
And accordingly you make a.
We'll do that.
Make it. So we'll have it on.
Any date, my lords. Tomorrow also is fine. This week, tomorrow also is fine. Because my lords have directed me to appear in the matters where my lords have passed the orders before the appellate authority on 8th without further notice.
Therefore, my lords, these are all similar issues. It may also be, we'll appear on 8 before the authority if these are disputed.
Prepare it today evening. Probably tomorrow it can be there in the list. After, it may not permit, out of turn, we'll make a mention and then it will be disposed. If it is not.
Let us, I'll have it tomorrow,
Please.
depending on how it works.
My lords, in fact, directed that these matters to be listed under fresh today, as fresh matters in the daily order. Earlier occasion. I don't know how it has gotten tagged with this. The daily order is quite clear. It should be under fresh matters.
95.7
7
to
to
95.11 to be delinked and listed separately. Tomorrow.
Pleasure.
Make a table.
My lords,
And you have the dates.
With those dates.
Please, with lordship's permission. My lords, item
my lords,
70
may I make
is
a mention,
also
my
on
lord?
the issue of intermediary. Item 70, my lord's preliminary hearing list. It's also on the issue of intermediary which your lordships are hearing. So if this can also be listed on the 3rd of July, after this batch, item 95, it can be taken up.
Now you have the benefit of an interim order.
Yes, my lords. And the issue is, pleadings are also complete in that. One of the issues is of intermediary only, where I am providing software development services on a principal to principal basis, and it has been considered as intermediary. So your lordships are already hearing item 95, which is on intermediary. That, my lords, those can.
List serial number 70.
70.
On 3rd of July.
At 2:30, my lords.
At 2:30.
Interim
my
order.
lords.
Interim order earlier grant is extended till the next date.
I'm so grateful.
Yes,
May I make a mention, my lord?
yes.
My lord, matters similar to the intermediary services which senior Mr. Shivadas argued. There are other petitions which wherein senior advocate Raguraman is engaged. Can these matters also be clubbed along with that so that the arguments could be also placed?
Now, I mean, one part is the legal part, the other one is factual. So
Yes,
we'll have to take case by case to look into the agreement to see whether it's an intermediary or not, isn't it? So instead of clubbing it,
Yeah, madam.
we'll have it on the same day, we'll see. We'll have it on the same day, but we have to
Yes, madam.
take up case by case.
Yes, no, it could be listed along with the same batch in a different number. Because the factually also appears to be similar issues, my lord. That's the reason I made a mention.
Let us see, let me finish this batch. I'll have it on the same day. We'll see. Which serial number?
May I, no, my lord, it is fresh matters. It's not there in this today's list.
You move it,
If my lords permit, I'll place the numbers, my lord.
No, you move it for 3rd. Let it come up. But let me finish this batch and then I'll take up your matter.
Obliged, my lord. Obliged.
May I make a mention, minutes?
Yes.
Number 94.
ಇಲ್ಲಾಂದ್ರೆ ಅದು ಹಿಂದೆ ಬರ್ಸ್ಕೊಂಡ್ಬೇಕು ಇದನ್ನ ಇಷ್ಟು ನಂಬರ್ಸ್ ಕಳಿಸ್ಕೊಡ್ಲಾ ಒಂದು ಲಿಸ್ಟ್ ಮಾಡಿ ಒಂದು ಶೀಟ್ ಅಲ್ಲಿ ಪೆಟಿಷನ್ ನಂಬರು ನೇಮ್ ಬರ್ಕೊಡೋಣ
Lord, on 21/6, your lordship had directed me.
Yes.
To place.
Yes.
ಮೆಮೋ ಮೆಮೋ ಈ ಮೆಮೋನೇ ಮಾಡ್ಬಿಟ್ಟು ಅವನಿಗೆ ಕಳಿಸ್
To take the stand in writing, Lord, I've received the instructions, my lord.
Just take me through it.
Please, my lord. May I read, Lord says, this is with regard to the amendment application which was filed. Lord, 16A is the amendment sought, para number 16A was the amendment sought. My lord, the amendment was like this. On 24/01/2024, the Honorable Chief Justice addressed a letter to the Secretary, Ministry of Health and Family Welfare, New Delhi, and to the Director, Minister of Health and Family Welfare, Government of India, Central Government Health Scheme, stating that since the employees of the High Court have been migrated to the central pay scale, and since the pensioners are not covered under the existing medical attendance rules, and that all the employees and the pensioners are agreeable to pay the contribution as per CGHS scheme framed under the Central Service Medical Attendant Rules 1944 to the employees, pensioners, and the retired employees of the High Court of Karnataka. Reply: it is submitted that only those employees and the pensioners of the central government who are paid from the central civil estimates are eligible under the CGHS irrespective of scale. But 16B, the next amendment was that, my lord, in the said letter, the Honorable Chief Justice has also indicated that the government of Karnataka has withdrawn the Karnataka Government Servant Medical Attendant Rules 1963 and is in the process of implementing Karnataka Arogya Sanjeevani scheme to the state government employees. It is stated that the employees of the High Court of Karnataka have been excluded from the preview of the said scheme. Having regard to the said fact, the state government medical rules and the new scheme proposed to be implemented does not cover the employees of the High Court, and hence your recommendation was made to the implement the benefit of CGHS scheme to the employees, pensioners, retired employees of the High Court of Karnataka. Reply: since healthcare facilities of High Courts are governed under respective state government schemes, rules, and since the state government is running many schemes for its employees and the citizens, the state government may evaluate and consider the provisioning of suitable health service to the High Court employees on priority. It is 16C, my lord. It is relevant to mention here that the employees of the Delhi High Court are similarly situated to the employees of Karnataka High Court have been granted the benefit of CGHS scheme. The said benefit is been extended to the employees of Delhi High Court since the year 1989. Reply: the facilities of CGHS has been extended to the employees of the High Court of Delhi only as a special case-wide letter so and so dated so and so when Delhi was a union territory. Further, the institutional arrangements of CGHS in Delhi are different and compared to the other administrative zones in AD zones in various states. In Delhi, there is a tie-up with the central hospitals and with other organizations. B1, this is the prayer, my lord. Issue a writ of mandamus or direction, directing the Ministry of Health and Family Welfare, Government of India, third respondent herein, as well as the Director, Central Government Health Scheme, Government of India, the fourth respondent herein, to extend the benefit of and to cover the employees retired as well as the pensioners of the High Court of Karnataka under the Central Government Health Scheme by treating them on par with the Central Government employees as well as the Delhi High Court employees. Reply is that, my lord, CGHS is centrally sponsored scheme for Central Government employees and the pensioners. Hence, CGHS regrets its inability to accede to the request of extending CGHS facilities to the employees and the pensioners of High Court of Karnataka, which can be well addressed by the state.
Now we just examine the stand, and in 2 points you may have to get back.
Please.
One is the para 1. They say that it's only those employees who are pensioners of central government who are paid from central civil estimates. That one, and the reply to Delhi as a special case.
Yes.
So whether Delhi, when it was a union territory, employees were again paid from central civil estimates. You just make your research.
I'll just
They
verify.
appear to indicate
Yes.
that only those who are paid from central civil estimates,
Please.
and Delhi employees were paid from, it appears, their logic, from central civil estimates as they were employees in the union territory.
Yes.
And accordingly, as a special case, it was extended. Have a look at that letter of 18/189 referred to in the reply at para 3.
Please, I'll just find.
And then you see how you can equate yourself to them, or that similar as Delhi can be extended. You take your, you make your submission regarding it.
Please.
Because the only point is, it will be binding, but you have to show that the CGHS can be extended to you also.
Yes.
That you examine.
That I'll.
If the pay packet is similar to that of central government
Yes.
to the High Court employees, you have a look at that reference. On what basis they have made the pay scale similar to that of central government.
Yes.
And then you see if you can equate yourself to Delhi. That was
Because
this
when revised pay rules were framed by this honorable court in 18, it specifically says we are now migrated to the central civil services revised pay rules. So all those rules and the benefits thereunder are should be automatically applicable. Anyway, let me find out this and we'll make our submissions.
So all those Delhi letters
Yes.
treating it as special case,
Yes.
then whether Delhi employees were in fact paid from central civil estimates at the relevant point of time that you examine.
That I'll take instruction.
The counter affidavit file is taken on record for the say of the petitioners. List on.
May week after next, if may concern.
Yes. When do you want it? On any Monday? Monday, no?
8th, if not.
8th. Relist the matter on 8th.
In the meanwhile, my lord, may make one more submission. Let the state also come up with some scheme as to why they have not included the employees of the High Court, my lord. Even that has to be looked into, my lord.
Because now the medical and attendant rules have been withdrawn. In the new scheme, we are out from the one
Neither-
that is framed by the state. We are neither here nor there.
Now, how are you getting now? At present,
At present, I'll just verify. Yes.
the state government to also take their stand insofar as governments made in para 16B. 16B by the next date. Yes.
I've been told that, my lord, the Karnataka government, by the officer of CGHS, have been told that, my lord, they have come up with a new scheme called Jyoti Sanjeevani, on par with CGHS. Lord, the stand may be what to the note.
Yes. Karnataka ROP Sanjeevani. That is under process, it is not.
Not yet. That is.
Please.
Yes.
Great. I apologize, my lord. I was on my legs, my lord.
No, that's it. Continuation number 445 was mentioning money list. Is any mentioning?
My lords, may I mention? Lords, may I mention, my lords?
Yes.
Serial number 45, my lords.
Yes.
My lords, this is an issue where, my lords, for pre-deposit, lack of pre-deposit, my appeal has been dismissed by the state VAT. Identical issue, my lords, is dealt with by this court in Midworld India Infrastructure. So our request, my lords, is that if lordships would kindly issue notice to Mr. Hem Kumar, he can come with instructions. And then the matter itself can be disposed of next week.
This is arising.
Very short compass.
Under the VAT Act, my lords, it is compulsory.
It's
that
under the VAT Act.
For an appeal to be maintained before the tribunal, 30% of the tax amount has to be deposited. Here, my lords, they have paid to deposit the 30% of the amount. So the IA for
Waiver of-
dispense
Waiver
with
of
the
payment of
waiver
30%.
that amount, that has also been dismissed. Now that before this honorable court, my lords, it's a 2022 matter. In some cases, my lords, this honorable court has exercised its discretion and waived the penalty. In some cases for 10%, in some cases 20%, but that is all in public sector undertakings. This is a private
We will
undertaking.
be able to, my lords, will be able to demonstrate the public interest, also the difficulty which we are facing in a very short compass.
Mining company, what public interest?
Let us see.
But because of the ban, my lords, mining company, because of the ban from 2011 to now, even now, that is a difficulty.
M. Kumar is directed to accept notice for the respondents. List the matter on
Next Wednesday, my lords, preliminary hearing.
the court officer is the sole arbiter of giving dates.
I leave it to your lordship.
Yes. Date may be fixed.
Serial number 56, please.
Can it be put in preliminary hearing, my lords? Preliminary hearing. In the preliminary hearing list.
Then this preliminary hearing list.
Your lordship, serial number 86
serial
had come
serial
on,
number
your
22
lordship had directed that today it should come on top of the board, your lordship. 86. I don't have an interim relief and today it was supposed to come on top of the board. It may be taken up tomorrow, your lordship. Before 30th, if I'm not able to get any orders, I will have to face consequences, your lordship. In the second writ which I filed, the 2024 writ, which is
for the respondent.
Amit Deshpande, sir.
What is the point?
Your lordship, it's blocking of input tax credit. My input tax credit, which was available, was 22 lakhs. It was blocked on 15 September 2023. They blocked to an extent of 4 crore 67 lakhs. So I'm not even able to do anything beyond 22 lakhs. In the first writ petition, I had an interim order. This court had directed me to pay 20% of the amount. I paid that amount. Then the respondent challenges that order before the division bench of this honorable court. Before the division bench, the respondent advocate says there is an IA filed for vacating. So the division bench of this honorable court says, let the IA for vacating be considered. Revenue is reserved the liberty for speedy disposal of the writ petition. Now, once a matter comes back again before this honorable court, that time they filed a statement of objections, and for some reason, the hearing is not able to be concluded. In between, they take a stand that I'm not cooperating in the investigation. I do cooperate in the investigation. And then I say, you have retained my money, which I've paid pursuant to the interim order, and not even unblocking the ITC. They take a stand that in the writ appeal, the court has said IA for vacating has to be considered, whereas that IA was filed subsequently. Nevertheless, your lordship, I file another writ, which is a 2024 writ, which is connected. Now, in this writ, I have challenged constitutional validity of Rule 86A. So that's a subsequent, even new challenge which I've taken, which is not there in the earlier writ, your lordship. So in the 2024 writ, your lordship, under similar circumstances, this honorable court has given interim orders for unblocking of the ITC, where the constitutional validity of the rule is challenged. Therefore, my respectful submission is, if to the extent of 4 crore 67 lakhs, my ITC is blocked, whereas according to them, a respondent, admittedly it was only 22 lakhs what is available, blocking to such an extent is arbitrary, and I have not been given any reasons. And
Relist the matter on.
Your lordship, tomorrow, if it can be taken up, your lordship.
Friday, you take your chance.
On top of the board, if it may be listed, your lordship.
Can't, madam. I've got other matters also.
Because at least in the light of other orders, this honorable court can grant me a relief in the second.
Let's see, on Friday, you take a chance.
I'll make a mention at 1:30 if it doesn't reach.
1:30, after 1:30, I'm not sitting. It will be only division bench. Friday morning, you take a chance.
I'll make a mention at 10:30.
My lord, serial number 56, please, my lord. Serial number 56.
60?
61. Will be permitted to serve Dilip. Posted for the first time.
Learned counsel,
Here.
Dilip is directed to accept notice for the respondents.
Similarly, serial number 80.
To be complied with. List the matter in the fresh matters list on third.
Similarly, serial number 80. 80. 79, 80 are connected. One was listed last week. So 80 may be listed along with it.
80 is fresh matter?
Fresh matter, yes, yes.
First time?
First time.
Who has to accept notice?
Dilip, your honors.
Dilip is directed to accept notice for the respondents.
Respondent, yes, your honors. You know, serial number 62 and 63 are listed.
List the matter in fresh matters list on third. Third list no rest.
62 and 63, stay has not been granted. 62 and 63 may be also listed in fresh matters. 62 and 63, your honors.
But they already appear, 62 and 63.
Yes, your honors, but stay is not granted. 62 only I'm praying. Rest of 61, 79, 80 all have to go back.
No, just only 63. No, this is the matter. No, there is a interim protection or no?
It is not there. None of the cases.
So just 1 minute.
Sorry.
No, what is the interim relief you're seeking? 63.
Stay of demand. No, but it's an ex parte order. If you remitted.
Just 1 minute. The respondents are restrained from taking any steps for recovery. List the matter in preliminary hearing list week after next. Ninth.
Serial number 56, please.
62, yeah.
Number 52.
62.
It can be listed next week because this is a 151A issue. This needs to be stayed.
List the matter in the orders list on
Second year.
3rd July.
Third July.
My lord, serial number 50.
47, your lordships.
Yes.
It's a writ petition challenging 147 order and the consequent penalty orders on the for violation of natural justice, your lordships, and interim stay has not been granted in the matter, your lordships. Been posted. So question is. It's not so simple, your
Let us list the matter in the orders list on 9th.
Your lordship, serial number 91. 91, it can be disposed of. It may be kindly posted under orders on Tuesday or Wednesday.
90.
Serial number 91. It can be disposed. It's a small interim order needs to be extended also, my lord.
There is already interim order.
Interim is order. It can be disposed of next week. Either
Interim
Tuesday or
order
one second.
extended to the next day. List the matter in the preliminary hearing list on 9th of July.
Your lordship,
serial
one more
number
matter,
56, please,
46. There's a bank attachment, 46 GST matter. There's a bank attachment which does not have a 46, Pranay Sharma, Vignesh. Can it be posted tomorrow? There's an urgency, my lord.
The matter in the orders list
Orders
on
tomorrow, if possible, my lord, or Tuesday, my lords. There's an urgency, my lord. Tuesday, please.
third.
My lord, serial number
Serial number
56.
50, my lord. 50, my lord. That's serial number 50. It is covered by judgment, my lord. This honorable court was already passed in order on WP number 21-269 of 2022. This is the GST matter, my lord. It can be restored, my lord. My learned friend is also agreed
The matter in the preliminary hearing list.
for undertaking, my lord. They covered by judgments. We are ready to pay the arrears. We are ready to, as requested by learned friend, I am ready to.
One.
On the very same day, the assessment order and penalty notice was passed. I filed an amended writ petition. I need a stay of the assessment order and penalty notice.
Interim order is not yet considered.
Only 148 notice has been stayed, my lord.
Stayed.
Stayed, my lord. But subsequently, the assessment order and penalty notice are issued. Have therefore filed the amended writ petition. It is stay of the annexure E1 to E3 and annexure E5.
List the matter in the orders list on.
Lordship,
Lordship,
serial
serial number
52,
78.
Serial
Interim
number
order may be
52.
extended, Lordship. Serial number 78.
Yes.
Interim order may be extended. And date, any date may be given. Lordship.
Lordship, serial number 52, your lordship.
Serial number 78.
My lord, serial number
Interim order
67.
earlier granted is extended till the next date, 78. List the matter in the same stage on.
Any date may.
Your lordship, serial number 52, your lordship. Your lordship,
Lord,
the
serial number
income tax department has
67.
issued 52, your lordship.
Serial number 66, fresh matter, my lord. Only office objection, the certificate has not been produced, registration certificate.
List the
Lordship,
matter
kindly have it Monday for
in the
fresh matter, my lord.
fresh matters list on Tuesday.
Your lordship,
serial number 22. Serial number
Lordship,
67.
the refund has, department has issued refund, your lordship.
Serial number?
52, your lordship.
Yes.
But we have not received the interest component, which I have submitted to the department council to ascertain the computation. Your lordship, a direction may be given. A direction may be given during the pendency of the writ petition so that they can ascertain the interest component, your lordship.
No, let him appear before you. You ascertain the interest amount.
During the pendency of writ petition, it can be done.
The petitioner is directed to appear before the respondents and make submission regarding quantification of interest.
A date may be fixed, Your Lordship.
Relist the matter on 2 weeks ಆದ್ಮೇಲೆ.
Serial
My
number.
lord, serial number My lord, serial number 67, my lords.
After 2
My
weeks,
lords,
16th of July.
Serial number
My lord, serial
56,
number
please, my lord.
67.
Just 1 minute, yes.
My lord, serial number 84 appear for the petitioner. My lord, the student's result sheet has been withheld. There's urgency in this matter, hence the matter was posted for preliminary hearing today. Kindly have it tomorrow or day after tomorrow, please, my lord.
84.
84.
List the matter on 28th.
56, please, my lords.
Lordship.
Number 56.
59, my lord.
Fif-
That registration certificate has been cancelled, my lord, but it is not reached, my lord.
59.
Declaration of registration, serial number 59, my lord.
Huh.
Monday, Tuesday, my lord.
59.
Tuesday, my lord.
Yeah, relist the matter on.
Fresh matter, yeah.
My lords,
My lord, serial number 55, there is a recovery action imminent. I was seeking a ad interim relief today, couldn't be called today. Can it be listed for tomorrow or day for tomorrow?
Tuesday, we'll have it in fresh matters list on
It's
Tuesday.
a fresh matter.
Relist the matter
55.
in fresh matters list on Tuesday.
56, my lord.
Obliged.
Next matter. 56.
56.
Next matter. It may be on Tuesday, my lord. It is ITC block.
Hem Kumar.
Section 83, attachment.
86A.
Relist the matter on.
Tuesday in the fresh matters list. man.
my lords, serial number 67, my lord.
Just 1 minute, just 1 minute.
Argued on merit,
Hmm.
because as my lord suggested on the other day, some alternate will be made of them for furnishing some security, the amount that is attached now.
My lords, there is a very short, my lords, I will take not more than 5 minutes.
Will have to be argued on merit with regard to seizure that is to be followed under 86.
56.
Tuesday, please.
List the matter in orders list on
Second.
second.
Obliged, please.
Your lordship, serial number 58. Your lordship, there is an attachment, your lordship, and the petitioner is not able to pay the salaries also. And he's in great trouble, your lordship, and we are not having any interim stay. Your
Then
lordship,
we'll consider the interim prayer. So what is any security? %20% you can deposit.
Actually, there is no mistake from the SS petitioner, your lordship here, because the assessing officer, because of his mistake, the demand is arising. If they would have waited for the valuation report, there would be no demand at all as of now. So they are on appeal, your lordship, to CIT appeal. Now only request is let it go back.
Relist the matter in the orders list on Tuesday.
A preliminary hearing, your lordship.
16. Orders list will come above preliminary hearing from next week.
69, please.
Yes.
My lord,
69.
Maybe direct take notice.
69.
Refund of GST.
Who appears?
Government.
AG M. Kumar accepts notice for the respondents. This is the matter on Wednesday. When do you want? Wednesday. Wednesday.
Next.
Let's serial number
22, my lords.
my lord, serial number 67, my lords.
Serial number 60?
67, my lords.
Yes.
My lords, the center and state have both issued an order for the same period, my lords. It's a 16-4 issue on utilization of ITC, my lords. Now there is recovery pressure from both the center and the state, my lords. The same amount, same period, same issue, my lords.
So who has to accept notice?
My lords, the center and state both are parties, my lords. Serial number 1, 2, 3, 5, 6 and 7 and 8 would be center, my lords. Mr. Akash Shetty or Arvind Chavan. Serial number 4,
1 to
respondent
3.
number 4. 1, 2, 3.
I can't hear you. 1, 2, 3.
1, 2, 3, 5, 7 and 8. My lords, 1, 2, 3, 5, 7 and 8.
Relist the matter. Relist the matter in the fresh matters list on.
My lords, tomorrow, my lords, there is a recovery issue, my
Fresh
lords.
matters list.
Second, my lords, second, my
Fresh
lords.
matters list on 3rd.
My lords,
One second.
second, if it's possible, my lords, I have an inconvenience.
You serve. Let us see. Fresh matters list.
And second,
Fresh
my lords.
matters list. 1 second.
Serial number 91 and it has to be posted under orders.
Serial number?
Serial number 91 and 46, both under orders. Both.
Just 93, final hearing matters as a counsel from outside. Can I request for 16th of July, my lord?
It won't reach you. Better come on online till we stream.
That's serial number 22 minutes.
Lordship.
When you want.
16th of July, lordship. 16th.
16th of July.
That's serial number 22 minutes.
Yes.
It was passed over today. Let's may have it on next week on 3rd or 4th, whatever suits my lords.
50?
22, my lords. Serial number 22, it was passed over.
3rd of July.
Serial number 72, my lord. I'm sorry. My lord, serial number 65, my lord.
Serial number 78, interim order may be extended and listing the fresh matter list.
Serial number 87.
Lordship.
87, I have informed the petitioner, 16th it may be taken up.
Other dates will be given. I have a
Your lord.
meeting at 5 o'clock. Dates will be given by the court officer.
My lord, serial number 77. I'm very sorry, my lord. Serial number 77.
Sir, ಹೇಳಿ sir.
Court officer, serial number 48, sir.
ಒಂದ್ ನಿಮಿಷ.
You show yourself. Show yourself couple of times. Court rotation.
ಸರ್ ಒಂದ್ ನಿಮಿಷ. Interim order ಆಗೈತೆ 90.
ಮತ್ತೆ ಡೇಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಆಗಲೇ ಇದು
ಆಗಿದೆ.
ಏಕೆ
40? ಮೇಡಮ್ 46 ಆರ್ಡರ್ಸ್
ಮಾಡೋದು
46 ಆರ್ಡರ್ಸ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಮಾಡ್ಕೋತಾರೆ.
Sir, 87, 16th ಹಾಕಿ ಸರ್.
ಒಂದ್ ನಿಮಿಷ.
87, ಬಾಲಚಂದ್ರ ಸರ್ ಹೇಳಿದ್ದೀನಿ 16th ಹಾಕೊಳ್ಳಿ.
87 ಅಲ್ಲ?
16th.
ಸರಿ ಸರ್ ಆಯ್ತು. ಓಕೆ. ಯಾವುದು 67 ರಿಸಲ್ಟ್ ಮಾಡ್ಬೇಕಾ? ಸರಿ ಆಯ್ತು. 2ನೇ ತಾರೀಕು.
Sir, serial number 67, sir.
65 ನಾಳೆ ಬರಲ್ಲ. ನಾಳೆಗೆ ಯಾವುದು ಬರಲ್ಲ. 28 ಆಯ್ತು ಹೋಗೋದು.
Sir, serial number 67, sir. Third ಹೇಳಿದ್ದಾರೆ, second ಹಾಕೊಳ್ಳೋದು.
ಒಂದ್ ನಿಮಿಷ ಮೇಡಮ್. 44
Thursday, sir.
Wednesday, sir. Wednesday. 5th. Wednesday ಕೊಡಿ 37. 1 2 3 37.
ಕಾಯ್ಬೇಕು ಮಧ್ಯಾಹ್ನ ಇವ್ರು ಬೇರೆ ಬರ್ತಾರೆ. ASC ವೆಂಕಟರಾಮ ಅವರು 2 ಅವರ್ ತಗೋತಾರೆ.
Sir, serial number 72.
9th.
Court officer, sir.
ಮಾಡಿದ ಅದನ್ನ ಮೆಮೊ ತಂದು ಕೊಡ್ಬೇಕು.
Sir.
ಹೌದು.
Sir. Sir. Court officer.
ಹೇಳಿ ಮೇಡಮ್ ಈಗ ನಿಮ್
Serial number 67, sir. Third ಕೊಟ್ಟಿದ್ದಾರೆ, second ಹಾಕೊಳ್ಳೋಕ್ಕಾಗತ್ತಾ sir?
57 ನಾ?
67.
67.
ಹಾ.
2nd July.
Yes, sir.
Sir, 72, serial number.
72.
ಹಾ ಸರ್ ಟ್ಯೂಸ್ಡೇ ಹಾಕೊಳಕಾಗತ್ತಾ ಸರ್ 72
9th July.
48, serial number
3rd ಜುಲೈಗಾರ ಹಾಕೊಳ್ಳಿ 3rd ಜುಲೈ.
ಹೌದು 3rd, 2nd, 3rd ಜಾಸ್ತಿ ಇದೆ ಮ್ಯಾಟರ್. 9th July.
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಸೀರಿಯಲ್ ನಂಬರ್ 77. 3rd ಅದು ಇಂಟ್ರಿಮ್ ಪ್ರೊಟೆಕ್ಷನ್ ಇಲ್ಲ ಅದಕ್ಕೆ. ಕೋರ್ಟ್ ಆಫೀಸರ್ 77.
9th July, sir.
ಸರ್ ಇದು 3rd ಜುಲೈಗೆ ಆಗುತ್ತೆ ಬಿಕಾಸ್ ಕೋರ್ಸಿವ್ ಆಕ್ಷನ್ ಇದೆ ಬಿಕಾಸ್ ಡಿಸ್ಪೋಸಲ್ ಇಟ್ಕೊಂಡಿದ್ರೆ ಆಕ್ಚುಲಿ ಇವತ್ತು 3rd ಜುಲೈ ಆದ್ರೆ ಆಗತ್ತಾ?
ಸರ್ ಅದು ಅಲ್ಲಿ ಜಾಸ್ತಿ ಆಗೋಗಿದೆ ಮ್ಯಾಟ್ರ್ ಸರ್, ಅಲ್ಲಿ ಆಲ್ರೆಡಿ 100 ಕ್ಲಾಸ್ ಆಗೋಗಿದೆ. ಸೆಕೆಂಡ್
ಅರೆ ವಾ.
100 ಕ್ಲಾಸ್ ಆಗೋಗಿದೆ. 9th ಜುಲೈನೇ ಬರುತ್ತೆ ಸರ್.
9th ಜುಲೈ ಬಹಳ ದೂರ ಹೋಯ್ತು ಸರ್.
Sir, 48 sir.
48
ಹಾ sir.
48 ಕೂಡ ಅಷ್ಟೇ. ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗಿದೆ 9th ಜುಲೈ. ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗಿದೆ 9th ಜುಲೈ.
Okay sir. Okay.
Serial number 75 sir. Next week
75 ಅಲ್ಲ 75 9th ಜುಲೈ.
Sir, under orders list ಆಗ್ಬಿಡಿ ಸರ್.
ಅಲ್ಲಿ ಆರ್ಡರ್ಸ್ ಲಿಸ್ಟ್ ಅಲ್ಲ ಸೇಮ್ ಸ್ಟೇಜ್ ಅಲ್ಲಿ ಬರ್ತದೆ. ಆರ್ಡರ್ಸ್ ಅಲ್ಲಿ ಇರೋದು ಅದು ಆರ್ಡರ್ಸ್ ಲಿಸ್ಟ್ ಅಲ್ಲೇ ಇರೋದು.
ಸರಿ ಸರ್. ಥ್ಯಾಂಕ್ ಯು ಸರ್.
ಸರ್ 72 ಗೆ ಯಾವ ಡೇಟ್ ಕೊಟ್ರಿ ಸರ್? 72 ಗೆ
72 9th ಜುಲೈ.
ಸರ್ ಅದು ಆರ್ಡರ್ಸ್ ಅಲ್ಲಿ ಬರಕ್ಕಾಗತ್ತಾ? ಅದು ಆ ಇಂಟ್ರಿಮ್ ಪ್ರೊಟೆಕ್ಷನ್ ಇಲ್ಲ
ಈಗ ಇರೋದೇ ಆರ್ಡರ್ಸ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಸೇಮ್ ಸ್ಟೇಜ್ ಅಲ್ಲಿ ಬರುತ್ತೆ.
ಸರಿ.